Well, good morning. I declare open this public hearing for the Senate Legal and Constitutional Affairs Legislation Committee's inquiry into the provisions of the Religious Discrimination Bill 2021, the Religious Discrimination Consequential Amendments Bill 2021 and the Human Rights Legislation Amendments Bill 2021. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via the web and in Parliament House. The committee has agreed that the media may record the proceedings subject to the usual rules and any directions from the committee or secretariat. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. I remind witnesses that it is not the role of the committee to arbitrate or resolve individual matters. If a witness reflects adversely on another party, the committee is generally required to offer the adversely reflected on party an opportunity to respond to the relevant comments. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. Now, with the formalities over, I welcome everyone here today. And our program begins with the Law Council of Australia via video conference, and also Dr. Renee Barker. Thank you very much for the time you've taken to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 8 and 2 respectively. Do you wish to make any corrections to your submissions?
Thank you, Chair. No, not on behalf of the Law Council.
Because we are taking so much evidence via video conference today, if you could just state your name when you respond, that would really help senators and those listening, and also Hansard. So I'm sorry, who could you just...
Thank you, Chair. My name is Catherine Eastman. I'm here for the Law Council of Australia, and I have with you Mr. Simmons.
Thank you very much. Dr. Renee Barker, do you wish to make any change to your submission?
Thank you, Chair. No, I do not wish to make any changes to my written submissions.
Now to both the Law Council and Dr. Barker, would you like to make a brief opening statement of no longer than 1 minute before we go to questions?
Thank you, Chair, I would. You'll also see on the screen with us is Leonie Campbell from the Law Council of Australia. So the three of us are representing the Law Council. May I briefly address you, Ms. White? We thank the committee for the opportunity to participate. The Law Council supports those standard parts of the bill to make it unlawful to discriminate against a person on the ground of religious belief in public life. However, Part 2 of the bill departs from the conventional approach to discrimination law in many important respects. In our view, it undermines the object of the bill. In particular, Clause 12 makes lawful statements of belief which would otherwise be unlawful. The effect of Clause 12 is to override existing rights, and it privileges the manifestation of religious beliefs over other human rights. It is contrary to international law. It is procedurally complex. The Law Council also raises concerns with respect to Clause 7 to be significantly narrowed. Concerns about Clause 9, our submission would be that the current requirements exception is sufficient, and we also suggest that Clause 11 is deleted. With respect to Part 3, the Law Council supports Part 3, except for Clause 15 concerning the qualifying body conduct orders. We also finally...
Ms Eastman, I'm sorry we are going to very strictly comply with our 1 minute opening statement. So I now need to ask Dr Barker if she has a 1 minute opening statement.
Thank you.
Yes, thank you, Madam Chair. My name is Dr Renee Barker. I'm a senior lecturer at the University of Western Australia in the School of Law. I'm an academic and commentator on matters relating to church and state and freedom of religion in Australia, but also internationally. My publications are in my written submission should anyone wish to review them. I want to make two very brief points, both which are related, which is about the breadth of application of the bill and therefore its fundamental importance and why we must be very careful in how we proceed with this particular law. The first being that religion is a matter which touches upon almost any aspect of a person's life. Just like other attributes we protect by anti-discrimination law, religion is all pervasive in a person's life. It is about more than simply turning up to worship on your relevant holy day. It can influence almost anything that an individual does in their life. And as a result, this bill has a potential to have a profound impact, both in terms of religious believers, but also in terms of those that they interact with.
Dr Barker, thank you. I am going to have to leave you there. I hope everyone understands today that we are very much confined by time, so I'm going to enforce that 1 minute opening statement strictly. We are going to be sharing the call, but I'm now going to firstly start by giving the call to Senator O'Neill.
Thank you very much, Chair. And
about 4 minutes.
Thank you very much.
We're going to run a pretty tight.
So we can see the time constraints that exist with regard to this hearing, and I know you quote St Thomas Aquinas: "To one who has faith, no explanation is necessary. To one without faith, no explanation is possible." And that's why this is such an important piece of legislation to provide religious discrimination protection. There will be questions on notice because the time of order will not allow us to properly interrogate your very detailed submissions. Thank you for them. The Law Council and others have noted the procedural problem with having a federal defence to state anti-discrimination law. And the problem is that if a complaint is made to a state anti-discrimination tribunal and partway through the hearing, a defendant to the claim says, "I'm relying on a statement of belief and I have a defence under Section 12 of the Commonwealth Religious Discrimination Act," the tribunal processes would have to stop, the matter could have to go to court, the process of dealing with anti-discrimination complaints will take longer and be much, much more expensive for complaints and respondents. Is that a fair summary of your concern? And could you go to the jurisdictional problem that some claim will rapidly diminish over time as a body of law develops? That's to the Law Council.
Thank you, Senator. Yes, that is a very fair and accurate description. With respect to the jurisdictional questions, the issue concerns the time taken for access for complainants to be able to raise their complaints and see their complaints work their way through tribunals so that they get an outcome. So that's the jurisdiction concerns, the timing of complaints, the complexity of the matters, and specifically we've identified the increased risk of costs.
So there's been some argument that there's no cost at state level. Is that correct?
In most of the state anti-discrimination tribunals, it's a no jurisdiction or costs are only awarded in exceptional or special circumstances. That is not the case in the federal jurisdiction, in the Federal Circuit and Family Court or in the federal.
Okay. And with regard to the arguments that have been put, that the jurisdictional problem will rapidly diminish over time as a body of laws developed, and state tribunals will then simply apply the law, and there will be ultimately no need for a requirement for matters to be transferred to court. Does that hold up in your view? Because you talk about this procedural and jurisdictional issue, and you articulate that having a federal defence to a state anti-discrimination law won't diminish over time, because if I get it right, no matter how certain a state tribunal is about the content of a federal law, it cannot apply it because it doesn't have jurisdiction. Is that correct?
That is correct. The barrier is Chapter 3 of the Constitution. At the moment in the City of Hobart form litigation, which is to go before the High Court, this very issue is being considered there, and the complexity is extreme, I should say. respect, and it means that matters that were simple and able to be raised in state tribunals now, a federal defence such as Clause 12 of this bill were raised, would have to go to Chapter 3 court. Now, as I indicated in the other committee, that's a bit of a mess at the moment. New South Wales, Victoria and recently Tasmania have a way to deal with that. The other states, apart from Queensland, do not. In any event, it would mean a transfer from one tribunal to a court, say in New South Wales, for example, and a whole new set of procedures would have to occur to resolve that part of the claim. And of course, they are all cost jurisdictions, so it fundamentally changes the access to justice approach to discrimination that is throughout Australia.
So this is
That cannot be, I might say that because of Chapter 3, that cannot be resolved procedurally over time, that there will continue to be that.
So
that's a double step, if you like.
which is quite a different view from other witnesses. So you don't hold hope that this will provide a smooth path, that it's going to be a very bumpy and long road to getting any resolution. And this is a very important point because it goes to the heart of whether Section 12 will actually work. I think there's been general agreement about a religious discrimination bill and compliance with international conventions, but the mechanics of making it happen for people of faith, like myself, product of Catholic education, chose the Labor Party as my vehicle as a way to bring that to bear in the world. I'd like to ensure that I'm not in any way misstating the position of those who argue that the procedural issue will diminish over time. So this is the quote from Associate Professor Fowler, who provided in good faith to the committee, and he said the need to refer the complaint to a determination on the question of the override imposed by Clause 12 would diminish rapidly over time as a body of law develops concerning the interpretation of Clause 12. Once that body developed, state tribunals will perform their role of applying the law as stated by the relevant courts. What should the committee do with that piece of information? And do you have any further recommendations that might help this committee practically deal with that if there were any amendments to be put?
Last question, Deb.
I'll answer that very briefly. We certainly respect other witnesses' opinion views. Our views are also informed from a very practical perspective of representing parties in courts and tribunals. The types of people who may use these laws are not academics following the development of laws over time. They're ordinary people who may be very unaware of the law and unaware, for example, as to what is the best forum to prosecute their case. Those making statements of belief may also be unaware of the law, the extent to which they may even have a defence, and also the consequences of raising defence based on Clause 12. So in that respect, for ordinary people, I don't accept the proposition that the jurisdiction will diminish. In terms of resolving those issues, they are very complex issues involving questions of jurisdiction and the operation of Chapter 3 of the Constitution, and they can't be dealt with in a very simple way in one piece of legislation.
Chair, Professor Toomey was unable to attend. Could I ask both of the witnesses to take on notice?
Oh, sorry.
Take on
Senator
notice a response to Professor Toomey's submission where she indicates that it is confounding to contemplate why the provisions of a high contentious bill will be drafted in such a provocative manner, referring to sections 11 and 12. Could I ask you on notice to elaborate on those concerns, in particular tell the committee how you think it is that the High Court would find these provisions unconstitutional? And sorry I didn't get to ask you any questions, Dr Barker, but you can see the time pressures we're under.
We will try and come back to Labor senators if there is time. Thank you very much, Senator O'Neill, and I appreciate everyone sticking to the time as best we can. Senator Rice.
Thank you, Chair. Thank you. Look, I'll start with a question to Dr Barker then, and thank you for your submission and your expertise about sort of what a religion is. And with regards to the definition of religion, we had some discussions at the hearings, the Parliamentary Joint Committee hearings last week, about whether the Church of Ubuntu, which sacked an employee for being vaccinated, saying it went against the religious faith of that church. And I had various witnesses who said, oh, well, that probably wouldn't hold up in the High Court, that they wouldn't be recognised as a religion. So I just would be interested in your comments, given your expertise on what a religion is, as to whether you think, in fact, that is the sort of thing that would be held up under this law.
I have looked at that instance very briefly. I would need more details about particular religion, what they're claiming their beliefs are and their structures and their setups to answer that specifically. But the definition of religion is very broad. And the High Court recognised Church of Scientology, but hasn't since had an opportunity to consider the definition. And internationally, it has moved on to be even broader. And so, given the way in which this bill has been drafted, and I understand the explanatory memorandum includes quite a broad understanding of religion, I would be reluctant to say it wouldn't be covered. Without a lot more information, I think there is a possibility it might be, because religion is a very broad concept and covers an awful lot of different beliefs and practices, many of which most people in Australia would be unfamiliar with and feel uncomfortable with.
Yes, thank you. To the Law Council, I would like to take you to the sort of operation and interaction of the different federal and state anti-discrimination laws. In fact, Tasmania, for example, prohibits expelling students on the basis of sexuality and gender identity. So, but this bill, as I read it, effectively creates a loophole. Under Section 7 of this bill, a religious school could decide that firing a gay teacher or expelling a gay student is conduct that a person of the same religion as the religious body could reasonably consider to be in accordance with the doctrines, tenets, beliefs and teaching of that religion. So effectively you could have a conflict between that Section 7 and the protections available under state law if this bill was passed. So what would happen then?
Well, insofar as there is a conflict in Section 109 of the Constitution, it would mean that the Commonwealth law trumps the state. So that is it. It would effectively amend or remove the protections that are available under Tasmanian law.
Okay, so effectively, as well as Section 12, which is the Statements of Belief clause, which explicitly overrides state and territory law, that Section 7 would also override the state and territory laws.
Yeah, one of the deep concerns of the Law Council is that there are many provisions within Part 2 which have that effect. Some are done specifically, some are done explicitly, I should say. So, for example, Sections 11 and 12. And some are done implicitly in the sense that it raises an issue as to whether there is conflict, Section 109 conflict under the Constitution, and whether the two sit happily together, or whether if there is an inconsistency, then of course state law must yield to the Commonwealth.
Thank you. I'd like to go to the point that you raised in your submission about relying on the external affairs power, which Professor Toomey raised significant questions around the external affairs power. So what's the Law Council's perspective on these?
Well, the question of the external affairs power is whether or not it gives the Commonwealth, obviously, the power to pass this law. And to the extent reliance on the external affairs power takes us to the international conventions, the question is whether or not the relevant Australian law is appropriate and adapted to give effect to the international law obligations. The simple point is this. While Article 18 of the International Covenant on Civil and Political Rights recognises the freedom of religion, that freedom comes with certain exceptions, and the exceptions are part of the way in which one looks at the character of the right and the extent to which Australian law reflects that relevant international law. The second point is that Article 18 of the ICCPR cannot be read and considered in isolation in the context of the human rights law, and to the extent that this bill gives precedence to Article 18 rights and freedom of religion to the important rights in the ICCPR, particularly equality and non-discrimination on a range of grounds, then in that respect, question of whether the bill would be supported by the international law is a live issue, and we agree with Professor Toomey's submissions in this respect.
Last question.
Okay, and so just then to summarise, so what that would mean is, given there is this uncertainty as to whether by relying on the external affairs power in this case, that potentially any case could be appealed to the High Court on the basis of unconstitutionality.
Well, it may not necessarily be an appeal to the High Court, but a question of the constitutionality and the validity of the law could be raised in any legal proceeding.
Yeah, so essentially you would have a lot of, a lawyer's picnic. You would have cases dragging on for a long time with sort of, a lot of legal expertise and legal resources having to be brought to bear. Wouldn't be simple at all.
Senator Rice, thank you very much.
Thank you.
I now give the call to Senator Scarr, who is appearing via teleconference.
Yeah, thank you, Chair. And my computer decided to restart whilst I was in the video conference, so I'm by teleconference just for a moment. Dr. Barker, can I ask you? I think you make a really good point in your submission, and Senator O'Neill picked this up with the quote from Thomas Aquinas, which causes one to reflect quite deeply, and that is, there's a question, isn't there, in terms of perceptions that different stakeholders have with respect to the extent to which religion impacts or is relevant in terms of how someone conducts their life. And to some extent, it seems to me, reading the different submissions, that some stakeholders are at cross purposes in terms of understanding the relevance of religious belief to those who are who have deep faith. Is that a fair observation to make in the context of this debate?
Thank you, Senator. I would agree with you that many people are at cross purposes here. One of the great challenges here is that for those who have deep religious faith, they find it very challenging to understand that that may not necessarily mean they can act in accordance with that faith in the public sphere at all times. Similarly, for those who do not have faith and do not believe in a particular way of doing things, or believe that a particular action or particular belief or practice is mandated by a God, they find it very challenging as to why they should have their life in any way impacted by something they don't believe in. And that's the challenge of this particular space, is that the people who are having this conversation have very fundamental different experiences of religion, some very positive, some very negative, some mixed, and very different understandings about to what extent they should be impacted upon religion, both as a practitioner and as a non-practitioner in the public sphere. Most, I think, would accept you can do what you like in your private space, but this bill isn't about private spaces, this is about public spaces, and there is a fundamental disagreement within Australia as to the place of religion in the public sphere. Traditionally, it has had a very non-confrontational public place. As long as you don't get too extreme, you can do what you like. But that is being challenged, and that is causing a great deal of distress on both sides. This bill is part of working that through, and will be a very fundamental part of Australia's state-religion relationship, in that it will set the tenor for what people can and can't do in the name of religion in the public sphere, not just in the written law itself, but also people's impression of the law and how people therefore respond to that.
And an expression of, or an example of that tension, of that dynamic, is in relation to the ability, the freedom of religious schools, for example, to make decisions with respect to who should be employed in those schools, or be part of that school community. So there is a debate, as everyone is aware, with respect to, well, should you qualify that right with something like, is something a inherent requirement of a role? But even in that space, there are different perceptions in terms of what is or is not an inherent requirement of a particular role. For example, does a maths teacher at a religious school need to be of a particular religious faith? Could you just provide some comments on that, please?
Absolutely, and that is one of the quintessential examples given, is the maths teacher or the gardener in a religious school. Because for a small, closely held religious school, small number of students, every staff will interact with every child, and they will interact with them not just in the classroom setting. And so for those who are running that school, and maybe many of the parents, they will have a perception that the whole school is religious, not just the religious class, and so the maths classroom is a religious setting to them. By contrast, a much larger religious schools, some of the systemic religious schools, would have a different view, that they are actually broadly secular in much of their education. It's only in certain aspects of their school which they are highly religious or religious at all. And then secular schools and parents of a secular background would have a completely different view, and they would very much delineate between religious and secular instruction. And there is that deep tension there. What is inherent to a secular person or to a person of no religion will be very different to a person of faith. And it's important to understand here too that people of faith will have different views. My personal view as a parent is I like there to be religion in my child's school, but I don't like discrimination on the basis of a person's sexuality or gender. But I am very conscious that many of the other parents who attend my children's school are very strongly of a certain view that the school should be able to discriminate, and we're of the same religion. So it's important to also understand that within a faith there can be quite divergent views on what is inherent in the role of a teacher or another person at a school and what is necessary to uphold the ethos and the values of that school. So it's a very real tension, and one that this law will have to seek to decide how it should be worked through in the Australian public sphere.
Thank you very much. I don't have much time, so I'll put just a few quick questions to the Law Council of Australia. Have the Law Council of Australia witnesses had a chance to read Professor Nicholas Aroney's submission?
Very, very briefly.
Okay, can I just put does the Law Council of Australia recognise that there are a number of leading experts in relation to issues such as religion, discrimination laws, human rights laws, international human rights laws, such as Professor Aroney, who served on the Religious Freedom Review expert panel, who have an entirely different view from the Law Council of Australia with respect to whether or not this legislation conforms with Australia's international human rights obligations?
Senator, in that respect, we are aware of Professor Aroney's view about the bill complying with Article 18, and we have, in our submissions, respectfully taken a different view.
Okay, so this is an area where reasonable people can have different views with respect to the matter, including, of course, lawyers and people of the legal profession. Is that a fair comment?
That may be so. Our approach would be informed by the way in which one approaches and interprets international law. So it may be that we have taken a perhaps more orthodox, a more technical approach to the way in which international law applies. We have had regard to the rules that apply to the way in which international treaties apply and operate, and also the broader practice of international courts and tribunals. I think our central point...
Sorry, we're running out of time. I don't mean to cut you off, but I could put to you equally that perhaps Professor Aroney, Associate Professor Fowler, and some of the other expert witnesses who've given submissions to this inquiry, they're the ones who are taking an orthodox view with respect to the application of international human rights law as opposed to the Law Council. And one example of that is this issue of corporations. And going through the submissions in detail from the witnesses who will participate in the next session, it seems quite clear to me that there are precedents from the United States, from Canada, from Europe, where human rights of people associated with corporations are protected through the corporation itself being able to bring claims. So isn't that an example where the Law Council of Australia...
Senator Scarr, if you can just hear me, we are going to need to wrap this up. So if you could just move to a question quickly, and then I'll just be seeking a quick response.
Absolutely, Chair. So isn't that an example where, on the one hand, the Law Council of Australia can say it's orthodox, but on the other hand, Professor Aroney and others say that the view of the Law Council doesn't reflect international norms and application of international human rights law?
Senator, I can answer that very quickly. International human rights law are not about protecting corporations, and the examples from domestic jurisdictions that you cite are a reflection of domestic law rather than international law.
We will need to leave it there. Thank you very much to the Law Council and Dr. Renee Barker for your evidence today. I now would like to welcome Dr. Alex Deegan, Professor Nicholas Aroney and Associate Professor Mark Fowler. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 13, 145 and 146 respectively. Do you wish to make any corrections to your submission?
No, not at this stage, thank you.
No, thank you, Chair.
Neither do I, thank you.
Thank you very much. For the Hansard record, would you each please state your full name and the capacity in which you appear today?
My name is Dr. Alex Deegan. I'm a senior lecturer in law at the Queensland University of Technology, and I appear in a personal capacity.
My name's Mark Fowler. I'm an adjunct associate professor at the University of New England and the University of Notre Dame, and I also appear in personal capacity.
Thank you.
My name is Nicholas Aroney. I'm a professor of law at the University of Queensland, and I appear in my personal.
Thank you very much. Would any of you like to make a brief opening statement of no more than 1 minute before we go to questions?
Yes, I will, Chair. Thank you for the opportunity to appear before this committee. There are 3 misunderstandings which I seek to address in these opening remarks. First, various submitters assert that the bill does not align with international law because that permits limitations on religious manifestation. This contention misunderstands the strict standards that must be met under that law, further set out in my submission. They also misunderstand that that law considers faith-based charities to be religious institutions. Second, the bill's regard to genuine beliefs utilises a mechanism that the High Court and courts within the United States, Canada and the United Kingdom have developed to refuse sham religious claims. As such, the bill will not licence sham. Finally, contention that Clause 12, protecting statements of belief, will limit an employer's ability to address inappropriate behaviour, misunderstand the bill. This is because the reasonableness test for indirect discrimination at Clause 14 is unaffected by Clause 12. Thank you.
Thank you. Professor Aroney or Dr. Deegan, do you have a brief opening statement?
Thank you, Chair. I'll make an opening statement as well.
Sorry, could you just state your name? It's just a bit tricky with everyone appearing remotely.
Sorry, Chair. Dr. Alex Deegan.
Thank you, Dr. Deegan.
Religious belief and activity is the only attribute that does not attract comprehensive separate protection under Commonwealth discrimination legislation. Such protection is necessary to address increasing hostility to religion and to fulfil our international obligations. Protection against religious discrimination is often stated interchangeably with religious freedom, and this is because they are conceptually linked. Protecting religious discrimination also entails protecting religious freedom. And religious freedom and discrimination against religion are unique for 2 reasons. First, religious freedom entails external expression. And second, religious freedom is unique because it entails external manifestation in community with others. And the bill recognises this by allowing or protecting statements of belief and protecting the ability of religious bodies to preference employees or staff.
That was 1 minute exactly. Well done, Dr. Deegan. Professor Aroney, do you have an opening statement?
Yes, look, I might address very briefly, if I may, this question about whether international human rights protect group rights and collective rights. And I'd like to draw the attention of the committee to the UN Human Rights Committee's General Comment number 22.4, which says that freedom to manifest and practice and teach religion includes acts integral to the conduct by religious groups of their basic affairs. And this is a similar view as expressed in Article 6 of the UN Declaration on the Elimination of All Forms of Intolerance and of Discrimination based on Religion or Belief, which says, among other things, that freedom of religion includes the freedom to establish and maintain appropriate charitable or humanitarian institutions. And I'd also add, finally, that UN Special Rapporteur Arkok Krishnaswamy, in his landmark 1956 report, highlighted the particular importance of what he called the, quote, collective aspects of the right to manifest religion or belief, which he said implied in...
Is that just frozen, that connection? It has. Look, we've just lost Professor Aroney for 1 moment. Hopefully we'll get him back in a minute. I'm now going to go to questions, and Senator O'Neill.
Thank you very much, Chair. And again, I have grave concerns about the amount of time that we have, but I very much appreciate your submissions. I don't know if you were watching when I just asked some questions of the Law Council. So can I first go to Associate Professor Fowler? I'd be keen to hear from each of you, but Professor Fowler in the first instance, because it's such an important question. It goes to the Law Council describing the procedural unworkability of Section 12, which is the statement of belief profession. You write in your submission that when it comes to state tribunals dealing with discrimination complaints involving the statement of belief, the need to refer the complaint to a determination on the question of the override imposed by Clause 12 would diminish rapidly over time as a body of law develops concerning the interpretation of Clause 12. Once that body is developed, state tribunals will perform their role of applying the law as stated by the relevant courts. The Law Council clearly have identified procedural problems with this as not being about whether there is well-developed interpretation of Section 12. The problem is that many state tribunals cannot apply federal law, no matter how certain that law may be. So do you still maintain that the procedural issues with Section 12 will diminish rapidly over time as a body of law develops concerning the interpretation of Clause 12?
Thank you, Senator, for the question. Yes, I do. Senator, it is the case that state courts are vested with Chapter 3 jurisdiction. So state courts can determine matters, constitutional matters that fall under Chapter 3. So where a state court determines a constitutional matter, that becomes binding on a state tribunal. I'm not entirely certain that the Law Council could clarify whether it agrees with that particular very orthodox, long-running position within our court system within Australia. Now, each of the relevant jurisdictions do allow for the transfer from a tribunal to a state court to determine matters that arise in such a conflict. Also, a federal court may be sought to determine such a conflict as well. In the instance that a federal court makes a determination, then the question is that binding on a state tribunal? A federal court's binding will be highly authoritative in respect of the particular conflict for a tribunal. And also, Senator, you may recall in the Parliamentary Joint Committee on Human Rights, I also directed attention to the rule in Fencott and Muller. And in that rule holds that where a matter is actually incidental to the determination by another claim within a tribunal, where a constitutional conflict matter, I should say, is incidental to such a claim, then the tribunal may determine it. It's a limited allowance, but it is an allowance that would prevent the need to go to a court. But look, it is very orthodox, long-running understanding of the Australian court system that a higher court will be binding on a lower tribunal.
This matter, though, really goes to the state level of interaction and its capacity to deal with this. Now, you would have heard the evidence from the Law Council last week. Where are they wrong, Professor Fowler?
I'm sorry, Senator, I didn't hear the evidence from the Law Council last week. Perhaps this is something to deal with on questions for notice, but this is quite clear and settled law here. A state court will be binding on a state tribunal and it has jurisdiction to determine these matters.
If I can indicate there'll be some questions on notice with regard to that, because we are receiving completely conflicting advice, and my goal in this committee is to make sure that the government is apprised of the best practical way to implement what it's much promised for many, many years and not end up delivering as something that actually is undeliverable. Do you believe, sorry, I might take a comment from Professor Aronia and Dr Deegan with regard to the matter I just raised with Clause 12 and with Professor Fowler.
Senator, I'd be very happy to make some additional comments on this matter, and that would be to draw the attention of the
Professor Aronia,
limited jurisdiction.
You're dropping out. Can we leave that question on notice given the terrible time allocation that we have? I do want to go to another matter. You'd be aware of Professor Anne Toomey's submission to this committee, I'm sure. Are you all familiar with that submission? Professor Fowler?
Yes, I've had a
And
read of
Professor
that.
Aroney?
Read one submission by her, whether it's the same one, I couldn't say.
Submission number 47 for the PJC HR from last week, and Dr Alex Deegan.
I have read that.
There's been serious concerns raised about sections 11 and 12 of the bill and how they've been drafted. Professor Toomey writes, it's confounding to contemplate why these provisions of a high contentious bill would be drafted in such a provocative manner. Now, this question is to all of you. Do you share Professor Toomey's concerns about the constitutionality of the bill, noting she's a very eminent constitutional scholar? If not, why not?
Senator, could I answer that? And I hope I don't cut out. I apologise for that. I raised this very question myself, submission on the second draft bill, and it is an important question to address. I think it will depend, as drafted, it would depend on whether a court interpreted those clauses as expressing the intention to cover the field. And if they were interpreted in that light, then they would probably be effective. However, if they were not,
Professor Aroney, you've dropped out again. I am particularly interested in hearing your response, so I wonder if you could provide a more detailed answer on notice. Perhaps, Professor Fowler?
yes, I could.
Yeah, look, I do have a brief.
Professor Aroney, it's the chair here. Could I ask you to turn off your video because we've got a continuing connection problem, perhaps to just appear via just with audio, and we might get a better connection. While he's doing that, Senator O'Neill, can I suggest that maybe we come back to you while Professor Aroney is reconnecting, because he's still not back online?
Sure.
Oh, Professor Aroney, can you hear us?
No.
No. Okay, we'll go to Senator Rice and then come back to you for a couple of minutes. Senator Rice.
Thank you. Given the discussion that we've had, the differing legal opinions that have been put by very eminent lawyers, yourself versus, and different opinions of the Law Council, and the potential for any action under this legislation to basically, we've got a real risk of long, drawn-out court cases with the bill as it's drafted. Given that, what is the view of the panel of why aren't we proceeding with a more straightforward, more orthodox anti-discrimination bill? And would you be in support of that, given it would limit the drawn-out court cases that we're likely to end up with as a result of this legislation?
Senator,
Thank you, Senator Rice. If I may bundle the direction from also Senator O'Neill about Anne Toomey's into this response. So, Senator Rice, in part your response goes to what the relevant international law is. I might say that this bill, on the whole, is largely orthodox. It takes the orthodox structure that we see within the Sex Discrimination Act and other forms of Commonwealth jurisdictions, such as the direct and indirect discrimination tests. Where it is novel is in the areas that we've canvassed also in the Parliamentary Joint Committee around Clause 12. That will require some clarification in courts. However, I understand the way that this presents to me is an attempt to protect the ongoing dialogue, open and free dialogue that has been around religious matters in this nation for many years. The question, going to Senator O'Neill's question about the constitutionality of this, Professor Toomey's submission raises two main points. One is she queries whether the drafting actually acquits the purpose of Clause 12, and Professor Aroney has given some drafting to deal with that in his submission, because he agrees with Professor Anne Toomey. Her further point is that the international law, this is relying heavily on the external affairs power, and therefore we're bundling in contest around what is international law. I set out within my submission at various levels how this particular bill acquits international law. And here's one example where I take a differing view from the Law Council, and I think it's very important that we look at the precise law that actually has issued from human rights courts within the world. So one of the points that the Law Council makes is that Clause 11 is too broad because it captures various faith-based charities such as public benevolent institutions, hospitals, and various other forms of faith-based expression. Quite clearly, international law encompasses these bodies as religious bodies that are exempt. If you look to the European Court of Human Rights in the Rommelfanger decision, a faith-based hospital was considered to be exempt. If you look to the European Court of Rights in 2011, the Siebenaar decision, a faith-based childcare centre was considered to be exempt. If you look to the UN Human Rights Committee's views, a group of nuns that were providing humanitarian assistance in Sri Lanka were considered to be able to exercise rights under Article 18 that protects religious manifestation. If we actually look to the precise concrete law issuing from these courts, we find that this bill is supported by that law. That's just one illustration. So Professor Anne Toomey's question is, if we are relying so heavily on the external affairs power, what certainty do we have? There is quite a degree of certainty around the scope and protections offered to religious belief within human rights law.
But given there is that, we've heard so many conflicting legal opinions over the last fortnight and in the submissions. What I don't understand is how is this legislation then going to help people of faith that genuinely need protection, given that it's basically we're going to be having access to justice being restricted because of the state federal issues. We've got the potential of long drawn out court cases when a much more simple, straightforward, orthodox piece of legislation would actually create that protection. It's not just the Law Council, we've got the Human Rights Commission that has basically raised issues, and they are the experts in the country of managing our anti-discrimination laws. What is your view? Surely, from my perspective, it would be much more sensible to have a much more standard orthodox bit of legislation that would give then protection for people of faith to not be discriminated against.
Thank you, Senator. Look, as I said, much of this bill is orthodox. The indirect, direct
much of it, but not all of it. That's the crunch, isn't it?
That's right, and I'll come to that. But in terms of the direct and indirect protections, these are protections that have been in state laws, apart from South Australia and New South Wales, since the 80s. And we haven't seen this level of concern expressed in respect of those particular protections. Yes, Senator, you're right. It is the particular bespoke protections that are within this bill that are raising most of the concern. And that's why our submissions, I think the three of us all address those particular issues. And as I said, the Clause 12 particular clause sets out quite a number of tests that must be satisfied to protect statements. So I think there is certainly a degree of clarity that can be taken from existing law around these protections. And I will hand to another of my fellow members because I've taken quite a considerable amount of time.
Senator, would I be able to answer some of these questions as well?
Yes.
Yes.
Thank you very much. One of the things I'd like to draw attention to is that although
This is obviously very frustrating. Professor...
I think we've lost them all, haven't we?
No, we haven't lost them all.
No.
We have,
Good.
we have Professor Mark Fowler and Dr Deegan. Senator Rice, do you have any other questions? I might need to ask you to put your questions on notice.
I had another question to Professor Aroney, which is a big
All right,
pity.
well, we might need to put that on hold or otherwise...
Senator Pratt here. May I ask, it might simply be that the witness has been knocked out by subtle bits of sound from other people's microphones who aren't muted. So if all our witnesses can mute, then perhaps our witness trying to answer the question might not get knocked out. So
well, we're not quite sure what the technical reasons are, Senator Pratt. Thank you. I will ask...
I'm suggesting what they are, but thank you, Chair.
Senator Pratt, just if you can just hold for a moment. Senator Rice, I will need you to put those questions on notice to Professor Aroney. I'm now going to give the call to Senator Scarr, and then we will try and come back to Senator O'Neill for a couple of minutes. If we can get Professor Aroney back on the line. Senator Scarr.
Thank you very much, Chair. And can I really congratulate and thank all of the witnesses for the extensive work you put in the submissions. I read them very closely. and they were extraordinarily useful. And the time you're being given today is subject to constraints, but I just want to place that on the record. Dr. Deegan, there was a point you made in your submission which resonated with me and comes back to a quote from Thomas Aquinas that Senator O'Neill referred to in relation to understanding the meaning of faith. And that is, and I want to quote from page 12 of your submission, where you quote Adar and Lee, who observe, opponents in the debates about the application of equality norms to religious ethos employers have been to a very large degree talking past each other because of their fundamentally incompatible starting points about the nature of employment, in particular the secular or instrumental view that is about outcomes and functions, as opposed to the religious organic approach, which sees work as a vocation in the context of service to God and fulfilling the religious mission of an organisation, end quote. I'm just wondering if you can expand on how that difference in view manifests itself in the context of this debate. And in particular, I'm thinking that example of the maths teacher. Does the maths teacher who is employed by a school, should a religious education institution have a right to require that maths teacher has a particular religious faith, a particular religious ethos, and this debate about the inherent requirements of a particular role? If you could comment on that, please.
Yeah, thank you, Senator. So this actually also partially addresses the points that Senator Rice raised in relation to why don't we just have a purely orthodox piece of discrimination legislation. The reason is because religion is actually, it's unique as an attribute which attracts discrimination protection, and it's unique in its form as religious freedom as well. And it's unique in two senses, as I briefly indicated in my opening statement. It's unique, firstly, because it entails external expression. Part of having a religion for many people is being able to externally express it through worship or through prayer, through publicly interacting with people in a public context and not hiding who you are as a religious person. And it's also unique in the sense that being religious or having a religion or practicing a religion entails practicing or manifesting in community with others. And our international law recognises this through, for example, as we've talked about, Article 18 of the ICCPR. So part of being a religious organisation with a religious ethos means that for some organisations, they may wish to develop that ethos through having staff which consistently adhere to the beliefs and the conduct standards of that organisation. And religious organisations with a particular religious ethos are obviously going to have a different view about what that ethos means compared to different religions or to secular organisations.
But presumably, but sorry to interrupt, we haven't got much time, but Dr. Deegan,
that's right.
Presumably the best people to determine that are the members of the religious community themselves in terms of requiring what they believe is necessary in the context of the relevant religious institution. Isn't that correct?
Yeah, precisely. The religion is in the best position to determine what their ethos is in terms of its content and also what it requires in terms of adherence by staff. So to take the example of the maths teacher or the gardener, for some organisations, it won't matter to them whether the maths teacher or the gardener is particularly religious. But for other organisations, they're developing a culture where everyone in that culture needs to adhere to that ethos and to model it for schools, the student body and to the broader community organisation. So the maths teacher can teach the beauty and the precision of God's creation from that perspective through looking at mathematics. The gardener can teach the care and the cultivation of God's creation through the way they take care of the grounds. So it's not a case of kind of making a distinction between secular teachers and religious teachers in a religious school setting. For certain religious schools, everyone is part of that religion and must consistently model that religion to produce a consistent ethos.
Okay,
In some schools that won't be the case, but the point is this legislation allows those schools who want to do that to do that.
Thank you.
Can I just make the point, Senator, because you've raised the question of inherent requirements. Again, if we look to the international human rights law, this has come up in the context of the Victorian proposal, which says that a court will determine whether a religious schools or bodies indeed approach to employment is reasonable and proportionate, and also has the inherent requirements of the role for that particular role. The problem is that in international law, religious manifestation can only be limited where it is necessary to do so. The word reasonable in the Victorian legislation drops that standard. That's widely recognised by both Australian courts and international courts, that reasonableness poses a lesser standard than necessary. Further, the case I cited in the European Court earlier, Siebener, involving a childcare assistant worker, is the authority that an inherent requirements test doesn't apply within religious institutions. So again, if we just read the international human rights law, we will find some quite substantive concrete guidance for us.
Can I ask Mr. Fowler if you can take on notice in that context your view about the legal view around inherent requirements when a school might employ someone not of that religion, but still determines, or any organisation, but still determines that there are other attributes of that person where to have particular attributes are part of that inherent religious requirement, but being of that particular faith is not one of them, which is often the case. Some of the examples of discrimination that have been seen to have happened.
Thank you, Senator Pratt. I will do so. I know that the Attorney General's Department has provided some quite consistent views on that as well.
Associate Professor Fowler, were you able to listen into the Law Council of Australia evidence before you joined this session?
Yes, I was.
And they seem to have a view that there are provisions in this Act that are unorthodox, that constitute a departure from human rights law, international human rights law, and in particular in relation to Clause 12, and I quote from their submission, they say this is significant departure from the approach adopted under international human rights law, end quote. Do you consider Clause 12 to be a significant departure from the approach adopted under international human rights law, or do you in fact consider it to be entirely consistent with and reflecting Australia's obligations under international human rights law?
The latter, Senator. Thank you for the very detailed reasons I said in my submission. There are a number of particular rights that are enlivened in consideration in Clause 12. Of course, Article 26 and concerning the right to non-discrimination, Article 18 concerning freedom of religion, and Article 19 including our freedom of expression. As I said in my submission, Article 19 in international law imposes very high standards on freedom of expression within our community. Clause 12 bundles in a very lengthy series of tests, including a good faith test, for which we have some direction from Justice French in Brofo, I should say. So whereas international law says there are very limited grounds in which we can limit free speech, this clause obviously has contemplated that particular requirement and has bundled in a series of tests that must be satisfied.
Right. And my last question, we're running out of time, is this issue in relation to the individual and body corporates. And you gave the example, Associate Professor Fowler, of a case in the US involving a Jewish retirement home dealing with surveyors who professed anti-Semitic views, and the Jewish retirement home as a body corporate was able to assert its rights against religious discrimination. So isn't it fair to say it's really important that body corporates and communities who are incorporated or gather as a collective have a right to assert their rights against religious discrimination?
Quite right. So this goes to what Dr. Deegan says. This is one of the unique aspects that follow with religious belief and activity, the sort of propensity of religious belief to cause people to congregate. So international human rights law, it is quite correct when the Human Rights Commission says that international human rights law is to protect individuals. But what it also recognises is if you don't protect individuals when they congregate, you undermine the protection that is given to individuals themselves. So in the European context, you cited the judgment in the US that I'd provide under the Civil Rights Act. In the European context, the European Court has also recognised the right of a corporate body to sue for breach of discrimination on the ground of religious belief. In Australian context, Justice Redlich in the Cobor decision recognised that if we didn't enable corporations of religious believers to also take protection, we would undermine the substantive protection to the individuals associated with those corporations. So it's very important that we be very clear about what we're saying here. International law does protect individuals, but if we don't also protect corporations, you undermine the protections to individuals.
Right. And Associate Professor Fowler, I'll keep asking questions as long as I've got the call. You made a number of suggestions in relation to a number of matters, including one in relation to the burden of proof with respect to requirements that might be set by employers, and also in relation to a reasonable adjustments clause. I'm wondering if you could speak to those, please, and why those changes are important.
Okay, thanks very much. Yes, the burden of proof. So in the Sex Discrimination Act, for example, in the indirect discrimination test, where an employer is asserting that their actions in discriminating or allegedly discriminating against an employee are indirect discrimination and reasonable, they have the onus to prove that under the Sex Discrimination Act, that their actions are reasonable. There is no equivalent provision within the Religious Discrimination Bill. Frankly, it seems like a drafting omission. That should be a fairly non-contentious issue. It lies within...
Sorry to interrupt, Associate Professor Fowler, and that's important because of the power discrepancy, isn't it? You've got the employer setting a requirement associated with the occupation. It might be health and safety or something, and then you've got the individual employee who's seeking to assert their rights. It's quite reasonable that the burden should be imposed on the employer, isn't it, in that context?
Yes, Senator, that is certainly the view that formed the inclusion of the provision within the Sex Discrimination Act. There's no reason why it shouldn't also apply here.
And then the reasonable adjustments clause?
So the reasonable adjustments clause is also something that has been pointed
Senator
to.
Scarr will have to make that the last question. Sorry, please continue. The last question, Senator Scarr.
Okay. So the reasonable adjustments clause is also something that's been pointed to in international human rights law. Heine Bielefeld, I set this out in my submission, the former UN Special Rapporteur on freedom of religion and belief, pointed to this as an important mechanism whereby we protect persons of religious belief within employment contexts. We should note that a similar provision already exists in the Disability Discrimination Act. And the reason it's there is very illustrative as to why I'm saying it should also be included in the Religious Discrimination Act. The Disability Discrimination Act includes a reasonable adjustments clause in response to the High Court decision in Purvis, and this is set out in my submission. The problem is this, it's around the comparator test, what discrimination lawyers know as the comparator test. That is, in this example, if in the employment context, we had a person of religious belief who undertook some form of action that their employer objected to and therefore took some disciplinary action, including termination. If the employer were to say, we would have done exactly the same for any person who did the same actions without religious motivation, that employer can then say this is not discrimination. That problem was highlighted by a Purvis judgment by the High Court. The response of the Labor government was to insert a reasonable adjustments clause within the Disability Discrimination Act to the comparator test problem. That's a very complex area of law. It is set out in my submission.
But if you can reasonably accommodate an employee, you should try and do so.
Senator Scarr, I'm going to have to pull you up there. I'm sorry, we are running over time, and I do want to return to Senator O'Neill. Hopefully we have Professor Aroney back on by way of teleconference. Senator O'Neill.
Thank you very much, Chair. And I was very interested in the line of questioning by Senator Scarr, and there is so much more that we need to hear from these expert witnesses. Again, we're racing at a clipping pace to do something that's profoundly complex. My questions were for you, Professor Aroney, with regard to the constitutionality. You know, I'm not a lawyer, and like, you know, many Australians, I know that involvement of any court, whether it's state or federal, is going to complicate and delay discrimination complaints. People won't know where to go. But I also know, as a person of faith, that the missing part of the suite in the protection of against religious discrimination is a really important thing. Despite its delay, we've got the chance now to get it right. Is there a better, more procedurally workable way of reassuring people of faith in Australia who are watching this show with the bill that an expression of faith in the way that the bill describes as a moderately expressed religious view in and of itself will not be in breach of an Australian law, and that they won't have to wait for years and have hundreds of thousands of dollars because the law isn't designed correctly? I know you've made some suggestions around Section 12. I'm very keen to get that on the public record today, Professor Aroney.
Thank you, Senator. Can you hear me?
Yes, very clearly, thank you.
I apologise for the connection difficulties we've had previously. Senator, I would answer it in this way, your question in this way, that Australia has an international obligation to protect freedom of belief and religion. And that includes an obligation to ensure that all Australian law, including state and territory law, conforms to Australia's international obligations. And as a matter of general principle, Australia is obliged under Article 18 to protect freedom of religion and also to prohibit discrimination on the basis of religion. And in essence, this is what this bill proposes to do. I think that inevitably, whenever new legislation is enacted by the Commonwealth relying on the external affairs power, questions about its constitutionality arise. I draw attention of the committee to the fact that when the Racial Discrimination Act was enacted, there were questions about whether it was constitutional. However, that did not stop the government from proceeding with enacting the law, even though the law was itself under constitutional doubt for several years until its constitutionality was resolved in the Kuwata case by a very close majority of the High Court. The same can be said about the other federal discrimination laws, including the Sex Discrimination Act. And also, indeed, when the Commonwealth decided to intervene in the construction of a dam in Tasmania, known as the Tasmanian Dam case. Whenever the Commonwealth intervenes in these areas, it does have the potential to produce a degree of litigation to resolve these constitutional questions. That is what normally happens in Australia. It's not something unusual. So I don't see that there is really a need to be overly concerned in principle that the introduction of this bill could produce some litigation, because all of the progressive steps that have been taken in Australian law to protect human rights have involved those sorts of problems. I think it's also worth observing that the same applies to questions about the jurisdiction of state tribunals. This question is not limited to this particular bill. There are many, many cases that have arisen before tribunals and courts where the limited jurisdiction of tribunals has been an issue. This includes under a lot of areas of Australian law that are well established and people don't question, such as laws relating to discrimination at a state level, or laws relating to vilification at a state level, and also laws relating to leases, retail leases, and military discipline proceedings. And no one is saying that the Commonwealth should get out of the area of law in order to resolve the problem. It's a wider problem that needs to be addressed, and I don't think it's a specific problem relevant to this bill.
Thank you, Professor Aroney. If there's anything that you think could improve the current drafting to overcome the concerns that are raised, I'd really ask you to provide that on notice. But in the end, can I just say, as a non-lawyer, but reading Professor Toomey's submission, she makes it pretty clear to me that Section 109 of the Constitution indicates that the Commonwealth law will prevail over any consistent state law to the extent of inconsistencies. And so this is how I understand it, that state law is rendered inoperative to the extent that it is inconsistent with Commonwealth law. She then goes on to say, the problem with section 11 and 12 of the Religious Discrimination Bill is that they do not follow this path of creating an inconsistency by stating that a person is authorised to do X despite a state law. That is comprehensible to me, that it needs to follow a path, and the way that the current drafting to achieve an outcome I think that, you know, everyone is in concurrence with is protection against religious discrimination, that the current drafting is flawed and will not be able to deliver that comfort to people of faith.
Yes, Senator, I agree with Professor Toomey. In fact, she raises a question that I myself had raised in relation to the second draft bill. And I proposed in my written submission to this committee alternative wording that could be instituted or inserted to replace what exists in clauses 11 and 12 to place this question beyond doubt. So I'd encourage the committee to consider that drafting.
I have read that, Professor Roney. Today I wanted you just to articulate what it is that needed to be changed so that people can understand.
I am going to have to finish up here because we are well over time, and I did.
Could we just get an answer to that question? What the difference is in the drafting that's proposed?
You need to put that on notice.
It's quite critical, Chair. It really is fundamental to the bill, and it's the area of contention.
Senator O'Neill,
I'm just pleading for an answer to the question I have already asked
Senator O'Neill,
live
for the
today,
respect
Chair.
of all witnesses today, we need to stick to time as much as we can.
Chair, I agree with you, but I've indicated we have terrible timing problems because the government has set this timetable. I urge you to allow Professor Aroney to answer that question.
Senator O'Neill,
what's wrong with that question that he can't answer it?
Senator
Seriously.
O'Neill, you don't have the call. I will ask the witness to put that on. I will ask the witness to put that on notice.
Point of order, Chair.
And
Point of order, Chair.
Look, just in the interest of trying to make sure that so far things have been running very smoothly this morning, could we give 30 seconds, just 30 seconds to the witness?
No, because I gave Senator O'Neill.
He's
it would
also
not
had
be.
technical issues with his internet.
We've got a group of witnesses waiting. We're meant to start at 10 o'clock. I did
He
say
could have
this.
answered in the time that you
There's no point of order.
interrupted his witness now.
There's no point of order. I would like to thank the witnesses for appearing today.
I want to register
and I would ask
a very high degree
Senator O'Neill,
of disappointment in the chair at this point of time because Professor Aroney has technical knowledge that can be helpful to the Australian people, and you're shutting it down.
Senator O'Neill, that is very disrespectful and reflecting on the chair.
You should let him answer the question, Chair.
We will now thank you very much to the witnesses today, and we will now move to representatives from the Australian Christian Lobby, the Freedom for Faith, the Institute for Civil Society and the Human Rights Law Alliance, as well as Mr Lyle Shelton. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions, submissions 1, 96, 128, 150 and 198 respectfully. Do you wish to make any corrections to your submissions?
Before you proceed, Chair, Senator Pratt here, someone in the committee room is typing very loudly. I'm not sure who, but it makes the witnesses quite difficult to hear because they're of comparable sound levels.
Thank you very much, Senator Pratt. We do know that we've got some technical challenges and we're trying to deal with them as best as we can. But for those who are not giving evidence, it would probably be very helpful if you could put your microphone on mute. Good morning, gentlemen. Just going back to my question, do you wish to make any correction to your submission?
Dan Flynn, Australian Christian Lobby. No, thank you, Chair.
John Steenhoff, Human Rights Law Alliance. No, thank you, Chair.
Lyle Shelton. No, thank you, Chair.
Patrick Parkinson, Freedom for Faith. No, thank you, Chair.
Thank you very much.
And Mark Snedden, no changes. Thank you.
And thank you. And for the Hansard, I know you have introduced yourself. For the Hansard record, would you please each state your full name and the capacity in which you appear today?
Dan Flynn, Deputy Director, Australian Christian Lobby.
Patrick Parkinson,
Lyle
Director,
Shelton, appearing in a personal capacity.
John Steenhoff, I'm the Principal Lawyer of the Human Rights Law Alliance.
Mark Snedden, Executive Director, Institute for Civil Society.
Thank you very much. Would any of you like to make an opening statement limited to no more than 1 minute?
Yes, Chair.
Mr Flynn.
Thank you, Chair. Thank you for considering our submission today. It is on behalf of 230,000 supporters of the Australian Christian Lobby. Subject to certain drafting fixes, we support the bill. It provides some protection for people of faith, ensuring they're not denied services or, for example, refused a venue hire for a religious meeting. The bill protects the operation and flourishing of faith-based schools, declaring in effect that it's not discrimination for these schools to recruit staff who will be ambassadors for their mission. Also helpfully, the bill makes it unlawful for universities, trade qualifying bodies, professional bodies such as law societies to prevent their members from making a religious statement in public. For employees, this protection should be extended to deal with unreasonable employer codes of conduct so that Christians cannot be sacked for posting a Bible verse on Instagram.
Thank you very much. Any other opening statements?
Yes, please.
Mr. Shelton, before I ask you to make your opening statement, I would just ask you, I'm aware of your particular legal proceedings. You're invited to appear in the capacity to respond to elements concerning this bill and this inquiry. So I would just not ask you to make any particular adverse reflections in relation to that particular matter. I know you hold that's a very passionate issue for you, but I would just ask that you be very aware of the issues in relation to adverse reflections.
Thank you, Chair. My statement just gives a bit of context to that legal matter and why I think this bill is deficient in not covering that. So if I can, I've got a 1-minute statement, if that's okay.
Thank you. Just if you can take on board my request. Thank you.
Thank you, Chair. Thank you for the opportunity to appear today. I'm being sued by 2 LGBTIQ+ drag queens for saying they are dangerous role models for children. My religious beliefs motivated me to speak up after a drag queen story time in a public library. One drag queen was a woman identifying as a man, the other a man identifying as a woman. The woman was crowdfunding on Facebook to have her breasts cut off. The man's drag name referenced a homosexual sex act. After writing a blog about the dangers of these role models to children, I was sued under Queensland's vilification laws.
Mr. Shelton, if I could just ask you to refer to that dispute in general terms, rather than making adverse reflections on the other parties in those proceedings.
Sure.
So if you could just skip over the...
Not willing to be adverse, just stating the fact. But yes,
well,
I will.
Well, that's my judgment is that there is some adverse reflection. So if I could just ask you to speak in general terms and not specify issues which are at issue in those legal proceedings, please.
Thank you. In my view, the deficient laws is allowing the shutting down of speech that people don't like using taxpayer-funded lawyers. The case has so far cost me $70,000 in legal fees and almost 2 years of angst. Despite warnings during the marriage plebiscite that this would happen, the bill before you today does not protect those who are speaking up to protect children. Thank you, Chair.
Thank you very much, Mr. Shelton. Mr. Steenhoff?
Thank you, Chair. I'll keep my introduction short. We appear for the Human Rights Law Alliance. Our organisation is a not-for-profit that acts for mainly Christians, but all people of all religions who face hostility for their faith. In our view, at its heart, this bill is a rather anodyne and unremarkable bill that gives a small incremental increase to the protection that Christians and people of religion will face. We have real examples of cases of Christians who have faced hostility. I have for the committee today a catalogue of over 44 cases that are Australian religious freedom cases that I'm happy to share around and distribute and speak to those very real cases of people who are facing hostility and for whom this bill will give some incremental protection. There are improvements that can be made to the bill that we've set out in our submissions and which are in common with many of the other submitters today. Thank you.
Thank you very much, Mr. Steenhoff.
Accept the proposed document as tabled?
Do you wish to table those documents, Mr.
I wish to
Steenhoff?
table those
Thank you very much. And now to Mr. Snedden. Do you have an opening statement?
Thank you, Senator. Yes, I do, Senator. I just need to find it. I'm sorry, I'm on holidays, but I've got it. So the Institute for Civil Society supports these bills. We work closely with faith groups in negotiating with the government. We think they're a modest and long overdue protection As senators know, there's no protection in federal, New South Wales or South Australian anti-discrimination law from religious discrimination, and staff at a cafe in those states can and have told people to leave for praying silently or reading their holy book, and they had no legal recourse. Second point is that the bill has been subject to a very significant misinformation campaign that it will enable discriminatory acts in workplaces and elsewhere on the basis of attributes other than religion, like sexual orientation or gender identity. It will not, and we have provided to the committee a fact sheet answering 5 of the largest objections to the bill. And the third point I'd make as by way of introduction is that the bill does need improvement. It does not do enough to protect against religious discrimination by employers against employees, and we have proposed a proportionality test which allows employers to have employer conduct rules, but to limit overbroad employer conduct rules. And as I think Associate Professor Fowler mentioned before, we recommend the inclusion of a reasonable adjustments requirement copied from the Disability Discrimination Act.
Mr. Snedden, I'm sorry, we will need to finish it there. I
All right.
apologise.
Sure.
We can
Thank you,
take
Senator, no
further
problem.
evidence during questions, of course,
Sure.
and then to Professor Parkinson.
Thank you, Senator. I'm here on behalf of Freedom for Faith. The best argument for this bill is how fiercely some of its opponents have argued against it. It's a very modest and limited bill, as others have said. It's not a religious freedom bill, despite what is said in the press. It's only a religious discrimination bill. Essentially provides a remedy for people to complain about discrimination. Federal law already exists in 4 out of the 6 states and in both territories, and in every state where currently there is a label. There is opposition to this bill. There have been wild claims about its effects, claims that no serious lawyer owing an obligation to be accurate and truthful could reasonably make. There are claims that people of faith run around our streets telling disabled people that their disabilities are punishment from God. These are extreme, defamatory and hurtful claims. They demonstrate the need to protect people of faith from discrimination. The reality is that over the last 2 centuries, the vast majority of caring work has been done by Christian organisations, caring for the people no one else will care for, loving the people that no one else will love. And we will continue to do so, as long as the religious character of our caring and educational institutions can be maintained. So here we stand, Christians of different denominational traditions, Catholic and Protestant, Muslims, Jewish people, people of other faiths,
Professor
united.
Parkinson, I do apologise, but I'm going to have to hold you up there. Thank you so much for... Thank you so much for your opening statement. We are running through till 11 o'clock, or a tiny bit afterwards, and I'd like to start by giving the call to Senator O'Neill. Oh, Senator Ciccone.
Thank you very much,
Thank
Chair.
you very much. And I
good morning.
welcome you as the Deputy Chair today as well.
Thank you. Could I just begin, just ask a very simple question? Would you support the bill in its current drafted form for it to be passed through the Parliament? And a simple yes or no.
Yes.
Yes, with some minor amendments.
Yes.
And the other 2 witnesses online?
Yes, with some minor amendments to make it consistent with standard anti-discrimination law in a couple of points.
I mean, despite this bill first being promised by the government around 4 years ago now, it seems the perspective of many that the provisions that are contained in the bill somewhat still require some further drafting, and we've heard that not just this morning, but obviously last week in another committee as well too. From your perspective, what else could be done to add or be drafted to the bill so that it improves the effectiveness, I guess, of the outcomes that it seeks to address? I'm probably happy to start at the table here first.
Thank you, Senator. There are a number of improvements that could be made. Some of them are simply to enact the recommendations from the expert panel report from 2018. Others are to make the changes that have already been discussed by Professor Mark Fowler and Professor Nicholas Aroney, to add a test that's consistent with international law on what constitutes a religious belief and activity, to add a proportionality test to allow for reasonable adjustments to be included as a standard for reasonableness, and also to make those changes which have already been talked about, which will cure the deficiencies which mean that religion gets lesser protection than other attributes in federal discrimination statutes, such as the onus of proof in determining the reasonableness of a condition, the inclusion of a provision that requires it to be interpreted in line with international covenants. There's plenty of things that can be done to make this a more robust and more effective bill.
Senator, I agree with the points raised and would add that if there was some protection for employee speech of a moderate nature, that would be very valuable. Interestingly, it does appear in relation to qualifying bodies, but not in relation to employer code of conducts. That would be a significant improvement.
Look, as I said, Senator, in my opening statement and in my submission, obviously I'd support the bill going forward because it's better than nothing, but there's a big gap in terms of fulfilling, I guess, the promises that were made by the leaders of the campaign to change the definition of marriage, that no one else's freedom of speech would be affected. And here we are just a few years down the track, and you can't have a debate about gender fluidity and what's appropriate for children without being sued and taken through various bodies like the Queensland Civil and Administrative Tribunal. So I think protections for freedom of speech need to be put in. Freedom that is based on religious beliefs, as mine are. The Christian religion has a belief in gender that accords with the scientific belief that the genders are binary. And if we can't talk about that in terms of the protection of children, and if that's not protected by this bill, then I think there's a real problem.
Senator, may I add to answer your question? One of the key changes I think needs to be made in the bill is in relation to the override clause in Clause 11. At the moment, the Federal Parliament in this bill has a policy that religious bodies can preference in employment people of the same religion, whether they are churches, mosques, synagogues, temples or religious schools. As we know, some state parliaments are cutting back that ability, and Victoria has done that. So the purpose of Clause 11 is to override state policy in regard of that. Clause 11 is a funny provision in the sense that it's half pregnant. It allows religious schools to preference employees of the same faith in religious schools, and to that extent overrides the Victorian provision. But for some bizarre reason, it doesn't apply the same rule to churches, mosques, synagogues and temples. So in Victoria, a church, mosque, a synagogue or temple may have considerable difficulties under the Victorian law as it now stands in preferencing people of the same religion for employment within those bodies. And that strikes me as bizarre, because that is a freedom which political parties and MPs have, to be able to preference people of the same political view when they do their employment in a political party or a ministerial advisor or an electorate officer. So a key change for us would be to extend the override in Clause 11 so that it applies to allow all religious bodies, not just religious educational institutions, to preference people of the same religion in employment.
Mr. Sned? Sorry, we haven't heard from Professor Parkinson.
I think you might be on mute.
Yeah, Professor Parkinson, you are on mute, if you could.
I apologise.
That's okay.
Senator, we've made 10 recommendations in our submission, which we refer you to. I support what Mark Steadman said about Clause 11. I think there are constitutional problems, and you could amend Section 7 by creating a right for religious bodies to employ staff of their faith or to preference them, which would create the inconsistency with state laws that we have been arguing for. So these are quite minor fixes and could be passed with goodwill through the Parliament quite quickly.
Yeah, sure. Could I just ask a clarifying question, because I think that we're all in agreement that there's a general preference from all submitters and in the general community for protection against religious discrimination, but that it really matters now when the rubber hits the road, to use highly legal language, that this is actually practically deliverable. Section 11 and 12 have been the prominent part of our investigations to date, and you've heard evidence this morning. Professor Aroney was unable to answer my question, but he is one of the few submitters that has made a very diligent effort to provide the committee with drafting recommendations around Clause 11 and Clause 12. Given your level of interest in this matter, and I know that you've been working with the government for years to try and get it to the point where we're sort of racing now through your evidence today, unfortunately, Could you give me a view on Professor Aroney's drafting recommendations for clauses 11 and 12, which go to the heart of some of the questions that you've expressed and that concern me as a person of faith also? If we're going to do it, what needs to happen to make it actually work? Could I start with Mr Steenhoff?
Thank you, Senator. Yes, we'd support Professor Nicholas Aroney's approach and his proposed drafting. We think it's far superior than the existing drafting in
Could you
clauses
flesh
11
that
and
out for me?
12.
Because Professor Aroney was not given the chance to do that. What is it that's distinctly different that you believe does that?
I think the key issue is that the problems with clause 11 and 12 is that the wording is not clear that it is going to override in those clauses, but also that it has this unusual provision, which no submitters, I believe, were asking for, that provides that the minister can specify laws that it will override by regulation, which is unusual, which I think hollows out largely the protections that are given, that are proposed to be given in clauses 11 and 12, and that a much simpler mechanism would be that's proposed by Professor Aroney.
In what way is it simpler, Mr Snedden? It just carves that bit out that you're concerned about?
Is that to me, Senator, or to Mr Steenhoff?
Well, who would like to answer that question? Mr Flynn looks like he's ready to go.
No, I think Mr Snedden is well placed to address this.
Okay, so Mr Snedden, you've been nominated by your peers.
Thank you. That's an honour. Senator, we've worked very closely in negotiations with the government about both of these clauses, and so the policy intent is clear. The federal parliament has a different policy about preferencing than some of the states. So the question is, how does the federal parliament implement its policy over the top of inconsistent state or territory rules? The criticism, we all along had said to the government it would be better just to put in a simple provision saying religious bodies have a right to prefer in their employment people of the same faith. And that then creates a legal right in federal law, which is inconsistent with contrary state law, and in the normal operation of Section 109 of the Constitution, the federal law prevails to the extent of the inconsistency. You don't need to be specifying by regulation each state law as it comes up and having a political argument each time as to whether there should be a regulation, and the Senate thinking about whether to disallow the regulation. You just have a simple statement of the right of religious bodies to preference, just like politicians and MPs and political parties have the right to preference people of the same political view. I support drafting like Professor Aroney's drafting, which would simplify that issue and would resolve the doubts which Professor Toomey has. I have to say that the government was adamant in their discussions with us that they felt their drafting was constitutional, and no doubt the Attorney General's Department will say that to you tomorrow, so you can address these questions to them as well. I think that the simple answer is to have a simply stated right, as described and as drafted by Professor Aroney, and then that will deal with the constitutional doubts that Professor Toomey has raised.
Okay.
And let me add, I agree entirely, Senator O'Neill. You have to create a federal right with which a state or territory law is consistent, and then override to the extent of that inconsistency. It's very simple.
So just before you go on, Professor Parkinson, to expand on that, that is the point that Professor Toomey makes in her submission that I read into evidence just a little while ago, and we have been talking now this morning about the only way that the state law is rendered inoperative is to the extent that it is inconsistent with Commonwealth law. And as it's currently drafted, practically you believe that is not sufficiently clear.
It's a very complicated and unnecessarily awkward way of doing it, when we've argued all along the simple way is to create a right. It is lawful for religious bodies to employ or prefer people of their faith, with which, if a state law is inconsistent, it's invalid to the extent of that inconsistency. It's not difficult and would make for a much clearer law for the Parliament to pass.
So each of the groups here today is representing, apart from Mr Shelton, significant numbers of people of faith in the Christian tradition. Professor Toomey has put her view of the way that this critical part of the bill, or this novel part of the bill, is designed. She says it is confounding to contemplate why these provisions of a highly contentious bill would be drafted in such a provocative manner. Do you share that position?
Senator.
We are unhappy, Senator, in the federal government having to take on a state directly by naming, be it Victoria, be it another state, when that doesn't create a nationally consistent law. We want to see a nationally consistent law, and one can do so without being provocative, without picking out one state which might feel targeted. So yes, I share Professor Toomey's broad view on this.
Thank you. And Mr. Steenhoff?
Sure. I'd certainly support what Professor Twomey says, but what she interprets as provocative, I interpret as a substantial watering down of the effectiveness of the provision and an unnecessary complication. We would like it simple, clear and effective by simply stating it as a positive right, which will then enliven Section 109 of the Constitution to the extent there are inconsistencies with state law.
So as it stands, the government legislation does not meet your demands as a community of faith?
It's just a complex way of doing it that we don't like and would prefer a simple way.
Yeah.
Thanks very much.
But I think, may I add, Senator, we would just prefer a simpler way. Professor Toomey has raised a doubt about a novel drafting style. The novel drafting style may well work. We won't know until ultimately the High Court decides on it, just as we didn't know about the Racial Discrimination Act. So we're not saying it's awful, we're just saying there is a simpler way to do it. What has been done may well be effective. The Attorney General's Department is disagreeing with Professor Toomey. I don't know the answer. It is better than nothing, but we think that a simpler provision of a right to preference would be simpler and clearer.
Thank you.
Yes, that is the view of the Australian Christian Lobby.
That is our view. What is the view?
The view, Senator, is that there could be a more elegant way of expressing it, but Section 11, as expressed, we consider will work. It's somewhat convoluted, and there are more simple ways to express it, more elegant ways, but we do think it will work. But I certainly agree with what my colleagues have said, that there's a better way to do it.
Thank you.
All right, thank you very much.
Chair. There were more questions on notice.
Yeah, thank you very much, Senator O'Neill. I'll now give the call to Senator Rice.
Thanks, Chair. Thank you. Look, I'm going to start off with questions to the Australian Christian Lobby. Look, you just answered in response to Senator O'Neill that you support the legislation as it currently stands, but you would like to see some amendments, but you would support it. You were quoted in a December article as saying the Australian Christian Lobby will withdraw its support for the Religious Discrimination Bill package if it includes the removal of Section 38(3). So is that still your situation?
Yes, it is. It appears that that problem has abated in that there no longer appears to be on the table a concurrent removal of Section 38(3) of the Sex Discrimination Act. But yes, that statement is true. Should that be a part of this package, we would withdraw our support. But I think all parties agree that's a matter that's going to take some consideration, and the relevant body that will consider that will report, I think, in some 12 months' time.
So if it was in fact, as we know, it is a contention in the government between various peoples and various members of the government who want to see the removal of Section 38(3), if it, during the debate and negotiation over this bill, if it came to it that, there would be support from the current members of the government who aren't in support of the bill, if the deal was that Section 38(3) was removed, you would withdraw your support for the bill then?
We would, Senator, because this is not something that should be sorted out in a sort of 5-minute corridor meeting. It's to provide protection for students in schools is a very complex matter, and an agreement to withdraw or to delete that section simply has no consultation and will open up the schools and the students to unforeseen risks.
So basically you would prefer to retain Section 38(3), which allows schools to discriminate against, to fire teachers, to expel students on the basis of their sexuality and gender identity. You would prefer to keep that, and so if you had to choose, you would prefer to keep that rather than see this bill go ahead.
Look, we're not actually presented with that choice, Senator. There are both processes. We are involved in this process. We will be involved in the other process, and there are a lot of difficult and complex matters to consider about the way in which a school governs its environment. I can say this, though, Senator, that in relation to the religious discrimination bill, there will be no gay student who is disadvantaged as a result of the passing of this bill.
Because the schools have already got the right to discriminate against them. And you want to keep that right. And basically, and that's in order to support this bill, it's keeping the right of schools to be able to discriminate against same-sex attracted and gender diverse students.
No, with respect, Senator, they are quite different matters. This bill actually gives people additional rights. It doesn't take away any rights that currently exist.
Well, I mean, this bill actually overrides existing rights. For example, in the Tasmanian state legislation, schools do not have the right to discriminate against same-sex attracted and gender diverse student. But this bill, it seems that Section 7 would overwrite that.
I don't accept that characterisation, Senator, and I think the conflating of the two issues causes confusion, and it's not something that we support.
But you do absolutely support the ability of Section 38(3), the ability for schools to be able to discriminate against same-sex attracted and gender diverse students.
I wouldn't
and
frame
teachers.
it that way.
No, you wouldn't.
Senator.
But that's the reality. That's what the consequence is, as we have seen in various cases across the country of teachers being sacked and students being asked to leave schools.
I'm not aware of those cases, and it seems
I've had many given to me over many years.
If you could just allow Mr Flynn to answer your question.
The two matters are separate. This bill gives students, teachers and others more rights, and it should be considered and dealt with on its merits to protect people from religious discrimination.
Mr Steenhoff, I think, hello. I think we I asked you some questions in the Parliamentary Joint Committee hearing in December, was that?
I believe your recollection is incorrect. I think you left just before I appeared.
Oh, okay.
I did not
All right.
read anything
I was
into
trying
that.
to recall. So thank you for tabling this case study, because I thought it was you that I asked questions about some of these case studies. But look, if I didn't, that's great, because I'm not repeating myself.
Now is your opportunity.
Now's my opportunity. In particular, I wanted the questions that I asked in December were about the case study of Max, which is on page 13 of the document that you've just tabled.
Sure.
Yep. Where it says that Max is a Christian teacher in New South Wales who had fired for his conscientious objection to the transgendering of a child at school. Can you tell me, so Max, reading this case study, it seems that Max was a teacher in a public school, not in a Christian school?
So a lot of the broad details of the case we've kept anonymous so that people do not try to find Max or find his school. We're not authorised by our client to disclose the school. So
I'm not asking you to disclose the school. I'm asking whether it was a Christian school that Max was employed in, or was it a public school?
So, as I said, Senator, if we play this yes or no question, we can narrow down to schools.
Oh, come on. How many public schools are there in New South Wales?
Chair, you might remind the witness that there is protection under parliamentary privilege, and therefore that protection should enable the witness to answer the question.
No, we have...
Senator Pratt, I don't think the issue is one of parliamentary privilege.
Well, I think it's the ridiculous assertion that's being made that somebody under a pseudonym, a teacher in New South Wales, I don't know how many thousands of schools there are in New South Wales, that you're saying it might enable the identification of this teacher if we were to know whether it was a Christian school or a public school.
Thank you, Senator. My client has allowed me to disclose what's in this, and I have obligations to my client that I can't disclose in a public forum, even with parliamentary privilege, but I can talk to the aspects of the case that my client has allowed me to disclose. It may be over-scrupulous, but it is my client's wishes.
Well, I'm going to presume that that Max was in a public school, because certainly that would be what you would read into this, where it says that teachers were instructed to refer to what you call a female student as a boy using male pronouns and a preferred male name. So basically what this is saying is that teachers were requested to affirm the gender
2 more minutes, Senator
of
Rice.
this boy. And what you want to be able to do is to allow this to occur in a public school.
Senator, this case is instructive because it shows the importance of having a reasonable adjustments clause. This was a large school in which the teacher had been confronted at a first meeting with an issue that raised for them a conscientious objection, which could have easily been allowed by the school. The teacher said, look, I have this conscientious objection to using names and pronouns. I can then be teaching in other classes. There are plenty of people in the pool of staff who can teach, and because of the difference between me and the school, I will find other employment. But this teacher was given a snap dismissal, was frog-marched out of the class, and was successful in a conciliation at reaching a significant settlement because of the way that that teacher had been treated was contrary to the Fair Work laws of Australia. But
essentially you want teachers to be allowed, even if it's not a student that they are teaching, and say in this case if you know Max was in a different classroom, to continue to be allowed to misgender this child. So that if they were having a conversation with that child's new teacher, to misgender that child, and to be able to say to that teacher and to other students and refer to this child in their to misgender them.
it's about as
you wish under this legislation for that to be completely and no questions asked for that to be legal.
I'll try to answer what is an incredibly ideologically pregnant question about misgendering, etc., to say that we need a balance between the deep, conscientious views of teachers and the rights of students. And that in this situation, that balance was not struck well because of an initial and immediate animosity towards the conscience of the teacher. And that there was a way to resolve this matter which did not require the two conflicting rights to have to come up against each other, and yet this teacher was treated dreadfully by their school when genuinely exercising a workplace right to try and inquire about the policy that the school had sprung on the teacher at the beginning of the term.
Are you aware of the level of mental
question,
distress,
Senator Rice.
suicide ideation, actual suicide of transgender and gender diverse students who are not affirmed in their gender in their schools, and not necessarily just by their classroom teacher, but by the culture of the school? Are you aware of that? Because that's
Senator,
what you were saying, that this person's so-called religious right to misgender a child and potentially putting that child's life at risk is worth it because of that so-called that requirement for their religious freedom.
Senator, the teacher involved was not seeking to, as you would say, misgender a child. There's no way that they were trying to seek that. If you read the case description, that wasn't what the case was about. And so I appreciate the attempts to make it highly emotive when dealing with a religious
It's very emotional.
discrimination bill.
It is very emotional because of the level of
And I'm happy
mental
to share
distress
the
from
deeply
having
emotional-
transgender children
the deeply
being not
emotional
accepted in
stories
their
Rice,
of people of
if I
faith.
could ask you to allow the witness to complete his answer.
So I'm happy to trade stories of the deeply emotional stories of people of faith who've been treated horribly and faced deep hostility in the workplace, at university, in their engagement in the public sphere, which make this bill necessary. Because I want to talk about this bill. I want to talk about real cases and focus on the aspects of religious discrimination that this bill addresses, not issues about gender and other protected attributes that other laws have protected for a long
Can I take
time.
it then to that generality? But essentially what you were saying is that in the interests of religious freedom, privileging other attributes, that teachers in public schools should be able to misgender a child.
No, I think I've answered that question.
Senator Rice, we will need to move to another senator. I give the call now to Senator Van.
Thank you, Chair. Mr Steenhoff, just to go back to that point that was made just previously. So you were saying that the issues that were being described by Senator Rice are issues with other bills, not with this one. Is that your evidence?
Certainly, if you're going to focus in on issues of the protected attribute of gender identity or sexuality, this bill doesn't actually cover those attributes.
Thank you, Mr Steenhoff. I then go to Professor Parkinson, if I may. Professor, can you explain why you believe the bill is compatible with Australia's international human rights obligations?
I think it begins to be compatible in the sense that it deals with discrimination, which was an Article 25 of the prohibited. It could do a great deal more to protect religious freedom. It doesn't try to do that, but we accept that this is an incremental step. We support the passing of this bill. We look forward to the Parliament considering in much more depth other issues around religious freedom that ought to be addressed as well, and one of them is around freedom of speech.
Thank you. In your submission, you outline a number of criticisms of the bill that you believe are unjustified. Can you outline some of those examples here and why you believe they're unjustified?
Well, there's been a lot of misinformation about the bill, as Mark Snedden has said. This is not a bill which deals with the Sex Discrimination Act. It does not deal with sexual orientation or gender identity issues or any other issues of pregnancy. It simply deals with discrimination on the basis of religious faith. And what it does is to give plaintiffs another right, a right which they already have in 4 states and 2 territories, which they already have under the Fair Work Act, another remedy for discrimination. It's benign and simple. It doesn't deal with the LGBT issues. Those issues are before the Law Reform Commission. They've been debated endlessly in our community. They continue to be debated, but they are issues for a separate bill.
Thank you. Thank you very much for that evidence. Do you believe there is a need for religious protection to be implemented in our legal framework?
A few years ago, I didn't, but now I do. I've always been concerned about the levels of anti-Semitism in our community, levels of Islamophobia, some of which could be dealt with under racial discrimination grounds. But I think that the levels are increasing dramatically. I think in 2018, there was a rise of more than 50% of anti-Semitic incidents in Australia. We've seen unreported incidents concerning Christians and Muslims as well. And it's very important that the federal parliament takes a stand and says this is wrong. And while the federal remedy will not add much to the remedies already existing in the state under the Fair Work Act, it's an important principle that this federal parliament ought to endorse. And for that reason, I think we need to take a stand and shame those who will discriminate on the basis of religious faith.
Thank you, and I share your views about the rise of anti-Semitism. Are there any examples that you could take us to of that, or anti-Islamic phobia, or anti-Christian, or other faiths?
There are several which we've given in our been cases of pigs' heads being left outside Islamic schools or mosques. The Jewish schools in Sydney and elsewhere need armed guards, or need guards anyway. They operate under really significant security restrictions. This is not right that high school kids should have to be guarded from violent attacks. In Geelong, just 4 or 5 years ago, we saw 5 different churches burned down, almost not reported in the press, only a very limited amount of reporting. One of those churches happened to have been converted into a mosque, but that wasn't clear from the outside. So these are some of the incidents we've seen. We've seen discrimination against Christians. The young man sacked from his job in a cafe simply because the owner said, "We don't want Christians here." So this sort of thing. It is on the rise. It's unreported. It's not right.
Thank you. I'll go to Mr Steenhoff now, if I may. In your view, what is lacking from Australia's human rights legal framework?
Thank you, Senator. It's always a puzzle to say how a human rights obligation is to be best implemented. As I said in my opening, I think this is an incremental protection. It's only narrowly focused around discrimination. Australia's implementation of its human rights obligations has almost always been focused only through the lens of discrimination, which means that it leads to some unfortunate optical problems, such as this whole suggestion that Christian schools expel gay students. So we must remove what is viewed as an exemption, which is actually a very pathetically drafted protection for human rights that are recognised in the law. So I think the approach of incremental protection is good. This bill is a good start. It has a lot of flaws that I, as a practitioner, think could be fixed that would make it much better to try to effectively use. But even just as a signpost that religious belief and activity is recognised as an attribute that you cannot discriminate against, it is a real step forward. And I think the opposition to the bill and a lot of the crazy scaremongering that has been raised in relation to it has shown the need for it. It's deficient in comparison to existing discrimination bills. It gives less protection in many respects, and yet there are people coming forward to this committee and saying it's preferencing religion and using scaremongering hypotheticals that really just could not happen under this bill, and which ignore all the other provisions of law which intersect and will give protection in those situations. So I think it is necessary, and it is a good start, but it could be improved. Particularly, we don't understand the removal of the protections for employees against draconian employer patrolling of their speech outside of work hours. There was a very banal protection that was suggested in the second exposure draft, which was removed because of, again, the scaremongering tactics. And I think what we've seen is that it doesn't matter what you do to moderate these bills. Everyone who opposes it doubles down when it comes to rejecting the bill. They double down. It hasn't worked.
Would you agree with me that from the Declaration of Human Rights onwards, Article 6 of the ICCPR, that all rights are treated equal?
Yeah,
is that the normative view of international human rights law?
That is indeed a fundamental principle of human rights law, and it is one of the recommendations of the expert panel review that is reflected in this bill, and one of the positive aspects of it, the recognition of the equality of all rights before law, which is one of the good steps that this bill takes.
Thank you. Thank you, Chair.
Yes, just before we go, we've only got a couple more minutes, but I just wanted to ask a clarifying question, Senator O'Neill, then I will go back to you. Mr Steenhoff, could you just perhaps elaborate on your concerns about this proposed legislation as to why you believe it provides less protections than other forms of discrimination law? Just quite keen for you to be clear about that particular point.
So I've laid out in my submission the areas where it is deficient in comparison to other discrimination laws, and I've differentiated that from the list of things which I think could be improvements, because everyone wants improvements to a bill, but there are some key flaws. The first is in the indirect discrimination test, where there seems to be a clause that was missed as a drafting error, which provides that if, say, an employer is going to say, the condition that I imposed on my employee that discriminated against them on the basis is reasonable, if they say, I've imposed a reasonable condition, all of the other laws, including in states and territories, say, well, it's that employer's job to prove that the condition is reasonable. Because that's missing from this bill, it means that the claimant is now going to have to contest the assertion that the condition is reasonable and prove that it is unreasonable, which would make it unique amongst all of the discrimination statutes. And I've put in some proposed wording in my submission that would deal with that, which was in the second and first exposure drafts of the bill, but somehow was missed in the redraft. The other thing is that all of the other discrimination statutes require the courts to interpret it in accordance with the international covenants. And in fact, with the supplementary changes that are happening with this bill, It's fixing up the Racial Discrimination Act to provide that it too must follow the other discrimination acts and be interpreted in accordance with international covenants. Strangely, in the object section of this Act, that is missing. There is nothing there to say that it must be interpreted in accordance with international covenants. That's a deficiency. The reasonable adjustments clause that
When you talk about a deficiency, you mean in comparison to other forms of anti-discrimination?
It's a place where this bill gives less protection, is of a lesser standard than existing laws.
Because all but the Racial Discrimination Act currently legislates in the way that you've just described, is that correct?
And the suite of bills that are introduced here is going to fix the Racial Discrimination Act, but is not going to put anything in for this Act.
Thanks, Chair.
So I just don't know why. Again, I think it probably an oversight. The next thing is the reasonable adjustments clause, which requires, say, someone imposing a condition to provide reasonable adjustments for the religious views of their employees. So a Jewish employee who cannot work on their Sabbath should be given reasonable adjustments unless it would cause undue hardship. It provides a way of moderating and allowing for the conflicting, obviously the conflict that's going to arise between, say, an employer and a religious employee to provide, if the reasonable adjustments can be made, they should. That is in the Disability Discrimination Act. It is not here. It is something that internationally has been recommended as a necessary part of any religious discrimination law, and it should be there. Other things that are missing is the lack of harassment protections. Both the Disability Discrimination Act and the Sex Discrimination Act prohibit harassment of a person on the basis of their protected attribute. Strangely, that's missing from the Religious Discrimination Act. In relation to an attribute, that definitely leads to harassment of the type, sometimes even criminal, that Professor Patrick Parkinson was referring to. There are some other small changes to the Act to bring it into line with existing acts that are in my submission that are probably not worth taking the committee's time with, but I refer
I
you
might
to
leave
that.
it there then. Thanks, Mr Steenhoff. Senator O'Neill, did you have anything else you wanted to quickly ask?
Of course, there's many more on notice, but Mr Flynn, you gave some evidence to, I think, Senator Rice with regard to section 38.3, and there have been a number of reports, including on the 1st of December, that there was a deal done by Fiona Martin, David Sharma, Katie Allen and Angie Bell with the government with regard to section 38.3. Could you clarify what you've been directly told by the government? Because somebody's not telling the truth. Either Mr Morrison isn't telling the truth to the public
Senator
or people
O'Neill,
aren't. So could you clarify?
Senator O'Neill, I would hold you
I
there.
was waiting for you to jump in there
well,
and prevent me getting an answer because Mr
No.
Flynn actually has
Senator
the answer.
O'Neill, you don't have the call.
Who's telling the truth? Mr Flynn?
Senator O'Neill, you don't
Who's
have the
telling
call.
the truth?
Could we turn off Senator
This
O'Neill's
is
microphone,
protection. This is a
Senator O'Neill, Senator O'Neill, you don't have the call.
Mr Flynn has the answer.
Senator O'Neill,
You should let him back in your
I'm going to suspend. I'm going to suspend this hearing. We'll take a private meeting. We'll resume very shortly. Thank you. The committee is now in session. Before I give the call to Senator O'Neill, I'll remind all senators that it's not in accordance with the standing orders to reflect on any member or senator. And so on that note, Senator O'Neill, if you could just rephrase your question and we'll continue.
So thank you. Mr Flynn, you may be able to answer it now. You're in discussion with the government, and I understand there were a number of reports, including on the 1st of December, that a deal had been done by Fiona Martin, Dave Sharma, Katie Allen and Angie Bell when they stated publicly they had secured a deal on section 38.3. Have you any insight into the reality of whether that deal existed or not? Has the Attorney-General or the Prime Minister advised you that there was any such deal? And what is the status of the deal to the best of your knowledge today, Mr Flynn?
Senator, I have not been advised by the Prime Minister's office or by the Attorney-General's office as to the status of any such deal. What I do know is that in search for the same answer that I have written to the Attorney-General and asked for clarification about referring to the reports and was there any such deal. So I have written to the Attorney-General. As far as I know, I have not had a reply to that letter. I do note, however, Senator, that the Attorney-General spoke at a podcast of an organisation known as Family Voice, and in that, the reporting of that event, which I wasn't in attendance at, but the reporting was, would appear to indicate that she was saying that there was no deal done. But in terms of a response to me, I'm still waiting for that in writing.
Thank you very much, Mr Flynn. And Chair, can I thank all of the witnesses for their detailed submissions and very helpful evidence, I think, this morning. The reality is we live in a pluralistic democracy and there are people of faith and no faith in Catholic schools, Christian schools, Jewish schools, Islamic schools and government schools. And it's about how we all manage to live together that we're trying to seek a remedy with this bill, I expect. So thank you. Thank you, and thank you, Chair.
Thank you very much, Senator O'Neill, and I'd like to thank all the witnesses for appearing today. We're very grateful for your time and for your considerable efforts in putting forward your submission to this very important hearing. So thank you so much for your time and commitment.
Thank you, Senator.
We're now going to suspend for morning tea and resume in 15 minutes. Is now in session, and I welcome representatives of the Australian Association of Christian Schools, Christian Schools Australia and Adventist Schools Australia, and the Australian Christian Higher Education Alliance. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submission 33, 89 and 103 respectively. Please advise if you wish to make any corrections to your submission. There being no such advice, for the Hansard record, would you please each state your full name and the capacity in which you appear today?
Mark Spencer, I'm the Director of Public Policy for Christian Schools Australia.
Nick Jensen, I'm the Political Liaison for the Australian Christian Higher Education Alliance.
Thanks, Mr Jensen.
Dylan Turner, I'm the Government Relations Advisor for the Australian Association of Christian Schools.
Dr. Jeannie Trudell, Chair of the Australian Christian Higher Ed Alliance and President of Christian Heritage College.
Thank you all very much for attending again today. Would you each like to make a brief opening statement of no longer than 1 minute before we go to questions?
Sure.
I will be enforcing the 1 minute strictly. I hope you understand we have to run a very tight ship here.
Understood. Thank you, Chair. ACHIA is a national association of faith-based higher educational institutions with a unique contribution to Australian society, which is distinct from not only the Christian schooling movement, but also secular universities. Our institutions come from a rich history that seeks to develop virtue, spiritual formation and devotion to service alongside the expansion of intellect. We train thousands of students to be chaplains, the pastors, the counsellors, the nurses, the teachers, the musicians, the youth workers and the social service employees that provide support across the nation, especially in times of crisis like the one we are facing. However, there are 4 fundamental requirements that we need in order to exist as faith-based higher education providers. These include the freedom to teach our faith and doctrine, the freedom to employ all staff according to our religious culture and ethos, the freedom to require staff and students to uphold that culture and ethos, and the freedom to resolve ethical issues with reference to our doctrines and belief. Religious discrimination impacts our institutions directly, and this legislation goes a long way to providing the necessary protections, and ACHIA supports the bill, encouraging bipartisan support before the election.
Thanks, Mr Jensen. Thank you very much. Mr Spencer, do you have
Thank you,
an
Chair.
opening statement?
Religious freedom must be the most analysed and reviewed human right in this country. As far back as 1998, the Australian Human Rights and Equal Opportunity Commission recommended a Federal Religious Freedom Act. Over that time, polling has shown strong support for religious freedom, with the independent private polling we commissioned last year demonstrating the widespread support for the bill's protections. More than 2 out of 3 Australians believing that Australian laws should uphold and protect the universal right to hold and practice religious beliefs. That polling also showed the overwhelming support for faith-based schools, with 79% of Australians supporting the right of religious schools to employ teachers and other staff who support the values and beliefs of the school, if those values and beliefs are clearly stated. This is a key element of the bill and a vital protection for Christian schools. As indicated in our submission, some of the claims against the bill in fact demonstrate its fairness and focus merely on protecting religious belief and a manifestation of that belief. The equal treatment of Mrs Colvin and Ms Lentz regarding their beliefs is clear evidence of the real concerns of Christian schools.
Mr Spencer, we will need to leave your opening statement there. Thank you. Mr Turner?
Yes, thank you, Chair. AACS represents more than 100 schools in all states and territories across Australia. AACS supports this bill and believes in its current form it will serve our school communities well, as it seeks to protect the manifestation of religious belief through Christian education. Clauses 7 and 11 are of particular importance to this end. Clause 7 is important because it protects our Christian school model by protecting the exclusive employment of staff that share the beliefs and lifestyle expectations of the school's Christian community. Clause 11 is important because it overrides certain laws at state and territory level which hinder the ability of our schools to operate under this proven and popular Christian school model. We believe there is an urgent need for this bill to pass the Parliament, and I thank the committee for the opportunity to appear at this hearing today, and I hope it will assist the inquiry.
Thank you so much. We'll now go to questions. We'll go to Labor senators first. Senator Ciccone.
Thank you very much, Chair, and good morning to our witnesses. As I did with the last round, can I just ask each of our witnesses here today a very simple question. Would you support the passage of the bill in its current form?
Christian Schools Australia and Advanced Schools would.
ACHIA would, with some recommended amendments.
Yes, Senator, we would support it in its current form.
Okay, and you mentioned with some recommendations. Are you just able to elaborate for the committee?
Sure.
Those recommendations or changes you'd like to see?
Probably the main one is around qualifying bodies. Now, it seems to be protections in the bill protect individuals who may be discriminated against according to their religion by a qualifying body, say a law council who doesn't recognise their application. But the cases that we've seen internationally, there's issues of institutions being discriminated against by qualifying bodies. So Trinity Western University in Canada had a law society who refused to recognise their law degree because of their religious code of conduct, which went all the way up to the Canada Supreme Court. So I would want to make sure, and maybe it's just a tweak or a clarity in the explanatory memorandum, that institutions who are discriminated against by qualifying bodies, be they government or otherwise, would also be protected.
And I guess I've just got a question for the Australian Association of Christian Schools. In the submission that you've put to the committee on page 348, you make a number of recommendations for amendment to this bill, but in particular, you have also raised or recommended an object be added to the bill to, quote, ensure that parents have primary responsibility for the religious education of their children in conforming with their own convictions. And I'll put this to you. How do you see this bill's education provisions intersecting with the matter respecting the choices of parents and how they educate their children?
I think the main reason why we would like to see that included is that then an educational decision or decision to educate their children becomes one that's in accordance with the doctrines, tenets and beliefs of the parent. So that if the religious belief that the parent holds, then making an informed choice in line with their belief. And so we just believe that if that's included in the bill, the legislative regime recognises that is a religious choice, so to speak, of the parent.
I don't know if the other witnesses would also like to add to it as well too.
Just add, we had the same or a very similar inclusion we recommended for the objects, merely reflecting the provisions of Article 18.4 of the ICCPR, which does recognise and protect that right.
Sorry, it does?
It recognises and protects the right of parents to educate their children in accordance with their beliefs.
Mr. Jensen, did you want to add anything? No. Okay.
Go on, I've got more questions when you're ready.
It's also been said that, I guess, around the employment provisions, and there's been a lot of debates around of that to date, but there's no need for religious schools, I guess, to require, for example, its maths teachers to be adherent to the respective school's faith. Now, I just wanted to, for the record, if you're able to put on the record your views on that too. Mr. Spencer, if I could start with you.
And we've covered in our submission quite extensively the nature of our schools and the holistic nature of the education we provide and the nature of our schools as faith-based learning communities. So to sum it up very briefly, the old adage about it takes a whole village to raise a child, we believe it takes a whole school to educate a child, and that includes all staff. So it's not just the transmission of academic knowledge or subject content, but as any teacher, any educator will tell you, it's about the relationships, it's about the informal content of the classroom, it's the dynamics within the classroom, the culture of the school, the ethos of the school. They all go to transmitting and forming that holistic young person in accordance with the education goals of the Moate Declaration.
Mr. Turner?
Yes, Senator, I would echo the comments of Mr. Spencer there. Our school model is such that it requires all members of staff in that school community to adhere to the faith of that school community, and that is the school believes that is of great benefit to the children, and that they are the learning environments then become holistically Christian. And it means then that Christian doctrine and beliefs can be weaved throughout the curriculum and not compartmentalised into one lesson per week or whatever it might be. Excuse me. So we believe that requirement is an inherent part of our school model and educational model.
And Mr. Jensen, did you have something to add?
If I could invite Dr. Trudell, who's the president of a college, to answer this one.
Thank you, Mr. Jensen. Learned members of the committee, I have to say that within the higher ed context, every single staff member needs to be of the same faith, because even if they serve in the library, they have opportunities to speak into students' lives, pray for them, and this is not just something that we make up. In the independent annual surveys, the quality indicators of learning and teaching survey, consistently the Christian institutions score really high, particularly on student care, and it's a whole of life academic and and personal development impact. So critical for all of us. I interview each staff member to ensure that they have personal faith because it does come out in their work. My staff do not see working at Action Heritage College as a job. They see it as a calling, as a vocation, as a way of life, that ministry and work are integrated. So when there is such a consistent approach to culture and to how we serve our students, it makes such a difference. For me to hire someone who does not share the ethos or the religious views, it would make such a difference in terms of how we approach student care, student learning in every single area. So it is critical. Thank you.
Could I just follow up with some questions? In terms of ethos and faith, I sort of opened a discussion towards the end of the hearings last week with the Human Rights Commission, but many Australians understand the concept of ethos, perhaps that don't understand faith. And this morning we were reminded by Dr. Barker in her submission of Thomas Aquinas' words, to one who has faith, no explanation is necessary. To one without faith, no explanation is possible. It's fair to say that across all of the faiths, there is a very differentiated way of perceiving what a faithful community serving through the provision of education looks like, and that the schools that you're representing, for the most part, in the Christians, would be along a spectrum, because no school's exactly the same, but that for the most part, that uniformity of a manifestation of belief is critical to the Christian school sector in Australia. Is that a fair representation of your sector?
Certainly a fair representation of our sector and the schools we represent. In some other schools who may have a Christian faith tradition, they may undertake faith formation in a different way, and that's perfectly valid, it's perfectly legitimate and consistent with their beliefs around that. But for our schools, it's a very deep dive, a very inclusive, a very embracing faith formation that's quite holistic in its approach.
And with all of the different faith traditions, that spectrum, if you will, of different perceptions about how faith should be manifest in the provision of a particular service by employment practices, etc., is also varied, say, in the Jewish tradition or in the Islamic tradition or in the Catholic denomination.
Without wanting to speak on behalf of them, but as I understand them, yes, and certainly we've had a lot of engagement with Islamic schools around some of these issues of religious freedom, and even within the Islamic school community there are a range of different approaches adopted within the Islamic schools around faith formation, in a similar way as there is within the Christian tradition.
So I think there's been furious agreement pretty well with every submitter and witness that Australia needs to fill out its suite of anti-discrimination legislation by providing protection for people from discrimination on the basis of religion and manifesting their religion. And I know that the sector has been waiting, or representatives of people of faith have been waiting for this for a very long period of time. This particular version is promised in 2018 and then again in 2019 and 2020, and here we are at a clipping pace trying to stitch something together that might hold in the Parliament. But making these things work in the Parliament involves deals, bits in, bits out, compromises, etc. When you were last before this committee, Mr Spencer, I asked you if you knew about a deal that was written up in an article on the 1st of December between Fiona Martin, David Sharma, Katie Allen and Angie Bell, who said publicly that they had secured it, and they each gave comments on the securing of this deal, by the way, on section 38.3. And I asked you, Mr Spencer, that question if you were aware of it. You said, "We understand there has been no deal made, that there were no amendments proposed to this legislative package that would remove section 38.3 of the Sex Discrimination Act, and will take the government at its word on that basis." Could you confirm if that is still the case, and how were you advised by the government that no deal had been made?
As far as we're aware at this stage, the situation remains the same, as indicated to the previous committee. We certainly were aware of the public comments by the Attorney General on the Family Voice podcast,
Yes.
webinar that has been referred to by other witnesses. And if I recall correctly, we had confirmed by the Attorney General's Office in relation to questions we put to the Attorney General's Office that there were no amendments proposed to the bill, to the legislative package that had been tabled before the Parliament.
So if you could take on notice who in the Attorney General's Office conveyed that information to you, so we don't name anybody publicly, that would be very helpful for me as a member of this committee. Do you have any concerns that there is a deal about 38.3?
We have no reason to have concerns. As I said, we'll take the government at its word until we understand otherwise.
Okay. So on the basis of, trying to take the government at its word and trying to work with the legislation, thank you, you've indicated in general an agreement, which is furiously agreed, that this discrimination legislation is significant and it should advance. But there is a serious contest about sections 11 and 12. I'm not sure if you heard this morning the debate about constitutionality with regard to the submission of Professor Toomey, and also concerns and debate between lawyers representing the Human Rights Commission, the Australian Human Rights Commission, the Law Council of Australia, very august bodies who are doing this work every day with very good practical knowledge on the ground, and a number of professors who cite international law, discussion about whether this is going to be an easy thing to implement or not. Lots of concerns, not about other parts of the bill so much, although minor concerns about elements, but particularly concerned about 11 and 12. And my question is to you, given that it's been so long getting to this point, do you have a view about, for example, Professor Aroney's amendments to section 12? What needs to change if we're going to do this bill in the coming weeks to make sure that what is being promised in the bill actually delivers the degree of protection from discrimination that's appropriate for religious people to expect in a way that is accessible, affordable, and doesn't discriminate against other protected attributes? Do you have a view on that complex area, Mr. Spencer and Mr. Jensen?
I haven't seen Professor Aroney's proposed amendments, so I'll take
We might
that.
provide those on notice.
I'll take that on notice,
Yep.
and certainly happy to come back to you. Certainly our position is that the bill on the face of it seems clear with its intent. We've had over the years put to us a range of perspectives around other legislation in the human rights area. It's been put to us, for example, the current proposal, the recent amendments to the Victorian Equal Opportunity Law may have a Section 109 issue in relation to the broader exemptions currently in the Sex Discrimination Act. That's been put to us that the Victorian law is likely to be invalid on that basis, although that remains unclear because it's an exemption rather than a positive right.
Right.
We've had put to us that the definition of gender identity in the Sex Discrimination Act is also so legally imprecise as to be unworkable and impossible to actually litigate on. Now, so there are many issues in the human rights area where lawyers will raise concerns of academic or other interest. We think the bill is clear enough on its face to go forward and provide the certainty that we need. And if there are concerns, if there are legitimate objections to it, they will be run through the courts. And that's the process we have, for better or for worse.
Thank you. I know you've taken that on notice with regard to Professor Aroney. Could you also read that in the context of the submission 47 to the PJCHR by Professor Toomey, because it's where those two intersect. I think it would be very interesting to get your view. And Mr. Jensen, could he provide an answer?
Senator O'Neill, we're well over time, so could I ask perhaps that question be taken on notice, or perhaps...
The committee will advise you, Mr. Jensen.
Yep, thank you very much.
Thank you, Chair.
We'll now we're just going to have to catch up on as much time as we can. To Senator Rice.
Thank you, Chair. Thank you. Thanks, Mr. Spencer and others. Look, I wanted to continue on about the discussions about this, what was reported as a deal to remove section 38.3. So was it ever put to you that that was a possibility, that there were negotiations going on, and to seek your feedback on to how you would feel about that?
To the best of my recollection, no. We certainly saw the media coverage around that, but that's as far as I'm aware, we've been involved in any discussions.
And when you saw the media coverage, did you react to that? Did you contact the Attorney General's office and say, hey, what's going on?
We wrote to the Attorney General, to the Shadow Attorney General, and put out a press release indicating our concerns around that.
And did you get a response back from the Attorney General?
I cannot recall whether we got a written response. I don't recall receiving one. That might have resulted in my previous answer to Senator O'Neill about being advised by the Attorney General's office. That might have been the response to that. I'll check and come back to you on
If you could
notice.
take that on notice and table for the committee, if you did get a response from the Attorney General, that would be most useful. Because, I mean, you're saying that you trust the government and that there has not been a deal. That's what your evidence is. But you're obviously concerned enough after seeing the media reports to write to the Attorney General.
Yes, and subsequent to that, we're less concerned about any deal being done.
And, I mean, clearly there's quite a lot of water to go under the bridge with getting this legislation through the Parliament. We know that the moderate Liberals are still very concerned and still, would like to see, as a lot of us in this room, to see the removal of Section 38(3). If it came to the crunch, if that was the deal, would you still support the package?
As we've indicated publicly to the previous committee and publicly, our legislative package of this bill and the mere removal, striking out of 38(3), we would not be able to support. 38(3), we're happy to, and we supported the recommendation of the ALRC, Australian Law Reform Commission, review 38(3). We know from 2018, 2019 it's a complex issue because it's a very broad provision that covers the whole of provision of education, including what we teach as Christian schools. So we're happy for that to be reviewed and for amendments to be made, but it needs to be done sensibly and carefully and moderately, not just a wholesale striking out of that whole provision.
Okay, so in terms of what you think is carefully, sensibly and moderately, you want the schools that you represent to continue on the basis of the religious sensibilities of the school to be able to choose to not have particular students at their school if their gender identity, their sexuality is at odds with the religious beliefs of the school.
What we want at schools is to continue to be able to have the opportunity to teach what we believe, to employ staff who share those beliefs and are able to model those beliefs. Now that's beyond a 38(3) provision. And to be able to conduct our schools in a way that support and reinforce those beliefs. So that's what we're aiming to continue to be able to have. The provisions in Section 38(3), as all the legal advice at the time was, is it's unclear because of the way that discrimination law is drafted in this country, whether we as Christian schools, for example, teaching our beliefs around gender and sexuality, whether that would fall foul of the Section 21 provisions in the Sex Discrimination Act. So until we can get that resolved and get some clarity around that, we need the broad scope of protections we've got at the moment.
Okay, so you've got teaching your beliefs around sexuality and about gender identity, but in terms of students who embrace their sexuality, affirm their gender identity, you still want to retain the right to be able to let those students know that maybe the school that they're at isn't the best school for them.
We want to continue to be able to have the right to ensure that the faith community of our Christian schools continues to be the sort of faith community that reflects our beliefs, models our beliefs and helps students to embrace those beliefs. Now that includes behaviour of students and that is across a range of areas. Now, how that interfaces with someone's chosen gender identity or their indicated sexual orientation, that's where we need the Australian Law Reform Commission to look at those things in some detail and come to a way of actually accommodating all of those things in a way that's consistent with international law, that protects our religious freedom and also protects appropriately the rights of students and others within the school community.
But so even if you've got a student who is still very strongly of the faith of the school, or in fact, a teacher who is very strongly of the faith of the school, and they have reconciled their sexuality, their gender identity with their faith and their beliefs, you would still, if that didn't align with the belief or the belief statement, for example, of the school, you would want to have the ability to ask them to leave.
Well, do you want to talk about staff or students, or do them separately?
Well, both of them, because I see the situation for both of them. And what I want to get to, and I just want to clarify for you, it's basically, it's religious freedom to conform with the beliefs of the institution. It's not the individual's religious freedom, is it?
So what we've got there is a situation where the individual's beliefs have let's take a staff member. Let's
take someone like Steph Lenz, for example.
Take the situation of Steph Lenz, who, while I can't speak on behalf of the school and not one of our members, but to use that based on the reported information, you've got a teacher who was married in a heterosexual relationship, left that relationship and went into a same-sex relationship. Her beliefs around that had changed. She indicated her beliefs around marriage and sexuality and gender had changed, and was seeking, from her comments in the media, to encourage the school to change their beliefs to align them with hers, or accept or accommodate her beliefs as being as legitimate as theirs.
Not to change the school's belief, but to accept her
her
that
belief
she
as
had
being a valid
reconciled her
expression.
belief as a devout Christian still with her sexuality, to accept her.
Yeah. And so effectively what we've got there is someone whose beliefs have changed. They now no longer align with the school. In the same way we have a range of different Christian denominations. Her beliefs no longer align with the school. It's the same as if she'd converted from Catholicism
But
to
she
Protestantism.
feels that her beliefs align with the faith of the school. She feels that she has reconciled her faith and her beliefs, and she still feels that she is a devout believer of that denomination, with that school. But essentially what you are saying is this legislation, and you support it, is actually privileging the religious institution's interpretation of those beliefs, not the individual's interpretation of their own beliefs.
It's allowing a religious body, which is a collection of people, a collection of faith community, to continue to hold their beliefs. And it's allowing the individual in that context, with their religious beliefs, to go and, as Steph Lenz has done, go and work in another school. I understand it to be another school in the broader Christian faith tradition that accepts and accommodates her beliefs. So she's still able to exercise her religious beliefs in that school, and the school where she was at continues to hold their beliefs, and that community continues to be able to...
But she would have preferred to have stayed at that original school.
She may well have.
And she felt that her personal religious freedom enabled, for her to embrace her religious freedom, she wanted to be able to stay at that school because she had reconciled her beliefs and her sexuality.
And there was a difference of beliefs between...
I add a question to Senator Rice's, which is to ask, many Christian schools, through a lack of teachers, employ staff that are not of their religion. Why then should schools then be able to dictate the attributes of those teachers in a personal sense when they're not of that faith? Because that's what these provisions also allow schools to do.
Well, Senator Pratt, you're talking about schools who aren't our member schools, and that's not the approach our member schools take. Our member schools take the approach of necessary for the faith formation as we see it, and the approach to faith formation that we embrace as schools is that all the staff within our schools need to adopt and share and conform and live out their lives consistent with our beliefs. If some other schools in the Christian tradition don't do that, that's fine. That's the way they've approached faith formation, but that's not what we're looking for.
All your staff are members of your own religious institutions then?
Sorry, I missed that first.
All your staff are members of your own religious institutions, not other religious institutions or non-religious belief, is that right?
So all the staff within our schools they may worship at a range of different denominations, but they all share
This is my question.
Yes.
What then gives you the right to define the attributes of that staff?
Okay.
Those staff, if that denomination in a particular Christian denomination evolves in a different direction.
So I'm not quite sure where the question was there, Senator, but I mean, we have a range of people from different Christian denominations who may worship in different churches on Sunday or different faith communities, but they come and work, they exercise their vocation in our faith community of a Christian school because they can share our beliefs and share the beliefs that are clearly stated by the school. And this bill will make sure that it's very explicit about that, although we do it already.
So sorry, we might now go back to Senator Rice. We've just got one more question,
Yeah,
Senator
final
Rice, then I do need to go to Senator
which
Bragg.
follows on from Senator Pratt's elaboration. So would your schools don't fire teachers of different denominations because they've got different beliefs, they've got different views on different areas of doctrine?
Step in here just for an example from higher education. So we had, in one of our members, we had someone who was high up in the theology department and who'd been there for a number of years, but over the years their beliefs changed to the point where they would say, look, I just think Jesus and the Apostle Paul were wrong. That wasn't their position originally, but they had shifted over time. Now, the school or the institution may decide that that's fine, they can still continue teaching that role, but generally our members would say, well, we are a community of faith-seeking understanding based on certain doctrines, one of them being that Jesus was right, so you can no longer be in that space. So it's more about their beliefs rather than the attributes, and there was no attribute that was in question as part of that.
So in that example...
Senator Rice, you'll literally have 30 seconds.
No, so an example, so that person was left the school.
Yes, they did. Yeah.
So, but my question was in terms of secondary schools, not lectures in theology at theological colleges. Do you ask teachers to leave because their beliefs in other areas have changed, or is it only on issues of gender identity and sexuality?
It's not merely on those issues at all. It is on a range of issues. It is on a range of conduct and a range of issues related to reflecting their beliefs.
It's not conduct. In the case of Steph Lenz, it wasn't conduct. It was her belief.
Senator Rice, we are going to need to move to Senator Bragg now. No, Senator Neal, you can at the end,
Well,
but I do need to go to Senator Bragg now. Senator Bragg, you have the call.
Thanks, Chair. Good afternoon, I should say. Do you believe that there are teachers being sacked in your member schools for being gay today?
No.
Okay. Can I ask you about this case of the pastor Karen Pack? Is that a question I can put to you, Mr. Jensen? This particular pastor says that she was sacked for being gay. Is that... So what's your...
I'm aware that's been claimed.
Yep.
So our Morling College is one of our member institutions where this occurred.
Yep.
Now they disputed that claim and indicated they provided significant support to Karen, and the departure was based on her decision to no longer adhere to a key Morling value about the nature of marriage.
Okay. So the question I have is, was Ms Pack teaching against the theology of the school?
I'm not aware of the details of her role and what she was teaching and what she wasn't. But in the same way that Mr. Spencer was talking about, the president, the ones making the decision, the board at that time, would have highlighted the importance of the culture and ethos of the school, and therefore all staff members needing to uphold that culture and ethos. And, in this case, the words of Jesus in Matthew 19 around the nature of marriage.
Okay. Well, can you take on notice whether or not Ms Pack was teaching against the theology of the school? Because I think this is the nub of the question. If people are teaching in accordance with the values and the ethos of the school, but they are gay in their private life, as I put quite crudely, does that give you the right to use the exemption in the law to remove that or terminate that person's employment? That is the question at hand here. So if you could take that on notice, I would be grateful.
May I? Sorry.
Someone want to add something? No?
Sir,
Okay.
may I?
Yes. Do you want to, Dr. Trudell? Did you want to add something to that question? Yes, Dr. Trudell.
If I could make a clarifying statement. When staff sign up for employment, frequently they are given a statement of faith. And amongst that statement of faith, it clearly sets out that including a position on marriage. If the conduct is such that it goes against the faith tenets, then we see that as a direct contradiction of religious beliefs and closely held values. So that's where the rub comes. It's not that we're seeking to fire someone on the basis of teaching or not teaching exact doctrine in the classroom. The fact that it's a community of faith means that we adhere to certain agreed upon beliefs. And that statement of faith and the closely held tenets of belief, regardless of the denominations that different staff come from, there are certain tenets that we all agree to in common, and we hold fast to those values. That's why the consistency of that belief is lived out. It's not just what we profess with our mouths, it's also the actions in our daily lives. That's a point of clarification I wanted to make. Thank you, Madam Chair.
And finally, as conscious of time, on the issue of the children in the schools, I understand that there was some discussion earlier about different clauses that may or may not be considered by this Parliament. My question is really more on the principle here, which is, do you want to have a right in the law to expel gay kids?
Again, you're making a sweeping statement there that is just needs a bit more nuance.
Yeah.
So you talk for a start, you talk about gay kids. Are you talking about same-sex attracted kids who might be committed to living a biblical, authentic life? Are you talking about young people who may be, by their behaviour, not meeting the conduct standards of the school? There's a whole range of different scenarios in there that you need to be unpacking and considering. So the short answer is no child has, and no child do we want to sack simply because they might be same-sex attracted.
Okay, so your answer is no.
The answer is no child do we want to expel simply because they're same-sex attracted.
Okay. So that means that you wouldn't have any problem with amendments that gave effect to that?
So what that means is that when it comes to the ALRC's review of Section 38.3, what we'll be looking to ensure is, as I said to Senator Rice previously, we can continue to teach our faith and beliefs around gender, sexuality and amongst a whole range of other things, that we'll continue to be able to ensure that our school as a faith community can support those beliefs. So once we get the nuance around that and where the fine lines are there, we won't have any problem moving forward, if we can get there.
Thank you. Thank you, Chair.
Thank you very much, Senator Bragg. I'll now move to Senator Scarr.
Thank you, Chair. I'll just ask a set of quick questions in relation to a matter which we haven't discussed with witnesses today. And I note that it's appeared in the submission in particular from the Australian Christian Higher Education Alliance. And that is this issue around publicly available policy. So, Dr. Trudell, I think you touched on, hello, good afternoon. You touched on the issue of staff members signing on, if you like, or joining the institution as a staff member on the basis of a set of a statement of beliefs or outline of ethos or the values or faith of the institution. The concerns being raised, so first, do you accept the proposition that it's quite reasonable that prospective employees, families that are considering whether or not their children should go to a particular institution or adults deciding to go to higher education should have the ability to consider and reflect upon a publicly available statement which makes it very, very clear what the position of the relevant religious institution is? Do you accept that as a reasonable proposition which should be included in the bill?
I don't know if it needs to be included in the bill, but it certainly does make sense that institutions, faith-based institutions, make it very clear its beliefs and what students should be signing up for. I think that's reasonable. I'm just concerned that if we try and legislate for every single possibility, it's going to be very unwieldy.
Well, I think in essence, and I'm happy to seek the views of other witnesses on this, from my perspective, considering it from a legislation perspective, the position of, say, a potential teacher who's considering making an application for employment and becoming employed, I think there needs to be an open book, if you like, in terms of, to the extent reasonably necessary, in terms of what the policies are and the ethos is, so they don't join the school, start building a career within the institution and then find that there's a misunderstanding or a difference of opinion with respect to something that's of key importance to the religious community. Is that a fair proposition?
That sounds like a fair proposition, Senator Scarr. I mean, when we seek staff members and post positions, our employment application clearly states that a pastoral reference is required, and then personal approaches to what, for instance, why is Christian education important, or something to that effect. So we try and make that clear that it is important, and then the expectations of staff that they participate in faith-based activities like chapels and prayer times, and they're expected to pray for students, etc. Those are made clear. So we don't want, it would be a travesty if someone signs on, has no idea that is a faith community, and there are a number of expectations and alignment of beliefs, that should be prior to hire. So, but the thing is, people change. You can start off being a person of faith, and that's where it gets sticky.
Absolutely, I understand that. And the particular concern, though, in this context, and I'd like I open this up to all of the witnesses, but perhaps starting with you, Dr. Trudell, a particular concern, though, is with respect to the publicly available policy that's referred to. There's a concern that the minister of this bill may, by legislative instrument, determine the requirements of that policy. And as I understand it, there's a concern from key stakeholders, and in fact this is raised by the Australian Catholic Bishops' Conference, who are appearing next, that there's a lack of definition as to what the power of the minister is in that regard, in terms of determining the requirements of that policy. And is that going to, for example, be A, purely administrative, you've got to put it on the website, you've got to have it here, you've got to have it there, or B, something a bit deeper in terms of having an impact in terms of what's in that policy or not in that policy. Can you just outline that concern? If I could just open that to the other witnesses.
I might speak to that, Senator, if that's okay. Yes, we absolutely agree that that probably is too broad. At the moment, it reads possibly allowing the minister to set requirements for the content of a religious education institution's employment policy, which is really a step too far. As you said, we agree with the policy idea, the administrative angle, but the way it's written probably needs just to be thought about, because I think it does open itself up to an overstepping of the minister's powers.
Because just in that regard, I know, and I'm looking at the draft in clause 6B, 7.6b says, if the minister determines requirements under subsection 7, the policy, including in relation to its availability, must comply with the requirements, end quote. So there's presumably no dispute that the minister might set requirements with respect to the availability of the policy and where it needs to be in terms of on a website or provided to an employee, prospective employee, within a certain period of time before joining the organisation, or provided to prospective parents and families. Is that correct? That would seem to be reasonable.
And Senator, we indicated in our submission that the approach taken in section 11.1b, which does set out on the face of the legislation the requirements of the publicly available policy, we believe those requirements should be transposed into section 7 6B and 7 6B.
Yeah. Okay. So, well, that from my perspective, that personally it seems an eminently sensible proposition on the basis that then it's quite clear what the basic requirements with respect to publication of the policy, what the policy has, etc., and that avoids the need then for this potential danger that I think it was intended, that the minister can actually dictate or have an impact in terms of what's actually in the policy. Is that correct?
Correct.
Okay. Thank you, Chair. I just wanted to flush out that point from the witnesses because it's not something we've discussed previously today.
Thank you very much, Senator Scarr.
Sorry, can I just add that we would support that
Sorry,
as well,
just
and that.
Mr. Turner. Yeah, Mr. Turner. Yes, thank you.
Yeah, thank you. We would support that as well, and we would not want to see, if the minister had the idea to make those requirements onerous, we wouldn't want to see that imposed on our schools. Many of them are small and have limited resources, so certainly we would support that sensible amendment.
So, Mr. Turner, it needs to be reasonable and proportionate.
Well, as long as the amendment's along the lines that Mr. Spencer proposed, that's fine.
Thank you. Thank you, Chair.
Thank you very much, Senator Scarr. Senator O'Neill just has a quick clarifying question, I understand.
I do. Thank you very much.
Thank you.
So, in light of the conversation or the discussion that just ensued, I think Professor Aroney's submission with amendments would be of real interest to you, and I just want to reiterate, can you have a look at that? My question, though, that I was seeking as a supplementary to Senator Rice's line of questioning goes to evidence we received last week in the Joint Human Rights Committee, and that was in response to questioning that I asked of the Uniting Church with regard to the difference between employment processes and procedures that are fair and just around ethos as opposed to employment procedures around belief. And there seems to be some language challenges about what's the difference between ethos and belief and how ethos is informed, even in a church instrument like the Uniting Church. The ethos arises from the beliefs. So if you could have a look at that evidence and just give your view about the sort of questions that we're having about the right of schools to employ in line with beliefs, in what ways, and this is really the nub of my question, in what ways is that similar to or different from employment around ethos, in your view? And if there are, and can I invite you, given the complexity of this bill, if you have any further submissions or particular drafting recommendations based on the evidence that emerges, it would be very helpful to hear from you.
I was going to say that our theology academics will love to dig their teeth into that question around belief and action and all the rest, but it may take them some time, but we'll do our best.
Sorry about the time restrictions. The government's in control of that, and, you know, they've been tardy with their homework, shall we say.
Theology academics take a long time anyway.
Senator O'Neill, the government is not in control of this. This is a matter for the committee and the Senate. So just to clarify,
it's a government control committee.
We're very.
I'm happy to change the format of this and take more responsibility for it. I'm sure it'll get done in a timely way if Labor are in charge.
Well, come and join our committee, Senator O'Neill, as a permanent member.
I have joined your committee to provide you with assistance.
Chair, just
yes.
to elaborate briefly on that, I mean, we certainly, and for the record, we see belief as including the manifestation of the belief as it's reflected in international law. So conduct and behaviour is an intrinsic part of someone's belief, and certainly in a school context, young people are very attuned to hypocrisy where actions don't mirror words. So we, from our context, see belief as encompassing conduct and behaviour consistent with that stated belief.
Yeah. And in a pluralist society, that expression and manifestation is going to reveal itself in very different ways depending on the faith tradition and the denomination of a particular faith, because the questions of the essence of humanity are contested, aren't they?
And possibly even within within subsets within a denomination, within a particular local faith community.
And we need to legislate for the whole caboodle. Thank you.
All right. Thank you very much, Senator O'Neill. And I'd like to thank all witnesses for your time today and for your very considerable efforts in giving evidence today. We really appreciate it.
Thank you.
you.
I'd now like to welcome representatives of the Australian Catholic Bishops' Conference and the National Catholic Education Commission. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 95 and 88 respectively. Please let me know if you wish to make any corrections to your submission. There being no request to do so, for the Hansard record, could you please each state your full name and the capacity in which you appear today?
Sally Egan, Acting Executive Director, National Catholic Education Commission.
Thanks, Ms Egan.
You're on mute.
Mr
Bishop Edwards, you're on mute.
How many times have we said that over the last 2 years? My apologies. Mark Edwards, I'm the Bishop of Wagga Wagga, and in particular for this appearance, I'm a member of the Bishops' Commission for Catholic Education. I'm also a member of the National Catholic Education Commission.
Thank you very much, Bishop Edwards. Professor Reynolds?
I'm Professor Rock Reynolds from Australian Catholic University, Professor in Law, and I'm here with Bishop Edwards as an advisor, well, with both groups as you know, a part of that group with a bit of legal expertise.
Thank you. And Mr McInerney?
Dallas McInerney, I'm a Commissioner of the NCEC and also the Chief Executive Officer of Catholic Schools New South Wales.
Thank you so much. Would any of you like to make a brief opening statement of no longer than 1 minute before we go to questions?
Thank you, Senator. Thank you for the opportunity today to provide a submission in relation to these bills and to appear today. The National Catholic Education Commission is the peak body representing Catholic education across Australia. The Australian Catholic Bishops' Conference is formed by the Catholic Bishops of Australia and are used to address national issues. My statement today is a joint one with NCEC and the ACBC. Religious faith is a deeply personal and fundamental human attribute. It must be given parity with the other personal characteristics given protection from discrimination. For Catholics, as for many other traditions, our faith goes beyond our private worship and is expressed in public through our services such as education. Australia's 1,755 Catholic schools educate 1 in 5, or over 777,000 students and employs over 100,000 Australians. We are open to all. This makes Catholic schools the nation's largest provider of education outside government. Catholic educational institutions are open, inclusive and welcoming places, not despite, but because they are Catholic organisations. Parents have the right to choose a school for their children that reflects their values and beliefs. For Catholic schools, this means being able to preference the employment or enrolment of people of Catholic faith and those willing to support the values and mission of their schools. This is reasonable and fair in a free, pluralist society. Catholic schools don't and are not seeking to discriminate against people on the basis of their personal attributes. Catholic schools should be free to be Catholic.
Thank you so much, Ms Egan. We will now go to questions and we'll move to Labor senators first.
From the Bishops' Conference?
No, that is a joint statement on behalf of both the Bishops' Conference and the Education Commission. Senator Ciccone.
Thank you, Chair. And I think as we've articulated throughout the course of the day, no doubt for the remainder of the day, I would probably start off by asking, do you support the bill in its current form?
We support the intent of the bill in its current form, and we believe it will provide a legal protection for our schools against overarching or overreach of state and territory governments. I'll ask Bishop Mark to respond as well.
It's certainly, there's a whole range of discrimination laws already in place, and they're really important. And this completes the suite of them, and we support that. And getting the balance then between the rights and the challenges between the different anti-discrimination legislation is really important.
Okay, and then I guess what changes would you like, the committee to make recommendations to the government in its final report in addressing some other concerns that you feel that aren't addressed by the bills currently before us?
I might take that if you like. I think that the main one is the Minister's involvement in the publicly available statement. We're great supporters of the publicly available statement. We think it encourages discourse and discussion. However, I just overheard your previous discussion about whether the provision of 11B might be included earlier in the Act for the other publicly available statements. Obviously, it only relates to inherent requirements in a position, but something similar or Professor Aroney's comments, I think, would be useful. So that's one of the main ones. The other one is the reasonableness requirement in relation to indirect discrimination. We think it could be strengthened, perhaps to say that it should take account of the objects of the Act, or, the objects of the International Covenant on Civil and Political Rights, for example. But they're the main two, I think.
And I guess, how would you like to see it strengthened?
Well, strengthened insofar as it would say, in assessing reasonableness, the freedom of religion must be taken into account. At the moment, it could just be someone takes a very secular approach to that and it doesn't really give that the importance it deserves. So, as I said, maybe by saying that it gives a number of examples of what could be taken into account in reasonableness, perhaps saying something like taking into account the objects of the Act could be added to that.
I do note in the National Catholic Education Commission's submission, on page 6, you suggest that it has the potential to result in a tiered system of religious rights across Australia, narrowing the freedoms for faith-based schools in some jurisdictions. And I was just interested to see if you could probably elaborate on that a bit further and what might be the result of such a system if it's not addressed properly.
I'll leave that to Sally, perhaps.
Yeah, look, all schools, we anticipate and expect our employees to adhere to the values and mission of our schools. And what that means in a Catholic school is that staff of Catholic faith and those willing to support the mission and values of a Catholic school are expected to adhere to the specific code of conduct and policies that are localised, I suppose, at each school and diocese. I will pass on to Dallas McInerney to also make comment here.
Senator, I think what sits behind your question is if there is in prospect an enduring differential treatment across the education sector, then might this legislation, as it's proposed, present a harmonisation opportunity for the Commonwealth and for players in education or other sectors as well, aged care or hospitals, for example, operating complex organisations and operations across multiple jurisdictions. Harmonisation seems to be something which we would support, if only for the better treatment and more certainty they would give to not only us as employers, but also to our employees.
May I have the call? Thank you.
You can have the call. Just to, I do need to stick strictly to time, so about 4 more minutes.
Thank you very much. I'm going to put on notice a couple of questions. I think there's been furious agreement right across the spectrum of the need for discrimination legislation to fill out the suite for Australia to, comply with our international obligations. The question before us is not whether the legislation in elements is appropriate, but there are certain parts of it that have been contested. And I'm very concerned as a person of faith and a product of Catholic education, I thank you for that, and for all those who created it, that sections 11 and 12, clauses 11 and 12, remain very problematic. Professor Aroney gave a number of suggestions about the way in which the constitutional concerns that are raised by Professor Toomey might be addressed to ensure that the constitutional uncertainty around section 109 of the Constitution might be remedied before we end up with a piece of legislation that brings about a lot of litigation. So can I ask you on notice to look carefully at the submissions of Professor Aroney, particularly Appendix B, and the submission 47 to the PJCHR from Professor Toomey, and give us your considered view on that to both entities. With regard to the variation of manifestation of religious beliefs and the employment processes across a range of Christian denominations, including the Catholic tradition, we've already discerned that there's different views about how adherent to a particular set of values or faith positions some employees might be required to be. And we've opened up the discussion about 38.3 here. Can I just ask you for your response to this? The Association of Heads of Independent Schools Australia, who also represent a number of religious schools, told the Joint Standing Committee that, while they largely supported the Religious Discrimination Bill, they'd like to see the passage of the bill delayed and considered at the same time as the proposed amendments to the Sex Discrimination Act because of its the necessary complexity of these two sections of law being intertwined in the way they affect employment processes and the management of schools. What's your view about advance, delay and further amendment to the bill?
Could I take this perhaps? We think that the review was to take account of issues that arose once the bill was passed. We think there will always be difficulties that people can point out. I think the bill is workable even as it is. And I don't think there's a need for a delay. I think this is such a contentious issue, you may never get agreement, and delay will just be for the sake of delay rather than to really reach agreement.
So in that case, Professor Reynolds, your response to Professor Aroney's responses and Professor Toomey's articulation of the problem would be particularly interesting, I think, for the committee.
Okay.
Yeah.
Senator Neal, if I could just also add that the Government of New South Wales have stated that they're waiting with their anti-discrimination legislation in this area on the Commonwealth. So if we all wait for each other, nothing will ever happen. So I'd like to see some action if that was possible.
Okay, and to the best effort, our best effort should be to make sure that this is workable and not becoming an expensive lawyer's picnic with a long, long tail before any clarity for the sector. What would it mean for the sector, for Catholic people generally and for Catholic schools and the parents who send their children there in particular, if there was profound uncertainty about the validity of this law making under the Constitution? What would that do?
Would you like to take that one, Dallas?
Thanks, Bishop. Well, we've operated schools in this country for more than 200 years, so there's no great calamity right on the horizon for us from that. But I think if there, as I said before in my previous answer, if there is in prospect an opportunity for us to bring certainty where it's required, particularly as this has become more contentious in the public square and other fields, then that's the opportunity should be taken without delay. Schools are, by definition, complex organisations with a lot of competing interests, internal and external. If there is something which can be brought forward from the legislature to assist in the operation at schools, and I think this is one example of that, then that's something we would welcome sooner rather than later, Senator.
And on notice, if you could, provide the committee with any indication of whether you have had direct confirmation or representation from the Attorney-General or the Prime Minister that there is no deal and that there never has been a deal with the four members of the government, Fiona Martin, I'm just trying to remember them all now, Fiona Martin, Dave Sharma, Katie Allen and Angie Bell, because there was a report of that on the 1st of December, that there was a deal done regarding Section 38.3 and a carve-out for students. If you could provide any clarification about whether that deal existed or not, that would be very helpful for the committee, and any correspondence to that end or any phone calls to seek clarification. If you could provide a file note, that would be helpful.
Certainly.
Thank you, Mr McInerney.
Thank you very much, Senator O'Neill. Now go to Senator Rice.
Thanks, Chair, and thanks for appearing before us today. I want to take you to two submissions from other Catholic organisations, one by the Rainbow Catholics Interagency for Ministry, which I presume you're aware of that organisation. Have you had a chance to look at their submission?
I neither know of them nor have seen their submission.
Okay. Anybody else? Do you know
No,
of them?
I don't have an understanding of the submission or the organisation.
Okay. Well, they say in their submission that the bill undermines and overrides anti-discrimination laws in the states that currently protect LGBTIQ civil rights for people of faith and LGBTIQ Catholics who have often been historically marginalised in their own church. So I'll just leave that one for the moment. The other submission is Catholics for Renewal. Are you aware of that organisation and their submission?
I know of them through interactions with the Plenary Council. I don't know of their submission.
No, I'm not aware of their submission either, Senator.
Okay. Well, they say in their submission that part
Gay
two...
Catholics about their issues? Sorry, Senator Rice. I just wanted to ask if they talk to gay Catholics about their issues.
It's a good question. Thank you, Senator Pratt. I mean, in preparing your submission, have you spoken with any LGBTIQA plus Catholics?
Sorry, Dallas, you go.
Senator Pratt, we don't deliberately exclude any part of our church from these considerations.
Are you
intentionally or otherwise?
Are you aware of, in your consultation when you prepared your submissions, of engaging with any LGBTIQA plus Catholics?
It's not a practice for requiring self-declaration before we have a conversation, Senator.
In the Catholics for Renewal, they said in their submission that Part 2 of the Religious Discrimination Bill slips from legislating human rights, which are by definition individual, into defining institutional rights, which override certain human rights, and to allow religious bodies to discriminate, as the bill proposes, against non-heterosexual individuals would be to fail to protect the moral equality of such individuals and to do so for the sake of protecting institutional rather than individual rights. The results of the gay marriage plebiscite discredited all claims by religious leaders to be speaking on behalf of individuals composing their congregations. So look, I'm presuming that those two statements that I've read out to you aren't the positions that you are reflecting in appearing before us today?
Senator, I would think that this is about a right of freedom of association. And so in that sense, an institution isn't something separate, but it's a gathering of a whole lot of individuals. And so I get that there's a balance to be achieved between competing rights, but it's also rights of individuals to get together to form a group where the ethos, the belief, the curriculum, if you like, of who we are is able to be presented and passed on. So we're looking for an opportunity. It's so hard for our young people to experience that it's possible to be somebody who lives a relationship with God, who believes that God's present and active in our lives as a personal being, and to be in a group of people that believe that is the gift that we want to offer our young people in our schools, but also, in our workplaces.
Yeah, but what I'm going to is you've got people who are a member of your community of faith, who are Catholics, they're Rainbow Catholics, members of Catholics for Renewal, and yet in supporting this legislation, if there an instance came up where there is an individual working in a Catholic school who is a member of the Rainbow Catholics, same-sex attracted, gender diverse, perhaps divorced, perhaps had a child outside marriage, they're a member of the Rainbow Catholics or Catholics for Renewal, in one of your churches or schools or social organisations, you think you are supporting legislation that would enable that school or social organisation or church to be able to fire that person.
We don't fire anybody for that sort of, you know, like they belong, they're part of us. We want them to be a part of our, we're inclusive, not exclusive.
There were many in submission by the Independent Education Union, certainly to the Parliamentary Joint Committee. I presume they have made the submission to this inquiry as well. They gave ample examples of people working for Catholic organisations and teachers in Catholic schools who, if not directly fired, were certainly made to, that they had to hide their sexuality and having the threat of having their employment terminated hanging over them. And this legislation would continue to allow those individual Catholic parishes or schools to enable that to occur. And so is that what you're supporting?
Excuse me, the Act protects, gives institutions, in recognition of the international law of obligation to allow parents to bring up their children in the faith, in particular, because we're talking about schools. It isn't saying you can discriminate on the basis of homosexuality, for example, and we don't. And in fact, the Catholic Constitution says we don't discriminate on the basis of homosexuality. If people are being discriminated against, it's on the basis of religion, and it may be that some person, regardless of their sexuality, may be, you know, disagreeing on the tenets of the faith in relation to the sacrament of marriage.
But
for example.
What I'm talking about, though, is that they might disagree on the basis of that they feel that the Catholic Church, they have embraced their being able to stay as a Catholic and to embrace their sexuality or their gender identity. So they very much feel that they are operating within the Catholic faith, and they are saying that that's the case, but that isn't accepted by their school or their parish or their social organisation. And so what I get to is it your position that basically it is the outlining of that faith by the institution rather than the individual is what needs to be paramount here?
The faith is it's not something that we pick or choose. It's the faith that's been handed on by the Church from the apostles, from our Lord. So it's not something that I can say what I believe, but it's what the Church believes that's actually what's important, because that's the reflection of who Jesus is.
So it's the hierarchy of the Church, or the excuse me, Senator Pratt. It's what you're saying is that, however, it needs to be the hierarchy of the Church. It needs to be the hierarchy that makes that decision, rather than an individual Catholic who has reconciled their faith and their gender identity or their sexuality.
The Church believes, so the Church is all the people, believes the hierarchy has the particular role of enunciating the belief.
So it's basically freedom for the institutions, not freedom for those individuals who have reconciled their faith and their sexuality. It's freedom for the Catholic Church hierarchy. Is that right?
It's freedom for all of us as Catholics to have freedom of association with people who believe.
But they believe
in the same way that we do.
But they
don't have to associate with me or with other bishops.
Okay, look, I will leave it there.
All right, thanks
you.
very much, Senator Rice. I now give the call to Senator Bragg.
Thanks very much, Chair. Thank you for your time. I'm also a product of Catholic education, and I thank you for your statements around children in your schools. I just want to go over some of the ground I went over with the prior witnesses. In relation to teachers in your schools, are teachers who are same-sex attracted in your schools removed from their employment, to your knowledge?
No, not at all. And it's our intention in Catholic schools to employ teachers of Catholic faith or those who adhere to our mission and values, and both of which are expected to follow a code of conduct and the policies which have been developed as they apply for the role at the school.
Okay, so thank you for that answer. So there are gay teachers in Catholic schools that are teaching in accordance with the ethos of Catholicism and the school.
Yes.
We've always yes.
Yeah. Okay. That's good. That's very important. And finally, yeah. So just on the students issue. So your position is that students who are gay should not be and are not removed from your schools.
Correct. Correct.
And do you think that the existing provisions in the Sexual Discrimination Act should be amended or repealed?
Senator Rock? Rock, did you have any thoughts on that?
I don't think they need to. I heard the previous witnesses, and I think although in the Catholic system we have a particular way of addressing these issues, in other religions they may, as they pointed out, these things are very complex, and the implications of just getting rid of Section 18.3, for example, don't know what that means. I think it would be much better to keep it there where it's been there for many years and been tried through the courts and understood through the courts.
Okay. I mean, the problem with that is that provision is very broad, and although you might have very good and progressive policy in this space, others may not.
That's right, and that's one of the aspects of freedom of religion, is that there are things that other people do in their faiths that are not the same as what we do in our faith.
That's right, and I don't think anyone is proposing to remove the ability of an institution to teach in accordance with its ethos. The question is, are there institutions that are using this provision to discriminate against people on their sexuality?
We always hear stories in the press, but I think you will normally find that those stories are about behaviour and conduct in normal HR provisions. So we deal with these as normal HR issues, and
okay.
I'm sure you'll find that that's what they are.
Okay.
In any,
Well, why
probably
not
in
put
any
in
school.
a provision into why not put a provision into your employment and other contracts that establishes that, so
Senator Pratt,
it can
with
be
respect,
established on the proper HR grounds.
Senator Pratt, while I
Because the
encourage
union tells
robust
us
discussion,
that that's not what it.
Senator Pratt, I'll just allow you to ask this question, but Senator Bragg does have the call, so if you could respect
Senator
that.
Bragg's indulgence.
Senator
I just
Pratt.
had my question to his.
Senator Pratt, if you could just
Thank
ask
you.
your question.
Okay, thanks. My last
I just wanted to ask, if you establish that you don't discriminate and it's normally for other reasons, why not terminate those on those grounds rather than the other pastoral reason?
I think that's what you would find is happening as a matter of practice.
Well, what the union has told us is that these cases don't come forward until afterwards to their minds because it happens within a pastoral care context and someone exits employment by agreement rather than an explicit discussion about their teaching.
You know that legally they would have had an action for a constructive dismissal, which I'm sure the union would have taken had there been one.
Back to Senator Bragg.
I might just ask a final question. So, if a teacher or a student does come out in one of your schools, what does happen?
I'll leave that to the schools people.
So all people in our school systems, students and staff, are to be considered and are considered equally for the basis of both employment and enrolment. As the Bishop said earlier, ours is an inclusive posture, not an exclusive posture. If there are, any sector could be pitchforked on one or two examples of where there are incidents or details which run contrary to what we're representing here today. We're happy to take those notice and look at them individually. But the history of our contribution over the last 200 years is to be an active contributor in Australia's pluralist society. We are not a secular society, and that's sometimes of Section 116. The better reading of Australia generally, and this is reflected in other public policy with the accommodations made for faith-based institutions in aged care and hospitals and education, higher education and school education. So to answer your question, Senator, there's an equal treatment, and we do not seek to weaponise someone's personal circumstances in our own settings. Not at all. That's not our policy.
Thanks, Chair.
Thank you very much, Senator Bragg. I'll now give the call to Senator Scarr.
Thank you, Chair, and I'm alive to the time, so bear with me. I want to deal specifically with respect to elements of two state legislatures. Legislation the Tasmanian Government has under Section 17 of its anti-discrimination legislation first. And I want to refer Bishop Edwards to the Porteous case, where, and I quote from the submission from the Australian Catholic Bishops' Conference, and I note this really impacted the Bishops' Conference itself, because reading from your submission, in 2016, Hobart Archbishop Julian Porteous and the entire Australian Catholic Bishops' Conference were required by the Tasmanian Anti-Discrimination Commission to issue a complaint that a document which respectfully and sensitively expounded church teaching on marriage and which was distributed to parents of Catholic school students was discriminatory, end quote. If you could please explain, Bishop Edwards, firstly, your thoughts with respect to that issue about constraints being imposed upon the Catholic Church in particular to espouse its teachings in a respectful and sensitive fashion. And secondly, the practical consequences of the application of that sort of provision in the context of a major society debate in relation to matters which impact people of faith, people of different faiths, and people of no faith.
So it was certainly a moment of drama. So it was in the context of the same-sex marriage debate, and we tried to present the Catholic position that marriage is between a man and a woman, sacramental marriage is between a man and a woman, and we put out a positive view of that. Not, it wasn't condemning anybody. Somebody took offence to that in Tasmania, and under their state legislation, dragged Julian Porteous.
Sorry, the bit that they took offence to was messing with marriage is messing with...
Sorry, Chair, I didn't interrupt.
I just wanted to put that on the
Senator Pratt,
in the context.
I didn't interrupt you.
Yes, I understand. Senator Scarr, if I could just remind all senators, Senator Pratt, respectfully, you don't have the call, so if we could just allow the Bishop to finish his answer. Senator Scarr has the call.
So as a part of there was a mediation process, and as a part of that process, Bishop Porteous was required to meet with the respondent, with the person with the complaint, and that happened, so he would turn up for the meeting and she wasn't there, and then he would turn up for the rescheduled meeting and she wasn't there. It was a very difficult time and a very scary time under, the possible consequences were quite challenging. So yes, it was a very challenging time.
And just to be very clear, and again I read from the Catholic Bishops' Conference's submission, and I quote, "The Tasmanian legislation as interpreted by the Commissioner and this is an important point because the Commissioner accepted the complaint under the relevant provision, as interpreted by the Commissioner who allowed this complaint to go forward, is incompatible with Australia's international human rights obligations and offensive to people of faith. So just to be clear, the Australian Catholic Bishops' Conference position is that that section of the Tasmanian anti-discrimination legislation, as applied by the Commissioner in that particular context, is incompatible with Australia's international human rights obligations. If I could ask Professor Reynolds, could you please explain why it is that the Catholic Bishops' Conference has that view that that provision is incompatible with Australia's international human rights obligations?
Our international human rights obligations require us to protect freedom of religion and the manifestation of that, freedom of religious belief and the manifestation of that belief. And an important part of that, of course, is teaching the belief. If you can't teach the belief, then your belief founders. And what we had there was a bishop, and the role of the bishop is to teach. That is their fundamental role. And the bishop was explaining the Church's teaching on the sacrament of marriage. So I know that people outside the Catholic Church might use marriage in a much broader sense to include civil unions, secular marriages, etc. When we talk about it, we're talking about the sacrament of marriage, and that the sacrament of marriage has a very narrow definition.
Could I just clarify that
Sorry,
the teaching was that messing with marriage equates to
Senator
messing
Rice.
with kids.
I didn't interrupt Senator Rice.
Senator Rice,
you're not.
you don't.
Senator
Senator Scar, I hear you. Senator Rice, with respect, you don't have the call. Senator Scar, we are actually almost at time. Do you have a final question?
I have one more question, and that is in relation to the Victorian legislation included in the
Senator
Equal
Scar,
Opportunity
Chair,
Religious.
before we go there, can we just clarify to round out that evidence? What happened with that claim that was put?
No, Senator O'Neill,
it was withdrawn, wasn't it?
Yes. Senator O'Neill, I'm just going to allow Senator Scar to ask his question, and I have committed to you that I will come back to you for one clarifying question.
And look, I just say, Chair, while Senator O'Neill is correct, the chilling effect on freedom of speech is clear.
Yes.
So if I can move on to the Victorian Equality Opportunity Religious Exceptions Amendment Act. And again, I quote from your submission, quote, "The new legislation diminishes the ability of faith organisations to confidently manage employment matters according to their faith and conscience. As a point of principle, this is a serious overreach of the government into the rightful freedoms of faith-based organisations in Victoria." Again, Bishop Edwards, can you explain the importance of this issue to the Catholic Church? And then Professor Reynolds, if you can explain how it sits with Australia's international human rights obligations.
Thank you very much, Senator. So as I was saying before, our schools and our hospitals and all of our communities, it's a gathering of people which provides a context which makes it easier for us to live our faith. And if we can't discriminate in favour of faith, then it makes it difficult to have that, if you like, that curriculum that we teach and we support ourselves with, that atmosphere in our different areas where we gather. Professor Reynolds.
Yes, this provision has been interpreted many times at the European or in the European courts, and it has said, I'm trying to find one quote, for example, Mark Fowler has said, the European Court of Human Rights judgments on religious institutional autonomy, in its determination in a number of cases, the European Court of Human Rights has found that there has been no violation of the rights of the employee without applying narrow occupational requirements. Because the importance is, according to the teachings of international law standards, that the ethos of the organisation goes beyond a narrow inherent requirement for one position.
And perhaps that's where we come back to the Thomas Aquinas quote with respect to the meaning of faith that Senator O'Neill's referred to. So I might pass back to you, Chair. Thank you.
All right, thank you very much, Senator Scarr. Just one final very quick question from Senator O'Neill, then we'll need to finish up.
Thank you, Chair. I just want to refer to your submission to the Parliamentary Joint Committee on Human Rights, where in your submission you assert the longitudinal study of Australian children indicates that roughly 1 in 20 Australian children has experienced discrimination on the basis of their religion, and it was higher than the rates of discrimination based on disability, mental health and sexual identity. Given the complexity of identity, including religious identity, and the challenge we seem to be facing right now as a pluralist nation to make space for a range of different views, whether they're inclusivist, as you've described the Catholic faith, or perhaps the Christians who've just described a more exclusivist model of manifestation of their faith in their schools. I link all of that to a paragraph in your submission for today that states, there are a small number of active voices in the community antagonistic to the protection of religious rights who wish to push Australia to adopt a monoculture of thought under the banner of diversity. By seeking to exclude the internationally recognised right of freedom of religion from the suite of rights Australia protects, it is in itself discriminating against people who hold religious views and is the antithesis of diversity. Could I just ask you to flesh out what is the ill that this piece of legislation seeks to address, and are you confident that, having waited so long, sections 11 and 12 of this bill will deliver the outcome that you consider necessary as leaders in the faith communities, both pastorally and in the mission of the school as church?
If I could take the first attempt to answer that, Senator, or the first part of the answer. Up until now, we've been working under exemptions and exceptions, and that's it's not a very positive way to express the right to freedom of religion, and so we're looking forward to actually having a proper anti-discrimination legislation in this area, and so I think that's we're very positive about it for that reason.
So that's the ill that you think needs to be redressed, and the bill essentially does that with some parts that might need further refinement.
That's correct.
Okay.
All right, Senator O'Neill, we are going to have to...
Could Ms Egan just give the school perspective? And that's it for me, thanks.
In 30 seconds.
We'll take that question.
I have a quick question.
Thank you. Taking on notice, I think she said.
All right, thank you very much.
Chair, I have a quick question, please. I haven't yet had the call before me.
Well, that wasn't conveyed to me, Senator Pratt, and we are at time. Can I?
I could take it on notice. That's fine.
Yeah.
I just wanted to say, so we understand this law overrides in the Tasmanian context. The statements messing with marriage is messing with kids. Can I ask your understanding of whether a statement like that would be allowed in a doctrinal context made in good faith, or whether it would invoke the Commonwealth's vilification laws under this bill?
I would like to make a comment on the title that we chose, Messing with Marriage, for that document. And one of the things that I think we've learnt is that negative title was not helpful, and we wouldn't express ourselves that way again.
Purpose of these laws? Isn't that the purpose of these laws, so that we've got a way of bringing people together to negotiate?
We certainly wouldn't express ourselves that way again. About the actual.
Should you be allowed to?
Senator Pratt, look, I did give you a bit of grace, but we are going to need.
No.
If you
could take that on notice, should you be allowed to express yourself in that way, and what recourse should the community have if you were to continue to do that?
All right. Thanks very much, Senator Pratt. The witness will take that on notice. We are now going to need to conclude this panel. I want to thank the Australian Catholic Bishops' Conference and the National Catholic Education Commission for appearing today and for their considerable time and commitment to this hearing. We're now going to suspend for lunch. I am proposing to have a shortened lunch break so we can catch up of 30 minutes. So if we could resume 30 minutes from now. Thank you very much, everyone.
Thank you, Chair.
And I would like to welcome representatives of the Executive Council of Australian Jewry and the Australia, Israel and Jewish Affairs Council. Before we proceed, though, to witnesses, I just want to just make reference to a report online which has appeared in the Australian newspaper, just to correct that report. This was published a short time ago under the title Deal or No Deal, Fiery Committee Clash Over Religious Laws.
It was rather fiery.
So I just wanted to clarify, there was a report. The report includes the statement that Senator Sarah Henderson shut down the inquiry after Labor's Deb O'Neill refused to back down from a line of questioning. I just wanted to clarify that that was not the case. I'm responsible for the good.
But we did come back.
I'm responsible for the good order of the committee, and we suspended because I had tried to make an order in relation to standing orders, and there was quite a lot of robustness, and so for the good order of the committee, I suspended the committee, and then I made the clarification in relation to the standing orders that no senator can reflect on a member or senator, and then Senator O'Neill, which was obviously well noted, continued her line of questioning, taking into account the ruling that I had made. So I just wanted to correct that report in the Australian. Okay, so I do want to thank...
Get the truth on the record, isn't it? It would be nice if we got the answer to the question.
I'll just take that as a comment, Senator O'Neill.
Yes.
I will now, as I say, move to the Executive Council of Australian Jewry and the Australia, Israel and Jewish Affairs Council. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 94 and 147 respectively. If you wish to make any corrections to your submission, please indicate that you'd like to do so. That being the case, I will now ask for the handset record if you could please each state your full name and the capacity in which you appear here today.
Thank you, Senator. I'm Peter Wertheim. I'm CEO of the Executive Council of Australian Jewry.
Thank you, Mr. Wertheim.
I'm Colin Rubenstein, Executive Director of the Australia, Israel and Jewish Affairs Council.
Thank you, Mr. Rubenstein.
I'm Naomi Levine. I'm a Senior Policy Analyst at the Australia, Israel Jewish Affairs Council.
Thanks, Ms Levine. Would any of you or either organisation like to make a 1 minute opening statement?
Thank you, Senator. We have a 1 minute statement if that's in order. We believe that the bills meet the recommendations made by the Ruddock Religious Freedom Review in 2018 and should therefore be supported. The main bill would provide federal legislative protection against negative discrimination, that is, behaviour that is directed against a person because of that person's particular religious affiliation or belief. The bill seeks to balance this with the freedom of religious organisations to operate according to their ethos, that is, to engage in positive discrimination in support of a particular religion without being directed specifically against any other religion. It is especially important for the religious organisations of numerically small faith communities, such as the Jewish community, to continue to be free to look after the religious and cultural needs of members of their communities, which are not generally catered for in the wider community. Clause 10 of the bill and the note to it recognise this. Governance of religious bodies is another area of concern to numerically small faith communities. And the bill will also permit such bodies to give preference to people of the same religion in the rules governing their membership and that of their governing boards and committees.
Mr Wortham, I'm sorry, we do need to stick strictly to time. I apologise. So I'm going to have to ask you to make any further comments in response to questions. Now to the Australia, Israel and Jewish Affairs Council for a 1-minute opening statement.
Thanks, Senator. I'll be brief. Apologies first from our Jeremy Jones, who's been involved in this issue from day one. Unfortunately, he's not well, but sends his apologies. Secondly, AJAC welcomes the rigorous work being done by Parliament to introduce religious discrimination laws. We welcome this Religious Discrimination Bill 2021. It complements existing human rights legislation and existing anti-discrimination legislation. We submit 2 particular areas that we would draw attention to. Like the ECAJ, we believe faith-based hospitals, aged care facilities, accommodation providers and disability service providers, indeed all faith-based institutions, including schools, must be free to preference the appointment of individuals to governance positions who share the religious beliefs undermining the organisation. But further work could be done to clarify this area. And secondly, we support the balanced approach taken towards statements of belief. While views distant from the mainstream are still likely to be aired, we think it's the responsibility of community leadership across the board to criticise or marginalise views that don't show respect to other Australians, and mutual respect is the hallmark, the key to the success of Australia.
Mr Rubenstein, thank you so much. I'm sorry to cut you off, but we do need to try and stay strictly within the 1 minute. We're now going to go to questions, and I will give the call firstly to Senator Scarr.
Thank you very much, and thank you to each of the 3 witnesses for appearing today. At the outset, if I could ask if you could each give your perspectives as in the case of Mr Rubenstein and in the case of Mr Wortham as people who have held senior positions in the Jewish community for a long period of time and made a substantial contribution. And also you, Ms Levine, as someone who's obviously making a serious contribution today, with respect to your perspectives about the growth of anti-Semitism and attacks on the Jewish communities and people of the Jewish faith in Australia. Mr Rubenstein?
Well, look, thank you, Senator. Look, Australia has fortunately had a tolerant history, but even in tolerant Australia, we've seen the disturbing rise in anti-Semitism in recent times, well documented in the ECAJ's annual report and certainly elsewhere, which makes this legislation, I think, particularly poignant and pressing. And so that's certainly one of the key reasons why we're very supportive to plug this hole in our anti-discrimination suite of laws here. So we're very supportive of the legislation from that point of view, but also, as Mr Wortham put it, from the positive point of view, that really faith-based institutions should be able to continue operating as they have been through the years in order to preference the appointment at a managerial governance level people who share the religious underpinnings of the organisation. That's been rather non-controversial, and we think it would be very useful to have that enshrined in the legislation.
Thank you. Mr Wortham?
Yes, thank you, Senator. It's dealt with at some length on page 2 and 3 of our submission. My organisation publishes the annual report on anti-Semitism in Australia. The 2021 report was published just recently in December. It showed an increase of 35% in the overall number of reported anti-Semitic incidents compared to the previous year. And taking a 12-month, taking an average over the years, it's well above average.
Sorry, can I just interrupt you there?
Yes.
So you said the report that's just been released in December last year showed a 35% year-on-year increase in anti-Semitic attacks or behaviour in the last 12 months. Is that correct?
That is correct, and the reference and the access to the document is provided in our submission.
Okay, thank you. And Ms Levine, I'm interested in your perspectives and no disrespect to Mr Rubenstein and Mr Wortham, just as a younger member of the community, with respect to how it impacts you belonging to a religious faith which is relatively small in numbers, and this issue of discriminatory behaviour, anti-Semitic behaviour.
To be perfectly frank with you, I think we as Australian Jews most generally have a very positive experience living here and living our faith in Australia. And we hope that this legislation goes towards protecting that positive experience. You know, I went to a Jewish school. My children are involved in Jewish activities, and we do so with freedom. You know, we have access to support services, and those support services are specifically designed to appeal to the needs of our community. And we hope that this legislation, the introduction of legislation like this, will enable that to continue operating in the way that it currently does.
Excellent. Mr Rubenstein, you mentioned the importance of governing bodies and the membership of governing bodies of hospitals, schools, etc., and the importance of ensuring that the governing body comprises members of the same faith in some circumstances. Could you just expand why that's important at the governing body level? What's particularly driving the concern in that nature? Because I know it's emphasised in the submissions.
Well, I mean, the Jewish people are indeed a people, as well as incorporating a religion, and there's certain core values embodied in that peoplehood. And so to have people who are familiar and supportive and aware of those values, I think is important at the governance level in terms of maintaining the viability and the effectiveness of that range of institutions. So there's no disrespect anybody else in having this set up, and it's worked very successfully, non-controversially. And I think what we're arguing is that it's important, I think, in these times, in these uncertain times, to have that situation enshrined in legislation, just to add extra insurance and security to that necessary setup in terms of the existence and the future of the Jewish community in general. Mr.
Wortham?
Yes, I'd support that, and our submission certainly supports what Dr. Rubenstein said. It's stated in the explanatory memorandum that voluntary bodies that are faith-based should continue to be able to preference people of their own faith in appointments to governing bodies. It's especially important to minority faith communities like ours because, being only 0.5% of the population, it wouldn't take much for outside groups to stack the membership of an organisation, take control of their governing bodies, and then completely change the nature of the organisation from a faith-based body serving the needs of a particular faith community with a particular ethos to something that's quite different, even contradictory. So it hasn't been controversial in the past that faith-based bodies can control their governing boards in that way. It shouldn't be controversial in the future. The explanatory memorandum says that that's the intention of the legislation, but the bill doesn't make it explicit. It talks about membership, but not necessarily about governing boards per se. And we think that with a minor tweak, that could be clarified so that the intention expressed in the explanatory memorandum could be realised.
Right. So it's a question, especially in the context of a religion that a faith with relatively small number of community members, in order to maximise the sustainability of the faith moving forward, that you had that ability at the governance level, the board management level, and you proposed just a small change to the legislation to make that abundantly clear, and that's something you'd like us to seriously consider. Is that correct?
That is correct.
Okay, thank you very much. I have one last question.
Just make this, sorry, Senator Scarr, we'll need to move very quickly, so just a quick last question, please.
Thank you, Chair. I note that your submission support clause 12 that's in the bill in relation to statement of belief. but you add a very important observation that whilst you support Clause 12, there is also a moral obligation upon political leaders and community leaders to make sure that in public discourse we call out any examples of statements or behaviour which shows a lack of respect to any group of people in our community. I'm wondering if you could just, as my final question, I just wanted to give you an opportunity, Mr Rubenstein, Mr Wortham, to expand on the point you're trying to make there.
Yes, as the bill stipulates, really it shouldn't become licensed for Australians to intimidate, harass or vilify other Australians using religious belief as their cover. We feel very strongly that that's the case. I mean, this again is a hallmark of our broader multicultural compact. We have rights and responsibilities, and there's no way that this legislation should undermine other anti-discrimination legislation. It complements those other acts that are very important to protect human rights.
Mr Wortham, opportunity if you have the final word on that.
Yeah, well, the bill itself says that statements of belief that are motivated by malice or which intimidate or harass will not be protected under that clause. Nonetheless, it can be interpreted or might be interpreted by some as giving licence to lower level forms of denigration. And I do think it's important that politicians have a uniform message to the public that will negative any such message, whether express or implied, arising out of the bill. So that's the reason for that recommendation.
Thank you.
All right, thank you very much, Senator Scarr. I'll now go to Senator O'Neill.
Thank you very much, Chair. And if I can just indicate the report that you referred to in the Australian, I believe actually was a pretty accurate representation of what did occur. I note that you gave your rationale, but I think it would be important for people to understand that the journalist, in my view, actually did report what happened, and journalists who are interested, I encourage you to read the Hansard and watch the video to make up your own mind about the truth of that that article by Mr Campbell.
Senator O'Neill, I'm sorry, you're reflecting on the chair, and I would ask you...
No, I said that you clarified. I'm happy to put that on the record.
I would ask you not to do that. Please proceed to your questions.
Thank you for your evidence in multiple committees with regard to this bill. I know it's been a very, very long time coming. And while there is very generous and widespread support for the enactment of legislation to protect against religious discrimination...
Sorry, Senator O'Neill, apologies. I just would ask, could everyone, except when they're answering a question, please put your microphone on mute? We're getting a lot of interference. Thank you, Senator O'Neill.
Thank you. Could I ask, with regard to Clause 11 and 12, if you have given close consideration to the submission by Professor Aroney, who in Appendix B offers revised drafting of Clauses 11 and 12, which goes some way to address the concerns that are also raised in another important submission, and that's of the submission 47 to the Parliamentary Joint Committee on Human Rights from Professor Toomey. So if you have good insight into those particular submissions, I'd be very keen to get your response. If not, I would ask you to take on notice if the drafting by Professor Aroney addresses the concerns that are raised by Professor Toomey to your satisfaction as representatives of the Jewish community. I invite you now to make comment with regard to that, Clause 11 and Clause 12, more generally, and if you can, in the particular. Start with Mr Wertheim.
Thank you, Senator O'Neill. I haven't read the submissions, but I do understand that Senator Toomey raised an issue about the potential invalidation of some of the provisions of the bill under the Constitution, and Professor Aroney has suggested a workaround to remedy that potential problem. I don't profess to be an expert in constitutional law, and I'm not sure that my opinion on that would be of great value, but to the extent that it might be necessary to amend the bill in order to either achieve greater clarification or alternatively to avoid a constitutional invalidity, then we would support any such change. If you want something more detailed than that, I'm happy to look at it, but that would be our take on it.
Given the importance of the matter and the statistics that you've just heralded here of the 35% increase in anti-Semitic behaviour, which is noted also in the Australian Catholic Bishops' submission, also concerns about the Muslim community and the reporting of crime, religiously motivated crime. I would be very interested to see if what's put by Professor Aroney actually would go some way to getting rid of the uncertainty around the workability of clauses 11 and 12, because they are fundamental, they are novel, that's a given. They are fundamental to actually getting an outcome. I'm really keen to make sure we don't get window dressing that leads to years and years of litigation without an outcome for Jewish people, in your particular case, and all people of faith. To be clear, Professor Toomey's statement is that the state law is rendered inoperative to the extent that it's inconsistent with the Commonwealth's law, and that the draft currently doesn't actually meet that test. Professor Aroney believes that his new words do that, so that's why I'm particularly interested in that one.
As I understand it, he's seeking to introduce wording that would be consistent with Section 109 of the Constitution.
Yes, to deal with that matter.
And that would seem to me to make a lot of sense.
Okay.
But I'm happy to give you a more considered opinion on notice.
I'm sure you might be able to access a few bright minds in the legal area within the Jewish community. Dr. Rubenstein, do you have a view?
Yes, well, look, I did read the opinion of Professor Aroney. I concur with what Mr. Wertham said. I'm not a constitutional lawyer either, and I would certainly be prepared to give follow-up information, but I must say his qualifications seem eminently reasonable and worthy of serious consideration. I mean, the courts will clarify the terminology in due course, but as you rightly point out, that could be a tardy process. So our initial reaction is this is quite a sensible, reasonable suggestion from qualification from Professor Aroney.
Thank you. With regard to the reality of Jewish schools, we heard this morning concerns raised by other submitters of different faith that the level of protection that is now required at Jewish schools is actually very significant, that there are guards. There was some doubt about whether they are armed guards. Could you put the record straight with regard to that?
Some of them are armed, yes.
That is perhaps something that hasn't really captured too much of the imagination, because I think there's some people indicating that there is no mischief and the religious discrimination is not a thing that's really happening. The reality is very, very prominently known to your community. In light of that pressing reality, we need to get this legislation right. In addition to our discussion about clauses 11 and 12, can I just give you the opportunity now, seeing as you've made the time to be here for the inquiry, to put on the record any further amendments in light of all the evidence that's been emerging that you think are necessary to make this bill operate in a way that provides timely protection for the freedom to practice religion without discrimination as a Jewish person in Australia?
Well, I wouldn't go beyond the recommendations we've actually set out in our submission, Senator, which are, there's only about half a dozen of them, and they're mostly for the purpose of achieving greater clarification and consistency within the legislation. But in terms of security, I mean, having legislation against religious discrimination is really only going to be one string to the bow, if I can put it that way. We already have racial discrimination laws. We've had them for quite a number of years. We've had provisions also protect against racial vilification in the broad sense in Part 2A of the Racial Discrimination Act. by themselves, legislation and laws of that nature are necessary, but not sufficient to really address the kind of problems you've alluded to. We need to really address racism and bigotry across the board in a whole of government way. It can't just be legislation. There needs to be an education arm to it. There needs to be a nationwide system of recording hate-motivated crime. We don't even have that at the moment. Other submitters may have talked to you about hate-motivated crime in respect to particular faith communities. But it's left to those communities themselves to document it, because most of the time there is no system available either at the state level and certainly not at the federal level to do so. There's a whole range of things that we need to do to address these issues, Senator. It's not just through this one piece of legislation, as important as that legislation will be.
Some other submitters, including communities of different faiths, don't share the same views as the Jewish community with regard to the necessity of this legislation. And they particularly don't accept the necessity for religious organisations to be given protection. Perhaps that's a misunderstanding of the international human right with regard to manifestation and the freedom of association. Nonetheless, could I ask you, because you provide very specific aged care into Jewish communities, about why it is so important that reality is covered off in this bill for your community?
Well, we do have aged care facilities throughout Australia who cater specifically for the needs of the Jewish community. And like any other minority community, there are cultural needs, religious needs that are specific to the community that would not otherwise be catered for in the wider sector, whether you're talking about the aged care sector or accommodation sector or generally. So if the opportunity isn't there for faith communities, particularly smaller ones like ours, to cater for those needs, then they're not going to be catered for. We're not going to, we can't expect, for example, every aged care facility to kosher food available for those who need it, or to have Jewish religious observances available for those who need it, or to have social workers who understand the specific experiences of Holocaust survivors for those who need it. Our community, through its various institutions, provide all of those things, which would not otherwise be catered for. And I don't think that is necessarily understood in wider instances.
Last question, Senator.
And is the need for this because it seems to me there's a little misunderstanding about the nature of faith. I've been quoting St Thomas Aquinas today. The reality is that if you are a person of faith, and let's talk about somebody in an aged care setting, that faith isn't something you just do on Shabbat or at a key event, that it's absolutely, totally enmeshed with your life. And that might not be the case for all Jewish people who might associate without practising the faith. But for those who do practice the faith, that it's part of every moment of every day of gardening and reading and food and observance and gathering. So the protection is not just for an individual then, it's for a community who seek to manifest their faith in a particular way. And that matters in this piece of legislation.
Absolutely. And being Jewish is not just something you can compartmentalise off as part of who you are. It really is seen as a whole of person identity. And like other religions, it's not just an optional belief system, it's a way of life for those who are religiously observant. So it means that it's a much more fundamental part of identity than other attributes that might be protected by the law at the moment against discrimination. People who are religiously observant, and this doesn't just apply to Judaism, it applies across the board, will see their religion as going to their very nature as a human being. It goes to something that affects their immortal soul, and therefore even more important than their physical body. So I don't think that's a well understood aspect of religious identity, but it's certainly important for our community. And I think it's important for others as well.
Thank you very much.
Thank you very much, Senator O'Neill. Senator Pratt, just a couple of minutes, Senator Pratt, whereas we're trying to share the call around equally.
Thank you very much, Chair. I wanted to ask, in the context of your views about vilification, you've expressed confidence in the protection of prevention of vilification in the bill. But some of that vilification historically has been asserted very much on the basis of a religious belief and a religious doctrine and the statements within various religious scriptures. Where do you believe the line is drawn on what is vilification versus what is a statement of religious belief and doctrine when it comes to statements about marriage, Jews, or a range of other attributes that might come up in the context of this bill?
Well, it's a little different for the Jewish community because, as Dr. Rubenstein said earlier, Jewish people are both a community and an ethnic community, so we have that dual identity. The only other community that has been recognised as having similarly dual identity is the Sikh community. So as far as the Jewish community is concerned, there is already protection in the Racial Discrimination Act, both Part 2 and Part 2A. And so the additional protections that will emerge under this particular bill really will just be a supplement to that as far as the Jewish community is concerned, but will be very important for other religious communities.
And what about non-religious communities as well?
Indeed. Well, again, if you're talking about Clause 12 and the statements of belief provision, there are very clear limitations to the applicability of that clause. And we've discussed that in some detail in our written submission. I don't want to repeat all that because it would take a lot of time, but essentially we believe that the band of statements that are not currently, the bandwidth of the statements that would be protected by this bill that are currently unlawful is very narrow.
Well, I guess I'm trying to work that out because I'm not clear about what those statements are. So the bill seeks to override the Tasmanian Section 17. And in that context, one of the cases that's been discussed this morning is messing with marriage, messing with kids. And, the Catholic Church regrets that statement. But does that therefore mean that it's a doctrinal statement or it's a vilifying statement? And I'm interested in this debate in the context of how the Jewish community might be affected by similar type statements that have a doctrinal basis or a basis in scripture, as to the extent they might be justified by or their positioning within the law.
Okay, well, this bill will not in any way impact one way or the other on people simply quoting their scriptures, and nor should it in our view. And people within a particular faith community will take different views and have different interpretations about particular scriptural texts. But in terms of simply quoting their scriptures, this bill will not impact one way or the other on that. As far as the Tasmanian Anti-Discrimination Act is concerned, and Section 17 in particular, as we see it, this is a provision that is very broad. It's not paralleled by other provisions, as far as I know, anywhere else in Australia. It allows, it would proscribe or prohibit, I should say, statements that might offend and insult on the basis of religion. And the Bishop Porteous case of some years ago was a particular example where a complaint was brought under that section, but subsequently withdrawn. Now, as I understand the bill, it would simply have the effect of preventing such a complaint, which was withdrawn in any event, from having been brought in the first place. That will be its principal effect, and I think that's what it's intended to do. So that there's
But surely this is where it does get more complicated.
Last question, Senator
There
Pratt.
might be some cases in the context of the Tasmania that don't come about because of that override. But if it does invoke vilification, as could be argued about some of those statements, then they might nevertheless end up before the courts. But nevertheless, people seem to be stating that a statement like messing with marriage is messing with kids is a doctrinal statement that should be protected. And I am very much trying to distinguish whether, would it be qualify as vilification under the Commonwealth law, or would it be a protected statement as per this bill? And what happens when Jewish communities are subject to similar statements? Perhaps I might ask Mr. Rubenstein to give his views on that.
Well, there's no definitive answer here, but I think it's important to point out that the statements have to be made really in good faith, represent a reasonable belief, not be malicious. And, at the end of the day, it'll be up to the courts to actually decide where the line is drawn. But of course, there is a tension there that you draw attention to quite correctly.
Isn't that what happens in Tasmania already?
Beg your pardon?
Is that not what the Tasmanian law and the Commonwealth law and all laws should do?
Well, look, I don't think this will override existing law, the Racial Discrimination Act. And it'll be up, at the end of the day, it's going to be up to others and the courts to decide where the line is to be drawn.
Senator Pratt, we will need to leave it there.
Thank
I'm
you.
now just going to move to Senator Rice for one quick question and then to Senator Bragg.
Yes,
Senator Rice.
And really it's a follow-up, and perhaps, look, I'm happy for you to take it on notice. I mean, basically we're all incredibly concerned about the rising incidence of anti-Semitism. And my concern is anti-Semitism that doesn't meet that threshold of being malicious, harassing, threatening, intimidating and vilifying, or doesn't amount to the urging of a serious criminal offence. I mean, the Public Interest Advocacy Centre, in their submission, they noted that this bill also allows for demeaning and derogatory statements against people of minority faiths. Jewish people, Muslim people, Hindus, Buddhists, atheists and agnostics may all be subject to harmful religiously motivated comments on the basis of who they are. And they noted that these statements probably previously would have been prohibited under state and territory anti-discrimination laws. And they use an example in the Jewish context of a Jewish person at a cafe who is told while chatting with the waiter that they are responsible for killing Jesus. So I really am interested to know how effective this bill is actually going to be. And to me, it seems it's going to be counterproductive because it overrides those state and territory legislation and will actually allow more anti-Semitic statements in the name of other faiths.
So, Senator Rice, it will not override state and territory anti-vilification legislation. Let's be very clear. Except for Section 17 of the ADA, of the Tasmanian Anti-Discrimination Act, it will not override current anti-vilification provisions of state, territory and Commonwealth laws. Okay, I think that is made very clear. What it says is that a statement of belief will not constitute discrimination under those laws. It does not say that it cannot constitute vilification under those laws. And the explanatory memorandum makes that explicit. So I think, and in the example you gave about somebody in a cafe being told by an employee, Jews kill Jesus, just out of the blue, first of all, it'd be very hard not to say that wasn't malicious. And secondly, it would quite probably be covered by Part 2A, the Racial Discrimination Act, which is not ousted by this bill. So as far as the Jewish community is concerned, I think whilst we appreciate the concerns of others, they haven't really accurately expressed, in our view, what the current legal position is and what the impact of the bill on the current legal position would be. And more broadly, when you consider Article 18, paragraph 3 of the International Covenant on Civil and Political Rights, which says that freedom of religion as an aspect of freedom of conscience is fundamental and therefore should only be limited to the extent that it impacts on the fundamental rights of others. And then you go to the Syracuse principles as to what is meant by fundamental rights. I don't think kind of low-level denigration of the kind that you're talking about and protection against that, as important as it is, would constitute a fundamental right that would justify overriding freedom of religion. So I think these are the sorts of considerations that your committee needs to weigh up, and by reference to those particular instruments as recommended by the Ruddock Review.
All right, thank you very much, Senator Rice. Senator Bragg.
Thanks, Chair. Just two quick questions. Firstly, in relation to the statement of belief, is that something that you have asked to be included in this bill?
It was not a primary concern of our community. It was not something we specifically requested included, but given that it is of major concern to other faith communities, we can see the importance of it, and the importance of freedom of religion in Australia, and we can see also how that is being eroded as a greater proportion of Australians tick the no religion box in the census. We thought that the inclusion of that provision is certainly not something we would object to, given the very clear limitations on its operation that are set out in the bill.
Okay. Second question is just in relation to schools. Am I able to ask you questions about Jewish schools? Yep?
Yes.
Okay. What is the status with same-sex attracted students and teachers in Jewish schools?
They're treated the same as everybody else. To my knowledge, there have been teachers, even principals of Orthodox Jewish schools, and certainly students who reflect the full diversity of contemporary Australia in every respect. So it's not an issue for those schools, to my knowledge.
Okay, so you wouldn't have any problem with the removal of the exemptions which allow other schools to discriminate against same-sex attracted teachers and students?
Well, if you're referring to subsection 38(3) of the Sex Discrimination Act, no, we don't have a position specifically on that. That is a matter that's been referred to the Australian Law Reform Commission, and of course we'd like to see its discussion of the issue before committing ourselves. However, as discussed at pages 8 and 9 of our submission, Senator, we do believe that religious bodies should be as free as any other types of organisation to require their staff, students or others associated with the organisation to conduct themselves in public in a way that does not repudiate the stated beliefs and values of the organisation. And we don't think that that requirement should be construed or misconstrued as a potential form of indirect discrimination.
Okay, so final question, Chair. So just confirming that a gay teacher or gay student will not be removed from a Jewish school because they are gay?
No.
Thank you.
Thank you very much, Senator Bragg, and I'd like to thank the Executive Council of Australian Jewry and the Australia, Israel and Jewish Affairs Council for your time and for your evidence today and for your considerable work in your submissions. Thank you. Thank you all very much.
Thank you,
Notice,
Senator.
in particular in response to submissions from the Human Rights Commission.
Senator O'Neill, you're just indicating questions on notice?
Yes. So, yes, more with regard to the Human Rights Commission, particularly where they speak about the effect on their organisation of an amendment in 2017 to deal with complaints that might be relevant in terms of any response you give to the questions from Senator Rice about Section 17 in Tasmania, noting their points 84, 85 and 86, essentially indicating that complaints can't be prevented, but that legislation has assisted them in weeding out frivolous or vexatious complaints.
Thank you very much, Senator
Thank you,
O'Neill. If you need to clarify that question any further, you can do so in writing. I thank you again to our witnesses for your time this afternoon. I'd now like to welcome representatives of the Australian National Imams Council. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 144. Please let me know if you wish to make any corrections to your submission. If you don't, I will ask for the Hansard record, would you please state your full name and the capacity in which you appear today?
Yes, thank you. My full name is Bilal Rauf, R-A-U-F, and I appear today as the spokesperson and advisor for the Australian National Imams Council.
Thank you very much, Mr Rauf. Do you wish to make a 1-minute opening statement?
Look, very briefly, if I could, yes, thank you. We made our submissions and highlighted some of the contextual and specific matters in that submission. The Australian National Imams Council really has been at the forefront in our community in terms of emphasising the importance of addressing what is a very fundamental deficiency in the legislative regime. And in saying that, we have the situation we are confronted with, to put it in context, is that certainly post the Christchurch situation, there has been a heightened anxiety amongst a lot of Australian Muslims nationally. And in addressing some of that anxiety, one of the issues that we've been closely dealing with also is in terms of the legislative regime. Now, we've had various interactions both at state level and federal level, and really coming to the federal level, the issue there is about the complete absence of any protection in relation to religion that certain other communities, I think, have the benefit of ethno-religious at state or other state, but in New South Wales...
Mr Rauf, I'm so sorry, but we'll have to just leave your opening statement at that. I'm trying to keep to a 1 minute for all witnesses. We're now going to go to questions, and of course you can elaborate on what you wanted to say in your response. Look, I just wanted to kick off by asking you, in your submission you claim there has been a growing trend of Islamophobic incidents. Can you elaborate on this further, and what difference would this bill or these bills make?
Yes, of course. We've referred to a couple of reports. There is, of course, the report by Charles Sturt University, which has tracked various instances over many years of Islamophobia or anti-Muslim sentiment, and coupled with the increasing or rising tide of the white supremacist right-wing ideology and the instances of that online. So certainly there's some data which is reflected in more detail in those reports, which are referenced in our submission. Anecdotally, of course, in terms of the Australian National Imams Council, we have an engagement at the grassroots level, and just to give some explanation, the Imams Council is really a body that represents and is comprised of the various Islamic imams, clerics, scholars across the country. And each of those have their respective congregations, which can number from the hundreds to the thousands. And through that, it's given us the opportunity to really engage at a grassroots level with the congregants and understand the issues and the concerns. And of course, the Imams Council is also broadening the assistance it's providing through various other services. And through that channel as well, we've really received reports and concerns about increasing mistreatment, whether it's in the workplace, whether it's in other public places. And more so because I think one of the critical things with the Australian Muslim community is that a lot of Australian Muslims are distinguished by what they wear. Now, whether that's women wearing the veil, it's very obvious, it's apparent. A lot of men, for instance, who may wear the beard, who may wear the cap, and who may, during Fridays, want to attend the mandatory congregational prayer. So by what they do, by the way they look without even opening their mouth, they are readily apparent. And that really, in an environment where there has been a growing animosity or a certain view of Islam or Muslims, the recipients of vilification or discriminatory conduct tend to be particularly those who manifest their faith by what they wear. And one of the examples that we've drawn from the report by the Charles Sturt University in terms of case studies, and that's in the appendix to our submission. But one of those, for instance, is of a woman who, while working, decided to adopt the veil, and as a consequence of that, was told in no uncertain terms that, look, that wouldn't be something which should be all that welcome or appreciated in that particular workplace in a retail setting. So these are issues which are very much at the forefront. And in circumstances where there is an absence of any protective laws at a federal level. So we're grappling with that in addressing or serving our community. We are constantly asked, well, what's happening? What are you doing about that? And as it stands in 2022, the answer is, well, there's nothing really to reflect any change. And so we do think that this bill, while it doesn't go all the way, it is a significant and important step, at least, in addressing what is the gap that I adverted to in my opening statement.
Thank you very much. I'm now in the time remaining, and we've just got to, if I could just ask you to keep your answers fairly truncated, because we're under enormous time pressure. I'll go to, no, that's okay. I'll go to Senator Scarr for a couple of minutes. Senator Scarr.
Yeah, thank you, Chair, and I'll try and be as quickly as quick as I can as possible. Mr. Ruff, thank you very much for appearing today. I'd like to ask you about the need for a reasonable adjustments clause, because this is a matter which has been raised by other witnesses in front of this committee today. The need that an employee's genuine religious beliefs should be reasonably accommodated for in terms like rostering, if that's reasonable for the business to achieve. Can you just outline the importance of that in terms of your community, please?
Yes, of course. Look, as I mentioned, Senator, at the outset, the issue of religious activity is particularly important with the way Australian Muslims may conduct themselves. So, two immediate examples that are commonplace are, for instance, on a Friday for men, it's mandatory that they attend a congregational prayer. I do that on Fridays, and it takes about half an hour. But in certain workplaces, there's an issue as to being able to do that, the time it might take, or the flexibility around breaks, etc. So it's really enabling that dialogue or discussion to occur, such that if an employer is going to refuse, there is a rational and operational or proper basis to that, but otherwise there is an attempt to accommodate. Similarly, in the context of women, for instance, who may want to wear the veil, that they have the freedom to make that decision. And it's one thing if there are safety or other implications. And again, the onus, as is the case with the other discrimination, the suite of legislation at the Commonwealth level, there is the onus on the employer to demonstrate that they've sought to accommodate, but for some acceptable reason couldn't, safety, operational, etc. And similarly, operating in respect of other manifestations of religious activity, which are very integral to Australian Muslims.
So that second half of your answer is really speaking to the burden of proof question. If an employer imposes a safety requirement that may have an impact on a person's religious garments, then the onus of demonstrating the necessity or reasonableness of that requirement should be on the employer, as opposed to the individual employee, who's obviously in a less powerful position and less able to disprove the case than the employer to prove the necessity. Is that correct?
That is correct, and that would really be consistent with what is the existing approach across the other legislation, such that the onus is on the employer, including in response to claims of indirect discrimination.
Yeah, and then the last question I have, because I need to share the call, is in relation to vilification, and you provide in the submission some disturbing case studies which In fact, at least one of them I can recollect discussion in the Australian Senate with respect to the appalling episode. From your perspective, from the community's perspective, there's a definition of vilify, what it means to vilify in the bill, and that could be used as the basis for a clause which specifically prohibits vilification on the basis of religion. Is that correct?
That's right, and it's really trying to find a way within the existing regime so as to avoid some of the complexities and the political debates around a provision such as 18C, moving away from that, and because the focus here is really safety orientated. It's the well-being, it's safety, it's not just stifling debate. So the definition of vilification in this bill is set at a sufficiently high level that it really does focus in on the safety and well-being considerations rather than stifling debate or any issue like that. So we thought that that would be an appropriate and readily available approach.
Okay, thank you very much. Thank you, Chair.
Thank you very much, Senator Scarr. Senator Rice.
Thanks, Chair. Look, thank you for appearing before us today. I want to continue with some questions about Section 18C, and I want to clarify the position of the Australian Imams Council. So you're supportive of the protection provided by Section 18C of the Racial Discrimination Act?
In concept, yes, we are, but noting that that doesn't have any work to do in relation to Australian Muslims as it presently stands. It has no application.
Okay, and did you oppose the previous Liberal Party's attempts to remove that clause?
We did express concern, yes.
Yeah, and so you wouldn't be supportive of attempts to remove it in the future? Well,
the 18C, so that's really focused on racial discrimination, and we see that it has work to do, but of course, accepting that it's not something which Australian Muslims have the benefit of as it presently stands, given the legislative context. But ideally, it would be good to pick that up in the context of religious discrimination. But given all of the varying debate and the political differences around that provision, and to really avoid that and simplify things, hence, we've taken a different approach, trying to be a bit more pragmatic and balanced and to avoid the ideological issues that have attached to 18C. But that's not to say that we don't support 18C. It's just that Australian Muslims don't have the benefit of it. And secondly, to import it here, well, as it seems, there seems to be a lot of opposition to aspects of this bill. The last thing we want to do is introduce yet a further hurdle in circumstances where people of minority faith need this protection, because federally there is none, and there hasn't been.
And I think there's agreement across the board that in terms of protecting the rights of people to have their religion is something that is a gap in our federal anti-discrimination law that needs to be fixed. There's just a lot of controversy as to whether the way the government's going about it is the best way of doing that. Just finally, sorry?
Which Australian Muslims are feeling the brunt of in terms of not having any relevant protection federally.
Absolutely, absolutely. And the rising Islamophobia is of huge concern. Just my final question on 18C. I mean, do you think, that given what you've said on 18C, are you supportive of the Minister having the power to override 18C without requiring a change to the law, so being able to override it through regulation?
Look, we don't really have a position on that, in that we haven't focused our attention on 18C, and because it has no work to do for Australian Muslims, it's not something that we've deeply considered, I must confess. So we don't really have a position as to that question, Senator.
All right. Look, I want to take you to the concern that I have, and it's the same discussion that I was just raising with the Jewish community in the potential for this legislation, through overriding state and territory legislation in particular, but allowing for demeaning and derogatory statements, Islamophobic statements against people of minority faiths. And the Public Interest Advocacy Centre, for example, they summarise it as saying that Jewish people, Muslim people, Hindus, Buddhists, atheists and agnostics all may be subjected to harmful religiously motivated comments on the basis of who they are, where these comments which under state and territory legislation would be considered discrimination. They don't meet the threshold under this legislation of being malicious or harassing or threatening, intimidating or vilifying, and don't amount to the urging of a serious criminal offence. So I'm interested in your response to the concern about allowing Islamophobic statements couched in religious terms that this bill actually, through those overriding provisions in particular, allow.
Yes, I understand your concern. I think, can I approach it in this way, that the greatest source of the concern for us are, as we saw with the manifesto by Tarrant, statements coming from that angle and from those perspectives, which is more real and which is more actually occurring and is widespread online, and hence trying to find some protection against vilification in this bill. In terms of the broader override, look, it's not something which does, at a pragmatic level, has presented as a significant nor a real concern for us, in that, when I say us, Australian Muslims, in that, again, it's not something that has readily been experienced. And I think, if anything, what we're seeing is there is a growing, I think, mutual respect and working together between communities of faith. And so we take some confidence in that. The concern is really in terms of right-wing and other sources where those comments are readily coming. So, look, I'm not sure whether it doesn't directly answer your question, but I think it's not, we don't necessarily share that concern to the level that's been expressed.
Okay. Look, clearly from the hearings we've heard so far and from the submissions, there's a huge amount of controversy.
Just 1 minute, Senator Rice.
Across, from the Human Rights Commission, the Australian Industry Group, the ACTU, the Law Council, would the Imams Council be supportive of more straightforward orthodox legislation, as has been described, that would actually still protect religion as a protected attribute without all of the problematic, unorthodox elements of this bill?
The concern that we have is this, that it's taken this long, how many of a decade that is, to get to this point. And we have a real reservation that if we now throw the baby out with the bathwater, it may take another 10, 20, 30, God knows how many years, before we can get that orthodox legislation. That we haven't got anywhere near that orthodox legislation to this point in time in 2022. And here's something on the table. We want to take it. We want the benefit of it. Minority faith communities, based on our interactions, want the benefit of it. If that goes off the table, we are left again with nothing as we started.
Thank you very much, Senator Rice. Senator O'Neill.
Thank you very much, and thank you for your submission, Mr. Ralph, and for attending in the middle of what many people still feel is the holiday period. So,
thank you.
I just want to ask one quick question with regard to section 38.3, which has been the subject of some discussion. There has been reported on the 1st of December that there was a deal made with the Attorney-General, assuming that she was acting on behalf of the Prime Minister, a deal made with members Katie Allen, Dave Sharma, Fiona Martin and Angie Bell to make an adjustment to 38.3. Do you have any insight from members of the government, the Attorney-General, the Prime Minister or their officers, whether such a deal existed or does exist?
I must confess I'm not aware of that.
And you've had no communication with either the Prime Minister's office or the Attorney-General with regard to 38.3?
Yes. Are you able to just give me some indication of what that was? It might...
Oh, that's the Sex Discrimination Act and how it interacts with that with regard to taking out part of 38.3 to make sure that schools could not remove students who are gender fluid or discovering their sexuality in a way that might not align with the views of the particular school. That's that matter.
Yes. Look, thank you for that. That does give me some recollection. Look, I think there may have been some broad, high-level discussions. It's not something that I can specifically recall now, but I do remember something along those lines being mentioned in one of the various discussions that we did have.
So can I ask you to take it on notice and refer to your notes, Mr Ralph,
Sure.
because I'm keen to get to the truth of the matter, if there was a deal or no deal, and what the current status of that is, because there are varying reports amongst members of the government. Could I also... we'll send that to you on notice. We'll send that to you.
Yeah, okay. Yeah, I'm not aware of any deal though, so, or there wasn't any discussion of deals, but just more the broader concept.
Thank you. So I know Senator Scars explored the reasonable adjustments with you. Can I just go to your submission
Yes.
with regard to the practicalities of discrimination? You cited research, and it's also been cited by the Australian Catholic Bishops, headed by Dr Derya Inna on Islamophobia in Australia, reporting 349 verified incidents of discrimination, harassment and violence against Muslims in the two-year period 2016 to 17. And that report found that 72% of the victims of anti-Muslim attacks were women. Is that correct? And do you have any further data that you can put on the record today so that we get the sense of the importance of this legislation?
Yes, look, that's a very conservative figure. The reality is that there are many who, due to a lack of confidence or a belief that there is any appropriate recourse, simply don't raise it. So what we've got is a very conservative indication. And certainly on the discussions that we've had, as I say, amongst the grassroots and amongst members of the community who don't wish to really pursue it further because they don't see what might come of it, it's far greater. And the bulk of those are women.
Look, any further evidence you can provide would be helpful. And I do note in particular words their belief of a lack of recourse, and that takes me to sections 11 and 12, clauses 11 and 12 in this bill, which have been the subject of considerable discussion. I don't think there's any disagreement amongst those who've presented, either in writing or in person or via video conference to the committee, that there is a need to fulfil Australia's responsibilities and introduce a bill that protects against religious discrimination. But given the concerns that exist already about a lack of recourse and the considerable debate about the application of Section 109 of the Constitution to provide a head of power under which the states could be rendered inoperative, state law could be rendered inoperative by the government, federal government's action. Could I ask you to take on notice, because it's quite detailed, a review of the evidence of Professor Aroney to this committee and how that interacts with the concerns that I think are very clearly articulated in the evidence provided in submission 47 to the PJCHR from Professor Toomey. And I'd be very keen to get your view of those clauses, Clause 11 and Clause 12 amendments that are put forward by Professor Aroney to try and avoid years and years of litigation till things are settled, because your community clearly needs a much more timely recourse to justice.
Yes, that's true. Yes. I'll certainly do that. Thank you.
Thank you. Now, with regard to discrimination at the job interview, you put case 22018, which describes a chilling reality that I think fair-minded Australians would find appalling. My 16-year-old had his first job interview with unnamed company as an apprentice boilermaker. The company is at a place somewhere in Preston's. The interviewer was a certain person who is the managing director. On the application form there was a question of religion, to which my son put Muslim. I was under the impression that this was illegal to ask, but I could be wrong. He walked into the interview room and Ron yells at him, "Muslim, you're a Muslim. Don't think you can work here and pray all day?" My son politely said, "My prayers take me 5 minutes." There was no job description given to my son, no hours, no tour of the factory, nothing. I am putting in an application to the Anti-Discrimination Board. My 16-year-old was left broken-hearted, was shattered into a million pieces. We are both Australian born and raised, but this man couldn't see past our religion. I think that describes pretty clearly a problem that needs a response. But one of the concerns that is expressed by people who are opposing this legislation is that religion should be kept private. that prayers shouldn't be said in a public place, in a workplace, that people who voted against the marriage equality plebiscite in Western Sydney, who are of the Islamic faith, who continue to hold a traditional view of marriage that it is between a man and a woman, should not be allowed to speak that in their workplaces. That's kind of really where the heart of the problem is. Could you speak to the reality of being a person of Islamic faith with regard to those things, the workplace, dress, observance, the holding of a belief about marriage that is traditional? What's it like for Islamic people, and what do we need to do to make sure we redress that problem?
Of course. No, thank you for that. And it's a very important question. I think the objection that's been raised, it really misunderstands the inherent aspect of the religious belief and identity to people of faith. The female who opts to wear the hijab can't just simply take it off. The religion just can't be pigeonholed to the home or some room in the home, in the same way that, for instance, we saw last week, Usman Khwaja in his celebrations was concerned about being drenched in alcohol and stepped away from the stage because that's a critical aspect of his belief. Australian Muslims don't drink alcohol, and the last thing we want to do is be drowned in it. Now, on that objection, well, bad luck, he should have stayed on the stage and just copped it. Well, no, it's about our country is about inclusivity, diversity, and respecting these various attributes in the same way that in our submission we highlight there is a very long list of attributes that are protected, which are critical, no doubt, to all those people, be it breastfeeding, be it parental care or whatever it might be, race, etc. Religion is one of those, and for Australian Muslims and indeed people of faith, it is a very fundamental and inherent aspect of their humanity, who they are, how they identify themselves. They can't just simply pigeonhole it, put it to one side in the same way that someone of race can't put their race or culture to one side, or the female that chooses to breastfeed can't put that to one side. It is very important, and the objection really misunderstands that issue.
So there is an ill that needs redress. It needs to be done promptly, and it needs to be done in a way that is practicable and able to be implemented quite hastily for the protection of your community. Is that correct? Certainly, that's our submission in respect of this bill, and generally in terms of having that relevant protection, yes.
Thanks, Senator O'Neill. And Mr Ralph, thank you so much for your time and for your evidence today. It is very much appreciated.
My privilege. Thank you.
I would now like to welcome representatives of the Australian Muslim Advocacy Network. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received the Australian Muslim Advocacy Network submission as submission 122. Please indicate if you wish to make any correction to your submission. If you don't, please, for the Hansard record, would you state your full name and the capacity in which you appear today?
Good afternoon. No corrections are needed. My name is Rita Jabri Markwell, and I'm advising the Australian Muslim Advocacy Network.
Ms Markwell, thank you so much, and again, welcome. Would you like to make a brief 1-minute opening statement?
Sure. So the Australian Muslim Advocacy Network has been very active, particularly since the time of the Christchurch massacre, to try and deal with the roots of what caused that massacre in the first place. So we do a lot of engagement with industry, Facebook and Twitter mainly. We do research, we develop policy, do the space of policy dialogue. We engage internationally and nationally in that space. And as a result, we are very, very committed to having religious discrimination legislation. It's absolutely necessary and urgent, I'd say urgently needed, to prevent another Christchurch happening. And our submission in particular has 3 amendment proposals contained in it for this particular legislation before us. One is to introduce a vilification protection that the previous witness just referred to.
Ms Markwell, apologies, I'm going to need to leave it there because we're trying to stay strictly to 1 minute. we are running a very tight ship today. I'm now going to move to questions, and I will firstly go to Senator Scarr.
Thank you, Chair, and welcome, Ms Markwell, and thank you for all the work you've been doing in the community to especially bring to light this issue of vilification and how it impacts members of our Muslim community who are a dear part of our Australian community. So I'd like to give you an opportunity, I guess, in the first instance, just to amplify the 3 points that you're keen to draw out in terms of this testimony. So the first is, from your perspective, this bill provides an opportunity for an anti-vilification clause to be inserted to protect adherence to the Muslim faith. Could you please explain why that's so important from your perspective?
At the moment, there is legal uncertainty in Australia about whether Muslims are protected at a national level. This sends a huge amount of uncertainty to social media companies and to the public. This has been exploited by anti-Islam and anti-Muslim protest movements, which are the predominant force behind the growth of neo-Nazi and white supremacist movements in Australia, which has been recorded in research contained in our submission. It is absolutely critical and urgent that we close this gap, this legal gap, and we support the wording which my colleague Bilal Ralph Anik just mentioned before about just mirroring that standard of vilification that's already in this bill and just extending it both ways. So we aren't required as people of faith to vilify, we are required to not vilify people, and we just also have that protection of not being vilified. It's very straightforward, and it would do a huge service to the public interest.
And from your perspective, this is really a time-critical proposed amendment. It really is critical at this point in time, given the increase in acts of Islamophobia, given the appalling events that occurred in Christchurch. It's absolutely time-critical that this be considered by the Australian Parliament at this point in time. Is that correct?
Yes, I really think it's incumbent upon the Australian Parliament to do everything within its power following Christchurch, to do everything in its power to say, you know, hand on heart, we have done everything to send the signal that this is unacceptable. Inciting hatred against a group of people because of their religious beliefs is unacceptable. If we can just do that, I mean, I feel we'll be a lot more confident that we have set the right signals out there to the public. We've set the standard.
Okay. And just my final question, Chair, and I just want to provide you, Ms Markwell, you said there were 3 proposed changes that were the subject of your submission. We've spoken about the anti-vilification proposal. What are the other 2 areas where you would like this committee to consider amendments?
Thank you. Second thing is we would like a note inserted under Section 18C of the Racial Discrimination Act that persons who are making complaints because they are vilified on the basis of their religious belief or activity are not excluded from making a complaint under Section 18C. And this is really recognising that although 18C may not provide us with proper coverage or full coverage, that it does have some scope to provide us with protection, especially when there are racial undertones to the vilification. But we just need that clarity to the Australian Human Rights Commission that they can still accept those complaints. And I would just like that amendment made in the I think it's a supplementary bill, the Human Rights Legislation Bill, which makes amendments to a range of different acts, including the Racial Discrimination Act. So we would just like that clarification made there. The third thing is really...
Sorry, and just to interrupt you there, the real live example you gave, we know there's been a change in regime in Afghanistan. A lot of people have come to this country seeking refuge, and that's been extraordinarily important. And there can be nuances as to whether or not, say, someone who's come from Afghanistan and is subject to some vile comment can take action under 18C or not, depending upon whether or not particular adjectives are used with a connection with their place of origin. Is that an example of the sort of issue you're seeking to address?
Yes, thank you for highlighting that example. If we could, the point of this clarification is not to change the text of 18C. It's not to change 18C. It's actually allowing people of faith to use 18C. They still need to the test of 18C as set up by all our authorities, but it's not precluding them from using it. Just in case there is a situation where, for example, an Afghan woman who wears a veil, she's called a terrorist, and there is a question mark, well, is that because she's Muslim or because she's Afghan? There are a lot of situations where it is blurred.
And whatever the basis, it's beside the point, isn't it? And lastly, the third amendment you're proposing?
That is the removal of section 37, subsection 2, which gives the powers to, it says that actions by national security or by law enforcement under the guise of national security can discriminate on the basis of religion where reasonably necessary. We believe this clause could be sending the opposite signal to what we need to be sending to law enforcement. The latest survey by the Australian Human Rights Commission of the Muslim community found 50% of respondents experienced discrimination with law enforcement. Unfortunately, it's a reality because of the way that counterterrorism laws are framed. And we shouldn't be enshrining and encouraging that discrimination to continue. We should be sending the opposite signal. And we would argue that the subsection clauses that are just above and below it give adequate protection to the government to take actions as conferred by statute without being challenged under discrimination laws. But this particular subclause 2, goes even further to acts that not even under statute, but just any action, if it's claimed to be for national security and is reasonably necessary, it empowers agencies to directly discriminate on the basis of religious belief or activity. And we think that is sending a very, very toxic signal to the Australian Muslim community. We should actually be just judging all terror threats based on the risk of violence, the risk to security, the risk of ideological radicalisation, violent ideology. That is the way to, apply our laws in a non-discriminatory manner and encourage a non-discriminatory approach by law enforcement.
Senator Scarr, thank you so much. We'll have to leave it there and move very quickly to Senator Bragg, who just has one question.
Thanks, Chair. Just quickly, I just wanted to ask you whether you have any issues or any concerns about the Tasmanian law being lost, and I'm referring to Section 17(1) of the Tasmanian Anti-Discrimination Act, which prohibits conduct which offends, humiliates, intimidates, insults, ridicules, etc. As part of this process. Do you have a view on that?
I would echo the comments of Bilal Ralph before me that religious-based Islamophobic comments are not the bulk of the concern that we are facing. We are facing, it's more ideological types of vilification which are our concern. So as in based on violent ideologies and demographic invasion theory, that sort of thing. But Aman's submission did raise, I suppose, some questions or queries about Section 12 in the sense that we were questioning whether it may be more harmonious to refer to the vilification standard that applies in the legislation that is the home of the complaint, the origin of the complaint, as opposed to imposing a new standard of vilification. But we didn't have a solid recommendation on that. We understand that it does cause anxiety doing overrides or excisions of discrimination law. It's a big step. And from a public policy point of view, we are, sympathetic to the idea that it would cause stress in the community having such a big sort of override.
Thank you, Senator Bragg. To Senator Ciccone.
Thanks, Chair. And it just follows on from Senator Bragg's question. So there's no specific recommendations. Is there a particular reason why there's no specific recommendations on that section 12? Like, do you share the concerns, I guess, from some of the witnesses from earlier today, around, in particular the Law Council, describing as procedurally unworkable?
I'm not sure it'd be procedurally unworkable, but it certainly adds some complexity to the to litigate for claimants. So I think the reason we didn't have recommendations is that it is complex, and we don't have enough data. We aren't government to know what is the precise solution for the precise problem. If the problem is there being too many complaints that are putting people of faith under stress, too many discrimination complaints, then it would be good to see the data on that, and then to try and resolve that problem as precisely as possible. But we don't have enough information. That's why we didn't make recommendations.
That's fair enough. And look, just one other last question, Chair. Is there a better way, a more procedurally workable way, in your opinion, of reassuring people of faith that the expression of what the bill describes as moderately expressed religious views will not breach Australian law?
I think the more important thing is to protect people of faith from being vilified online. We should be able to exist and express ourselves as people of faith without the fear of intimidation and endangerment. So that is why we are pushing for this vilification clause, and it's quite surprising to us that it hasn't been in there yet, but we think that it is completely consistent with the government's position and other parties' positions to include it. I don't have any further comment on the question you asked me about is there anything procedurally we can do specifically, except to say that our laws already include summary dismissal options for discrimination complaints. I'm not sure how effective they are. Again, that is a question about availability of data.
Thank you very much. I'll leave it there, Chair.
Thank you very much, Senator Ciccone. Senator Rice.
Thank you, and thanks, Ms Markwell, for your work and the work of the Muslim Advocacy Network for highlighting the real huge problems of Islamophobia in Australia today, and for your suggestions of strengthening and Section 18C of the Racial Discrimination Act so that it actually did cover Muslim people. I presume that given that you want to strengthen 18C, you'd have concerns which have been raised that this bill actually would give the Minister the power to override Section 18C without requiring a change to the legislation.
Thank you. I just want to clarify that our amendment is to add a note to Section 18C. It's not to strengthen or necessarily change the basis of 18C at all. It's just to make sure that we have access to making complaints under Section 18C. In relation to your second question,
sorry, can I just clarify? I assume that means...
Sorry, just for everyone's benefit, Senator Pratt has just seeking a clarification.
Ask for clarification. You said you want to retain 18C as it is, but Senator Rice's question was, are you therefore concerned about the potential override of 18C, which would not leave it as it is, leaves the potential for that override to happen?
Yes, I was just about to address.
Yeah,
I was addressing. There was a comment that our proposal was strengthening Section 18C, and I just wanted to clarify that on the record. So we, in response to Senator Rice's question, I don't have anything further to add based off our submission. We did raise queries about the stress that an override place on certain communities if they feel that they are being indirectly targeted by Section 12. We highlighted the impact of the suspension of the Racial Discrimination Act in the Northern Territory emergency response and the effect that that had on Indigenous peoples over a decade ago. There are public policy signals that probably should be considered, but again, it's a complex issue and we don't have enough expertise to come up with solid recommendations on how to deal with this.
Thank you. I suppose it goes to the point of there's a clear need for changes to our federal law to protect people of faith from discrimination, which would, tackle the ability for people to discriminate against Muslim people now and not protected under federal law. But this bill has it's got a huge amount of controversy about it. It's not supported by the Australian Human Rights Council. It's not supported by the Law Council. It's not supported by the ACTU, the Australian Industry Group. We've got a huge amount of conflicting legal advice, and essentially we summarise that we're going to end up with a lawyer's picnic and cases in the courts, probably for the next decade. Given all of that, would it be the view of your network that we'd be better off going down the track of a much more straightforward, orthodox piece of anti-discrimination legislation that fitted into the suite of other anti-discrimination legislation that we have at the federal level without all of the additional unorthodox bits of this bill?
If you can guarantee that that orthodox piece of legislation would be introduced within the next 12 months, I would say yes.
And certainly it appears from the discussions that we've had with a lot of people that it's a much more straightforward piece of legislation and that would have cross-party support. Do you agree then that would be a better way to go?
I'm not the Australian Parliament. I think it would be a better way to go to go down a path that is not causing angst, but I ultimately, as an advocate on behalf of the Australian Muslim community, I have to say that we desperately need this legislation, and our needs have been put last again and again and again because whatever reason, this legislation is urgent and it needs to be passed. If there are concerns about specific elements, we encourage the Parliament to look at them precisely and to pass the legislation.
Thank you.
Thank you very much, Senator Rice. We are running a bit over time. I'm just now going to give the call to Senator Pratt. I just asked Senator Pratt if you could just keep your questions to about 3 minutes would be really helpful.
Thank you. I just wanted an opportunity to ask representatives of the Buddhist Council of New South Wales.
No, they're not on. They're not. They're the next panel, Senator Pratt. So we're just still dealing with this. We still have the Australian Muslim Advocacy Network.
Them on the screen, so that's fine. I'm happy to.
That's okay. Fantastic. All right. On that basis, I would like to thank the Australian Muslim Advocacy Network for appearing today. Ms. Markwell, thank you so much for your time and for your evidence.
Thank you.
We will now move to the Buddhist Council of New South Wales, the Australian Sangha Association and the Hindu Council of Australia. I welcome representatives. Thank you so much for making the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 18, 56 and 104 respectively. If you don't wish to make any corrections to your submission, then I will ask for the Hansard record. Could you please each state your full name and the capacity in which you appear today?
Patrick Gowan-Powell-Davis. I'm Chair of the Buddhist Council of New South Wales.
My name is Bante Akaliko. I'm a board member of the Buddhist Council of New South Wales.
Venerable Messaji, I'm a committee member for the Australian Sangha Association, the peak body for monks and nuns in Australia.
Thank you very much, all. I would like to invite you to make an opening statement of no more than 1 minute from each organisation, please.
So if I may begin from the Buddhist Council of New South Wales, our submission supported by half a dozen other Buddhist organisations, and speaking particularly from the point of view of a minority religion, many of whose adherents are relatively new in Australia and are establishing themselves within Australian society. We very much support the protection of religious freedom, and we are concerned that the bill the proposed bill doesn't get the balance right between that and some issues of individual protection. Our concerns are, first of all, that there's the potentially to negatively impact minority religions and minority groups through reducing access to employment in religiously based services, particularly where these are government funded, particularly where these are in the bush, where there are not many other opportunities for employment. And we also think that having an entirely monolithic religious perspective within an organisation means that people from other faiths will not have their experience and needs reflected in the way they otherwise would. We're also concerned that the proposed bill could entrench religious discrimination in a secular society. We're concerned that the protection for statements of religious belief can be used to target specific groups. Our understanding is that the protections around this are not clear and sufficiently clear. And also, of course, once the statement is made, the damage is done, whatever happens at law afterwards.
Look, apologies, we will need to stop you there because we are confining our opening statements to 1 minute. So thank you so much for understanding. To the Hindu Council, or Hindu Council next.
Yes. Surinder Jain from Hindu Council of Australia.
Yes, Mr. Jain.
Hi, Hindu Council of Australia represents, it's a federation of Hindu temples around Australia. We have members in every state. We think this religious freedom bill is a good step, but it's going too far. I will echo the same statements that have been said by our Buddhist brother, that this bill may actually reduce religious freedom of minority religions who do not have their own institutions like schools, hospitals, etc. We also think that the bill needs to be modified to keep in mind that we need a harmonious Australia. We do not need people who have never been exposed to somebody from another religion. And this bill might be promoting that. Third, on the religious freedom, we feel that there should be freedom for me to express my religious freedom, to say what my religion is and how it applies to me. But it should stop where somebody else's religion begins. It should stop. I should not be permitted to speak about my religious view of people of other religions.
Well, thank you so much. We will need to leave your opening statement at that point. And now to the Australian Sangha Association, please.
Thank you, Senator. The Australian Sangha Association's position is that human rights for all should in law exceed religious rights. A tolerant, accepting and inclusive society is a common aspiration for all Australians. No one should be subject to coercion or discrimination that would impair their freedom to have a religious belief or indeed have no choice, and in that sense, have no religion. And thirdly, and our last point, is that the legislation should not favour one religion over a minority religion or allow discrimination against a vulnerable group. Thank you for the opportunity to talk.
Thank you so much. We will now go to questions and I will give the call to Senator Pratt.
Thank you very much. I wanted to ask, in that context of the views that you've expressed in your opening statement, is there a better way of capturing within this bill moderately expressed religious views that shouldn't breach the established anti-discrimination rules, that would better accommodate religious expression without one group, without some views being privileged over others? You know, I note, for example, having a protected attribute invokes at least some ability to, well, invokes quite a strong ability to express the attributes attached to that. Thank you. You might need to
someone,
unmute.
yeah. If you could just please turn your microphone on.
I'm concerned that what is regarded as a moderately expressed religious view is an untested area of complexity. And of course, moderately expressed views can still cause a lot of harm. For example, it's quite common for Christians to come up to me on the street and to tell me that I'm going to hell, that I'm following the wrong religion. These are often yelled at me. I've been told in the past that I'm a sinner and that I will rot in hell. So these would be regarded as moderately expressed views, according to this legislation. It doesn't go far enough to protect people from views which are offensive or humiliating. The stronger definition of these protections are found in the Tasmanian legislation. And I think we have to be careful that we don't embolden such horrible comments being said under the guise of religious view. I think there's a lot of opportunity for bad faith actors and people who don't hold a genuine religious view saying comments to people from minority groups or other religions under the guise of a religious view, which can actually cause a lot of harm. And it's worth noting that these kinds of comments are not only religiously held views, but are sometimes forms of verbal abuse or psychological abuse. And hearing these sorts of comments on the street or in homes or on the internet, these are offensive, these are humiliating, and these kinds of comments are not covered by the legislation as it stands. The protections in that legislation are too weak.
Okay, so I want to, that's a really interesting thing to unpack in terms of the extent to which this legislation might protect people from vilification, and I'm very sorry to hear about your appalling experiences. Is there a difference between someone who is of a religious belief who makes those vilifying comments or any other person on the street who might be restrained in doing that because it could constitute discrimination because they're not doing it with a religious foundation?
That is the concern.
You know, it's thoroughly confusing to me in that context that someone who has a doctrinal basis for those statements is privileged in making them where someone else is not. But the extent to which any of them may or may not be vilification versus discrimination is pretty untested.
That's right. It's untested, and it will leave this kind of level of complexity up to, I guess, individuals and perhaps in the courts. And I don't really think we need to clog up the courts with this kind of stuff. It should be clear and simple, easily understood. It should be in line with other legislation, and it should be something that protects people regardless of their faith or lack of faith. We don't want to have a culture or society where people feel emboldened to go up and insult or harass other people, and certainly not humiliate or offend.
May I ask the other witnesses to comment on that? Yes, the Venerable Mataji. I'm sorry if I have not pronounced your title.
Thank you very much, Senator. In terms of looking at the overall bill, you know, there are a couple of terms that really worry us. One is, you know, the term discrimination when this bill started out as religious freedom. And the second one is statements of belief. So in the Buddhist faith, you would choose not to discriminate against anyone. As a Buddhist, you're asked to consider whether your actions would hurt another person or hurt yourself. So when there is the intention potentially in the bill to discriminate against people from a religious stance, we would choose not to do that. Secondly, given the statement of belief is an opinion under a dictionary definition and often may not be challenged with rigorous evidence, the application of, is that statement of belief fair in a court of law when one religion is saying, oh, my peer here said that was reasonable for me to say it, and that's the test that's been applied to this bill. So that's part of the reason that we say we can't support the bill in its current But I'd like to defer to my Hindu friend my friend from the Hindu Council. Surinder?
Yes, please.
The freedom of religion should be limited to me saying what my religion is without any fear of being, being prosecuted for that. But that should not extend to my opinion about others who adhere to a different faith and who have their own rules as to what will happen to them now and after this life. What Bhante said, that kind of discrimination happens on the street. It's very painful. Imagine same thing happening when you're employed by an organization that has a religion and you're hearing it every day. Not only is it a personal humiliation, you also know that my job is also at risk because I'm not being treated as an equal. I'm not being treated based on my competence to do the job. Thank you.
Just one more.
And so
minute.
do you
Just
have...
one more minute, Senator Pratt, please.
Thank you. Gawain Powell-Davies, I'm not sure if you wanted to respond to that as well.
Mr. Davies, do you want to respond as well?
Thank you. I would just like to distinguish between my thinking that my colleague Bhante Akaliko is going to hell, which is entirely my own right, and my saying it to him. And what we're talking about is what happens when you say things to other people, which is a public act and has public consequences. It doesn't infringe my right to believe whatever I want.
All right, well, we will need to leave it there. Senator Pratt, thank you very much. I'm now going to go just in one moment to Senator Bragg, but I've just got one question in relation to Section 12 of the bill in relation concerning statements of belief. Section 12, subsection 2, makes it clear that a statement of belief is not covered where it's malicious, or that a reasonable person would consider would threaten, intimidate, harass or vilify a person or group. Does that give you some comfort in relation to the concerns you have raised today?
It doesn't, because there's still offensive and humiliating statements which are allowed. And these statements which would be allowed under this bill that actually cause harm, these can be off-the-cuff statements, these can be purposely targeted statements, these can be statements such as you're a sinner, you're going to hell. These are not the kind of statements we want to encourage in our society, and these statements would be allowed. The much tougher legislation of the Tasmanian state also includes these terms, such as things that offend or humiliate or denigrate.
Does any of the other witnesses have any comment in relation to my question?
Yes, please, Senator. So the Senate...
I'm sorry, who's speaking? It's just a bit tricky.
Sorry. Venerable Metigy.
Yep.
From
Thank
the
you.
Australian Sangha Association.
Thank you, Venerable.
Thank you. So try and give the Senator some practical examples. So a fully qualified Buddhist chaplain in another state cannot get entry into a Christian hospital and provide pastoral care when that person has asked for that. So the answer that presently exists is this is a Christian hospital and we will decide who comes in and who goes out. That's interesting in the sense of, sorry.
Does that actually happen? Does that actually happen?
Yes.
So even if a Buddhist is being, but I can't see anything in this bill that protects a Buddhist patient who by necessity of government contracts in a Catholic hospital being able, that enables their freedom of religion to access the pastoral religious support that they would wish. Is that really true, what you're saying?
But we would say the Christian group has decided that they wish to provide chaplaincy to all of those patients, or in a prison environment, the prison contract in Western Australia has been given to one Christian group. We think highly of them. But if a Buddhist prisoner under the United Nations Charter asks to see a Buddhist chaplain, that can be denied.
All right, I will, Senator Pratt, sorry, I will need to keep moving. Do any of the other witnesses have any comments in relation to the issue I've raised?
Can I just
there
get
being
a clarification? Was it a Catholic hospital or a Christian hospital of another denomination, for the record, Venerable Mederji?
Christian hospital?
A Christian hospital, not a Catholic hospital?
May I get confirmation?
Please, yes.
You can take
I'm
that
just
on
seeking
notice. All right, I'm now going to give
you.
the call to Senator Bragg.
Thanks very much, Chair. I guess my question is to the Buddhist Council, and I note that your preference is that the statement of belief be removed from the legislation. Just to expand on what was said before, so are your concerns stemming partly from the impact on the existing Tasmanian law?
Senator Bragg, we did not ask for that piece of legislation to be taken out. We need it to be strengthened so that it also includes offensive and insulting comments that are discriminatory. So we want the stronger level of protection that are found in the Tasmanian legislation. We don't believe that the current form of this bill goes far enough to protect people from offensive and humiliating statements.
Okay, so your position is you don't want to see the state of Tasmania's laws amended in this way. You don't want to see those laws affected.
We want this bill to have the strength of the Tasmanian laws, which include offensive.
I think, may I clarify in that
Senator
question?
Pratt,
Are you saying that the Commonwealth law
Senator Pratt,
in their
sorry.
override should reflect the
Senator
state?
Pratt, if I could just ask you just to hold for a moment. Senator Bragg has the call.
So I guess the question is before this committee is, or one of the many questions, is this particular provision would, if it was constitutional, would or could knock out the existing Tasmanian law. And I'm just trying to understand if that is something that you are particularly concerned about.
We're concerned about the Tasmanian law. We're also concerned the bill does not go far enough to protect people of faith from derogatory or insulting or offensive comments, or queer, trans or intersex people from these kinds of offensive and humiliating comments, which are made ostensibly under the statement of belief provisions. Firstly, the individual person's statement of belief protections mean that they only need to have an opinion, a genuinely held belief. Fortunately, the religious bodies have a higher test, which means that they can only discriminate if their statement of belief is something that other people from their religion would agree with, is a genuinely held statement of belief. I'm concerned about individuals making statements which could be, who knows, based in what kind of fantasy version of their religion, or people who are acting in bad faith, making such statements which harm and offend.
Okay, thanks.
Thank you very much, Senator Bragg. I'll now go back to Senator Pratt, who was seeking to ask a clarifying question.
Thank you, Chair. I just wanted to clarify the principle of an override of the states you're arguing would be okay if the Commonwealth established a principle that said harassing statements, vilifying statements, offensive statements of that kind should be part, and not allowing them should be part of our anti-discrimination architecture for all attributes. Is that correct? Sorry, the Hansard won't pick up a nod, I'm sorry. So
I wasn't sure if you're asking Senator Pratt sorry, Senator Bragg, you're asking me?
Yes.
Yes, that is correct.
Thank you.
Thank you very much, Senator Pratt.
I think one of our other witnesses also.
Well, only to add from the Australian Sangha Association that in terms of statement of belief, we feel that might be a nightmare for lawyers to put together their cases for court and for judges to adjudicate on. So I think all three of us, all three organisations here are aligned that it needs to be made clearer, more specific and strengthened, sufficient that there isn't vilification, there isn't attacks on vulnerable minorities, and there isn't discrimination of a majority religion on a minor religion.
All right, Senator Pratt, I'll leave it there, and I'll now move to Senator Rice. Hopefully, Senator Rice can keep this at about 5 minutes.
Yes, many of the issues that I wanted to cover have already been covered in the discussion so far. I just wanted some clarification, first of all, as to how many people your organisations represent.
The Buddhist Council has about 70 paid-up organisations as members, varying from very large temples to smaller community organisations. And the population that we encompass in New South Wales is over 200,000 people.
Thank you. And the Australian Sangha Association?
It's worth noting, Senator, that our submission was actually endorsed by several other Buddhist organisations. And they're both member organisations as well as national peak organisations such as the Federation of Australian Buddhist Councils and other important Buddhist organisations. So our submission actually has a broader base than just our members.
But how many people then do you estimate that your submission is representing?
Or, Senator, if only we had the resources to make those kinds of data investigations.
But it's, the order of hundreds of thousands of people, are we talking about?
Yeah, Buddhist organisations in Australia are divided along culture, ethnicity, language, and traditions and schools. So, we're representing a very diverse group of people across Australia, and we consulted our members on this submission. We consulted other religious groups, and we consulted other Buddhist organisations. So I'm not sure how many people we could say to represent, but we've done our best to be representative.
Okay, look, I mean, if you could take on notice, just giving us a good feel for it as to how many people, because it seems to me quite extensive and very, and I'm, disturbed at the level of discrimination that Buddhists are experiencing in Australia today and whose experiences are reflected in your submission, which I'll come back to, but I just wanted to go, first of all, just in numbers to the Hindu Council of Australia. So how many people are you representing?
Again, I cannot give the number of people. It's very difficult to judge. But we have 70 temples and other Hindu organizations who are our members. And each temple may have thousands and thousands of members depending on their size. We have annual festivals held in each major city, and our estimate is that about 50,000 people come to those festivals. So that can give you some idea. It's probably in hundreds of thousands.
Thank you. So a very significant proportion of the Australian population, which then makes it disturbing about the level of discrimination, as Mr. Akaliko, you outlined. So I've heard people say, oh, surely this isn't really happening. Basically, if we put these sorts of cases to a range of people, often we get the response of, oh, no, that's I haven't heard of that, that's not happening. So I'd be interested to just any more examples that you could share with us as to that level of discrimination that is being experienced by Buddhists and Hindus in Australia today.
I think the bigger concern for us in terms of this meeting is that this bill will actually create further discrimination against minority religions by reducing access to employment because of the provision that allows for religious organisations and domestic employers, people employing cleaners or gardeners. Buddhists and Hindus, people from minority religions are employed in hospitals, in school, and I'm sorry, getting a weird message. And these people will have their opportunity for employment reduced. People from Buddhist, Hindu backgrounds are employed as personal carers, as cleaners, as gardeners. These people will have their opportunities for employment reduced. This will actually increase discrimination against minority religions. Minority religions don't have the resources and economic power of larger religions. We don't have the ability to create employment opportunities, schools and other education or aged care opportunities for our community members. This legislation will create more discrimination and lock our members out of employment opportunities. It'll stop our children going to certain schools. It'll stop people being employed in aged care, in hospitals. And although there is the provision, thankfully, which was removed from previous iterations of the bill, where services could be denied to people of different faiths, unfortunately, this means that those people will be allowed to access aged care, hospitals, education, whatever, but they won't be able to be employed in those places. It's a strange and curious double standard that I have the right to access services, but not employment. I have the right to access services and not employment in a publicly funded hospital or in a publicly funded aged care provider.
Thank you.
It's going to be a weird environment for those people from minority faiths or LGBTQI plus people being in organisations where they're not reflected by the staff base. And what kind of culture will that create? What kind of culture in an aged care home does a Hindu person have or a Buddhist person have where they are the only Buddhist or only Hindu in the village, so to speak? They don't have any connection to their religion in the staff, and who knows what kind of culture, what kind of intolerant culture that might create.
Thank you.
This is a real concern. These organisations provide essential services. Religious employers are some of the largest employers in Australia. Buddhists, Hindus, other minority religion, we work in these places, and this will lock us out of those opportunities and create further discrimination against our people.
Thank you for that. Venerable Mataji, I think you had your hand up. You'd like to say something?
Yeah, just quickly, because I think Surinder wants to say something as well. So you wanted examples of discrimination. Here's one that's a bit strange. The Buddhist Society of Western Australia versus the Commissioner of Taxation in the Federal Court in Perth. We were denied donor gift recipient status for one of our meditation centres because the ATO viewed that we didn't operate sufficiently under a definition of a school building fund. That case ran for 4 years. We told them at the very start that we believed that the law underpinning the school building fund didn't have any foundations in Australian law. That was discovered. That was presented to the judge, and the judge agreed with us in November last year. The Buddhist community, the Australian Sangha Association, and many other Buddhist organisations asked that that case be put forward because we felt we would be discriminated against in even being able to teach in Australia and operate in a Buddhist fashion. And there was ignorance on the part of the agencies in even bothering to visit and find out how we operated, how we were doing good things from good moral conduct. So I'll just leave at that example and stop there.
Thank you. And Mr. Jain?
I would like to add what Bhante has said. We have a lot of Hindus who work in aged care services and disability services, predominantly being run by religious organizations. We have doctors working in private hospitals. We have IT people and their job would be questionable. But there is another category of people who are new migrants who come here and who are desperately looking for a job, and they find a job in a religious organization. There is unsaid pressure on them that they should adopt to the religion of the organization that they are in. So this way, this religious freedom would actually be taking away the freedom of minority religions in declaring their faith, in practicing their faith, and in not being pressured into adopting another faith. Thank you.
Thank you very much for your evidence.
Thank you so much, Senator Rice. And I'd like to thank the Buddhist Council of New South Wales, the Australian Sangha Association and the Hindu Council of Australia for your evidence today and for your commitment to this inquiry. The committee will suspend...
Thank you very much.
Thank you all.
Thank you. The committee will now suspend for afternoon tea and resume... I'm going to just keep it a little bit short. Resume at 3:55, please. The committee is now in session, and I would like to welcome representatives of the Public Affairs Commission, Anglican Church Australia and the Anglican Church Diocese of Sydney. Thank you so much for taking time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 62 and 136 respectively. Do you wish to make any corrections to your submission?
No.
There being no corrections, for the Hansard record, could you please each state your full name and the capacity in which you appear today?
My name is Carolyn Tan. I appear as the Chair of the Public Affairs Commission of the Anglican Church of Australia.
Thank you, Dr. Tan.
And my name is Michael Stead. I'm the Anglican Bishop of South Sydney, and I'm here representing the Diocese of Sydney.
Thank you very much, Bishop. I appreciate that. So we will now ask each of you to make a brief 1-minute opening statement before going to questions. Would you like to go first?
Thank you.
Oh, Dr. Tan, yes, you go.
In summary, in the absence of comprehensive human rights legislation at a Commonwealth level, the Public Affairs Commission supports the principle of a religious discrimination bill. This is not so much for fellow Anglicans as for members of minority religions who need to be assured that they are valued members of the community and that their human rights matter. However, we do not support this particular bill because it overreaches in terms of its impact on the fundamental rights of others. And we urge that it be redrafted in a way that achieves a better balance in the protection of rights of all people to be free from discrimination on the grounds of who they are.
Thank you very much, Dr. Tan. Bishop.
We support the passage of the bill. The bill addresses a long-standing gap in federal anti-discrimination law, and this bill in particular does what a plain vanilla bill does not do, which is to strike the right balance between the twin stated aims of the bill, which is, on the one hand, to render it unlawful to discriminate on the basis of religious belief or activity, whilst, on the other hand, at the same time, affording sufficient legislative protection for religious institutions to allow them the freedom to maintain their religious ethos. In addition to the amendments proposed in our submission, we also support the amendments proposed by Professor Aroney to clauses 11 and 12, which will ensure that 109 of the Constitution is invoked by the bill, and I recognise that there may be some doubt about that.
Thank you so much. We'll now go to questions, and I will give the call to Senator Pratt.
Thank you, Chair. My apologies for being slow in unmuting myself. May I ask, please, specifically the Public Affairs Commission, in the context of your statements about the need for the bill to be amended before it could be ported, how would the Commission, seek to amend the bill? What's the most concerning aspect of it?
Well, our submission outlines various ways in which it could be amended. I think the most concerning aspect is section 12, and the statements of belief override other anti-discrimination legislation. We've also recommended changes to the way in which the exemptions for religious bodies are dealt with, and there's quite a lot of those. I suppose the key factors would be to have wider provisions allowing for exemptions for internal matters such as ordination, membership, religious worship, and also to have a separate provision relating to preferences. But then that would enable the more general exemptions to be narrowed substantially. And one of the big issues that we are concerned about in relation to the wider provisions and to the preferences is that we are concerned that preferences should only be at the point of employment and should really only be a factor that could be treated in favour of somebody's appointment if they're a member of the same religion. But beyond the initial employment, that the other anti-discrimination laws should apply, and that a person shouldn't, and also that a person shouldn't be able to be removed from the security of their employment, or students shouldn't be able to be removed from schools or treated adversely on the grounds of their religion. As we know, religious beliefs will change over time, and it's too extreme to dismiss someone or to penalise them for their beliefs.
So in that context, can I ask how it should be amended to both pick up on protections for minority religions or minority views about a religion within a religion? This is a religious discrimination and religious freedom bill. Have we got the balance right when it comes, this legislation, when it comes to saying, well, this bill is to support everybody's religious freedom? I don't know if you saw the witnesses previously in terms of some of the experiences of people having one religion discriminate against another religion, for example.
Well, that's the problem that we see in section 12. That would enable a statement of belief to override other discriminatory legislation. Now, it might not specifically override a clause of this particular legislation, but certainly could override state and territory religious discrimination components. Yeah, so that would be a concern. I think.
So in that
nothing that stops. Sorry, I was going to say there's nothing that stops people from making statements of belief if you remove section 12. The issue is whether you can remove it, whether people need to learn to make statements of belief in ways that are not unlawful under other legislation. And one would hope that in a society of mutual respect and dignity, people could learn to make their statements of belief in a way that respects that.
Yes, thank you. That's helpful. Can you give some insight perhaps into how religious protections in state jurisdictions for freedom of religion or perhaps First Nations cultural belief that should also be protected as a religious belief, and this bill I think clarifies that it does, how nevertheless those protections could be, religious protections could be diminished by the way that this bill manages religious statements of religious belief.
Well, I suppose that the problem is with you giving immunity to statements of belief that don't reach that high bar of harassing, vilifying, or otherwise, but they could be totally offensive and insulting, that those are protected. even if they might be in breach of state anti-discrimination provisions.
Senator Pratt, we are going to have to share the call around because we have a number of senators who want to ask questions. If I could ask you, have you got, is that your final question? That's, okay, thank you so much, Senator Pratt. I appreciate everyone's forbearance today. Senator O'Neill,
Thank you. Just a
if
couple
I
of
could
lines.
just ask just for a couple of minutes,
Two lines
please.
of questions, thanks. The first one is, can you shed any light on the supposed deal that was done, further to our last conversation, by Miss Allen, Mr Sharma, Miss Martin and Miss Bell, reported on the 1st of December with regard to section 38.3 and denied by the Attorney-General and the Prime Minister subsequently. Do you have any clarity about that, and have you had any contact with the relevant?
No, nothing's changed since you asked the same question last Thursday. I still have had no further contact with the Attorney-General or the Prime Minister, and so I'm still as much in the dark as you are, and I know what's been reported in the media and nothing more.
And have you sought clarification of that in any form?
Not directly, no.
And you haven't written a letter?
No.
Okay, thank you. Could I just go then, and I thank you for in your opening remarks alluding to the fact that you've been listening to the hearing today. And of course, while there's been general agreement that a religious discrimination bill needs to be enacted with some haste from particular communities because they are really experiencing profound discrimination, my concern as a Labor senator and a person of faith is that what gets enacted is actually practicable. So Professor Aroney this morning was unable to answer my question given the truncated time, but you have had a look at that submission, I understand, Bishop Stead.
Yes.
And I really seek your response to the interaction between the concerns raised about the constitutionality of sections of clauses 11 and 12 in the Act and Professor Aroney's proposed set of responses to address that concern about making this legislation actually practicable.
Yep. So just to clarify, the issue is not so much the constitutionality of the amendment, but whether they will be constitutionally effective. That is, will Section 109 be invoked to override the inconsistent
That's
state
a very
legislation?
good point.
Sorry to quibble.
No, I think it's a very important point because we do
Yep.
need to quibble. These words will matter.
And having read the submission from Professor Toomey, I should say I'm not a constitutional lawyer and I'm comparing one constitutional lawyer against another constitutional lawyer, but Professor Toomey's observation I think is accurate. She makes the suggestion about how that could be fixed with a clause that uses the words notwithstanding a state or territory law to the effect ... and Professor Aroney's amendments pick up exactly that language. So to my mind, as a non-lawyer, as a non-constitutional specialist, I think I agree with both of the professors that we probably do need to fix the language of clauses 11 and 12. And again, as a non-lawyer, I think that Professor Aroney's amendments proposed to clauses 11 and 12 do exactly that and are consistent with what was proposed by Professor Toomey.
All right, so would you encourage the government to undertake that amendment?
Yes.
Despite your previous expressed support for the bill?
Yes.
It does deserve this tweaking in your view, Bishop Stead?
Indeed, and as I indicated, in addition to the other amendments that we have recommended, we would now like to add that to the list of recommended amendments.
And
last question, Senator.
Given the regrettable limitation on time that has been inflicted upon us by the government's timetable, I would really just like to give you the opportunity to draw the committee's attention to any matters that you think we need to give consideration in the course of this inquiry and for our reporting on the bill. So over to you, Bishop Stead. It's a free kick for whatever you want to say.
Okay. I think I'd like to respond to something that came up in the context of the other inquiry about the unworkability of the Clause 12 in relation to the override of inconsistent state legislations, in particular the concerns raised by the Law Council of Australia, which are also repeated in their submission to this inquiry, that because state-based discrimination is meant to be no cost, quote unquote, this will now introduce complexity because it'll need to be removed to, in most of the jurisdictions, to a district court and in some jurisdictions to the federal court in order to address these issues raised by clauses 11 and 12. There's more to be said, and I will probably run out of time, but and so I'm happy to expand this on notice if I may, but in essence I'd want to say...
That'd be great.
I'd want to say it briefly, to make 4 points. No cost is a furphy. It's not no cost to those who are defending these actions. And just to pick on the Tasmanian legislation, which I want to do, the costs there have run into the tens of thousands of dollars for the people defending it.
So the no-cost claim is about the person who makes the claim, not the person who has to defend. So it's only one part of the equation that needs to be taken into consideration.
That's correct. And,
Thank you.
And that has an implication for vexatious or frivolous claims. There's a very low bar to making a complaint, and that, on the other hand, puts the respondent to incredible expense, and you've received evidence this morning to that effect.
The Human Rights Commission...
And I'm getting the signal that I'll stop.
No, sorry.
I'll take that on notice.
The Human Rights Commission have made some claims about changes made by the former Attorney-General that assisted at federal level. I'd be interested to see your view about how it might assist at state level. And then you had two more points.
I'll take that on notice.
Thank you so much. I do appreciate that, Bishop Stead.
I'll take that whole answer on notice.
Thank you.
Thank you very much, Senator O'Neill. Senator Rice.
Okay, thanks, Chair. Thanks. Great to see you here in person, Reverend Dr. Stead.
Thank you.
And good to see you again, Dr. Tan. Look, I wanted to quickly just ask some clarifying in terms of the supposed proposed deal to remove Section 38(3) of the Sex Discrimination Act, what your two positions are on that, whether you would support that or not support it.
So I wouldn't support the full removal of 38(3). We would support a very limited amendment of the kind which was foreshadowed by the Prime Minister. That is, his promise was that no student would be expelled on the basis of their sexuality or gender, or words to that effect. And if that's what the amendment to if that was the effect of the amendment to 38(3), we'd support that. The full removal of 38(3) goes much wider than that, because it actually goes to the operation of schools according to their ethos, and that's why it would be premature prior to the review by the ALRC to just take the wholesale removal.
Okay, thank you. And Dr. Tan?
Well, the Public Affairs Commission has previously made submissions in relation to the Sex Discrimination Act, supporting the removal of the entire Section 38 and amending Section 37(1)(d), which is the catch-all sort of exception. But I do recognise that it's quite a complex issue of drafting, and therefore it would be useful to see what the recommendations are from the Australian Law Reform Commission. And indeed, the ALRC advice on that would be useful for the exceptions in this particular bill as well.
Thank you. Thank you. So rather a different position between the two of you.
Of the same faith.
Of the same faith, that's right. So, and I now want to clarify. So, Reverend Dr. Stead, you just said that you would be happy with a narrower rendition of 38(3), so that students weren't discriminated against on the basis of their gender identity or sexuality. Yeah. Is that across the board for the Anglican Church?
Again, I can only speak for the Anglican Church in the Diocese of Sydney. So I can't speak across the board, and indeed neither can Carolyn, so we're each speaking for our respective bodies. So, but I can say...
on your knowledge of the Anglican Church sort of across the country?
Yes, if I had to guess, I would think that pretty much every Anglican school of which I'm aware, nobody expels students on the basis of their sexuality or gender, and therefore having a rule that says you can't do what you don't do wouldn't be an imposition for any of us.
Okay. And Dr. Tan, that's your understanding?
That is my understanding. I know at the time of the debate of over Section 38, at least 3 dioceses issued statements saying they want to build inclusive communities within their schools, and they certainly do not intend to discriminate in any way. Okay.
Now with the issue of teachers. So what's the situation with teachers, certainly from the Sydney Diocese's perspective?
Sydney diocesan schools employ a wide variety of people, a wide variety of faiths, a wide variety of sexualities. We, to my knowledge, nobody has ever been sacked for being gay, if I can use that kind of language, from an Anglican school in Sydney. We do not require all of our teachers to profess the Christian faith, and in fact, probably only 25% or 30% of our teachers would identify as active practicing Christians, and therefore we have quite a diverse and inclusive teaching body across our schools.
Okay, so even in the Sydney Diocese, which is, I know, conservative, socially conservative end of the Anglican Church, you're saying that you don't then discriminate against staff or teachers on the basis of their gender identity and sexuality.
That's right. But we're here. I guess I'm here to speak on behalf of exclusive Muslim schools and Islamic schools and some Christian schools who do require all their teachers to profess their respective faiths. And again, to push the point, nobody actually wants to sack people on the basis of their gender or sexuality. The issue is whether those teachers are able to support the Muslim ethos or the Christian ethos or the Jewish ethos of that particular school. And for some schools, that gender identity or sexuality will be a point of tension because it's a point of belief, religious belief, rather than about the gender.
Which is what I wanted to go to, because in your submission you defend the right of the school that sacked Steph Lenz on the basis
which, to be clear, is not an Anglican school.
And not an Anglican school, but on the basis that the belief of the school was that her sexuality no longer aligned with the school's statement of belief.
No, other way around. So the school required her to teach that, as a Christian school, we believe that marriage is between a man and a woman. That is a Christian understanding of marriage is that it's between a man and a woman. She was required to sign a statement of faith that said that she supports the Christian view of marriage, that it is between a man and a woman, and she indicated to the school that she was unable to sign that statement of belief.
But even though, so she was unable to sign that statement of belief, but she had reconciled, she still felt that she was a devout believer of that denomination, and she had reconciled her faith and her sexuality, but the school hadn't. But basically the school, it's the school's view of what is their statement of belief which you are supporting having primacy.
Absolutely, because the point we make in our submission is that otherwise you end up with the school at the tyranny of the minority. So if we have one teacher in a school that says, well, you all believe that Jesus rose from the dead and that's an intrinsic part of the Christian belief, but I've reconciled myself to the fact that Jesus didn't rise from the dead, but I'm still a Christian, you now have to accept me, and not just accept me, but accept me teaching this as a valid expression of my Christian faith to these students.
But it's not just being a Christian, it's actually, I mean, Steph Lenz's view was that she was still a devout believer of that denomination, but it's, so essentially what this legislation is supporting is the rights of the freedom of belief and to not be discriminated against on the basis of the religious hierarchy rather than the individual, isn't it?
No, it's not about the religious hierarchy, but it's actually saying that when an association has formed with like-minded believers to share a common faith, they get to maintain that faith rather than having that faith eroded by the minority. And it's not...
But even if that minority still say that they are a member of that congregation and they have got a belief in the faiths of that denomination.
Yeah, but Steph Lenz still has her freedom of belief. She is absolutely free to leave that school and get a job as a teacher at another school which has a different view, a more inclusive view, which she has done. And I'm saying that's how it should work out, because otherwise that school which has that particular ethos and parents choose to send their children to that school for that very reason will no longer have that ethos if it can't maintain its own view.
In terms of the Anglican Church, could you see that there would be statements of belief at some Anglican churches that some Anglicans would not be able to support?
Last question, Senator Rice.
Well, we don't require statements of belief by members of the congregation. If you mean members of the clergy, then well, yes, that's how we operate. When I became a minister, I confessed that I believed a certain set of beliefs. If I cease to believe those, it's not that Anglican Church has to change to accommodate me. I have to leave the Anglican Church.
So that, if it's members of the clergy, I mean, you have across the Anglican Church in Australia, there are same-sex attracted Anglican priests, there are transgender Anglican priests who are accepted in some Anglican dioceses and not in others. Isn't that the case?
That's right, and I'm saying that's how it should be, that each individual institution should be able to say, this is what we understand the teaching of Christ to be.
So essentially it's not religious freedom for the Anglican person, it's religious freedom for the diocese, for the hierarchy, or for the school, for
Senator Rice,
the Anglican organisation rather than the individual.
That's absolutely the last question. Bishop
May
Stead.
I ask under what influence has doctrines changed?
Senator Pratt, sorry, I would like to invite Bishop Stead to answer that last question of Senator Rice's.
Okay, just to clarify, Senator Rice, I'm not arguing for the freedom of the institution. I'm saying that the institution is nothing more than the collective of the individuals who choose to associate around a particular set of ideals. And if you take away those ideals, what are they associating around? If I can take it into a political domain, does Greenpeace have the right to insist that people that they won't employ climate change deniers? Is that Greenpeace enforcing its ideology on its members? No, all the people who join Greenpeace have a particular view.
But I suppose my question is how much the Sydney Diocese actually does reflect the views of Sydney Anglicans.
Senator Rice, I have made it clear that was your last question a couple of times. I am going to have to share the call around. Senator Bragg.
Thanks very much, Chair. I just have a couple of quick questions, and I think my first one is actually to you, Dr. Tan. So I just wanted to get my own understanding of your position. Effectively, on the statement of belief, your concern is that it would preference religion above other attributes. Is that right?
Yes, that's the summary of it.
Okay. That's an interesting position to take as a religious organisation, but that was, I'm glad I can read your very clear submission. Thank you. Very helpful. And to you, Bishop, can I ask you, because there was a discussion about the Steph Lenz case, stepping aside from the question of whether or not someone signs a piece of paper, the question I have is, can you be a gay teacher in an Anglican school and teach in accordance with the theology or the ethos of the school?
Yes, there would be many gay teachers in Anglican schools. We require all of our teachers to undertake that they support the ethos of the school. We don't require signing a statement of faith that articulates particular beliefs, and gay marriage, heterosexual marriage is not one of those things that we require. But there are many gay teachers in Anglican schools who nonetheless teach in accordance with the ethos of the school.
Okay. So on that basis, you wouldn't have any problem with law reform which went to the question of the school's ability to remove a staff member?
No, I would, for the sake of the other members of the religious community for whom that is an issue. So one of the interesting things to come out of this whole process has been the way that the Christians, the Jews, the Muslims have been working together on this, and I recognise that there are other schools for whom this is an issue, and hence the whole reason why I've gone out on a limb and I identified the Steph Lenz case, even though I know it takes some negative publicity for it, is on behalf of those other schools for whom this is an issue. So Sydney Anglican schools don't have a problem, but the religious community as a whole does have a problem, because it goes to the very question of at what point the government gets to tell religious institutions who they can and they can't employ. And for some institutions, that goes to the very essence of who they are. If you're an exclusive Muslim school, you want to be able to say all our teachers have got to be 100% Muslim, and that's what this bill allows.
But so I guess the question is, should you be allowed to discriminate against someone based on their sexual preference if they are teaching in accordance with the ethos of the school?
No. Sorry, I may have misunderstood your question. None of the religious bodies are arguing for the right to discriminate on the basis of sexuality or gender. What we're arguing for is the right to be able to discriminate on the basis of religious belief. And if it happens that somebody's religious belief also happens to reflect their sexuality or their gender in a way which is inconsistent with the belief of the organisation.
Sorry, Senator.
I think we're in agreement then.
Sorry, Bishop Stead was just about to make a very important point.
I'm confused. I really need to clarify this question.
Senator Pratt, I would just ask if I am going to come to you after Senator Scarr. Sorry, Bishop Stead, could you just finish your answer, please?
Yes. The religious institutions are not seeking the right to discriminate on the basis of sexuality or gender or any of the other protected attributes. They're looking for the right to be able to...
Age.
Thank you. They're looking for the right to, in the wrong language, discriminate on the basis of religion. We would say to preference on the basis of religion, to act in accordance with their religious belief. And it's only at the point at which somebody's religious belief has changed that reflects their sexuality or gender that makes it inconsistent with the school that we're into this area of intersectionality to work about. But no, we're not seeking exemptions, and that's what's wrong with Section 38(3), in fact 1 and 2 as well of the Sex Discrimination Act. It's an exemption that is way too broad. So we support the reform process which has been referred to the ALRC. We're happy for that to be fixed. But to get that fixed, we need to have a clear understanding that religious organisations can operate in accordance with their religious belief.
Thank you, Bishop. Senator Bragg, thank you. I'm now going to give the call to Senator Scarr, and then I will come back to Senator Pratt very briefly. Senator Scarr.
Thank you.
Thank you, Chair. And Senator Pratt, I'm aware you want the opportunity to ask another question, so I'll be as quick as I possibly can. Dr. Tan, during the course of today, I've been most impressed the sincerity of all my fellow senators and also all the witnesses here today and the empathy that's been expressed. I want to really drill down into this issue of the Tasmanian Anti-Discrimination Act. And I made those introductory comments on the basis that we had evidence earlier today from the Australian Catholic Bishops' conference, that from their perspective, the way that section of the Tasmanian anti-discrimination law worked in the lead up to the same-sex marriage plebiscite, which of course was successful, but the way it worked in practice was that a document, which I should say, they said maybe could have been better worded in respect, but a document which in good faith set out the teachings of their religion was subject to a complaint that it caused offence to an individual in the community. And from their perspective, as leaders of one of the great religions, right, from their perspective, they consider that their international human rights, their ability to state their religious belief in what in good faith, in a way which they consider was reasonable and wasn't beyond the pale, led to them being the subject of a complaint under the Anti-Discrimination Act. Can you understand in that context why, as a senator, I'm particularly concerned that if we don't achieve the right balance here, we can have a religion, people of deep faith, who feel that they're unable to express the most basic statement of belief where they're doing so in good faith. Can you understand why that causes concern?
Yes, to me, there are two issues involved in the Tasmanian legislation. One is whether the statement of faith had to be done in a way which was insulting or ridiculing or offensive. Now, we don't, I mean, I think part of the complainant's point of view there was it was not so much that they were simply stating what their faith was, which would not have been problematic. It's the way there was an attack on same-sex married couples. The second issue is the issue of the time-consuming nature with claims that may or may not succeed. I mean, we have no indication that the particular complaint would have succeeded in that Tasmanian situation, and that's a greater problem with being able to deal with claims and the process of the anti-discrimination.
Dr. Tan, can I put this to you? And I've been reflecting upon this. Certain stakeholders have given examples of statements which they say would be protected under this statement of belief clause. And some of these examples are absolutely extreme, beyond the pale. And I have a material concern, and indeed in one of the submissions, Professor Parkinson referred to the fact that as a Christian, he felt offended by some of these statements of belief that are being put up as examples are just so beyond the pale. They're leading into the creation of stereotypes as to what Christians believe or Muslims believe or other people believe. But reflecting on this, it seems to me, well, that's a stakeholder who's particularly concerned about this legislation. They want to put forward their concerns, and sure, it might cause offence to other stakeholders, but that's part of a pluralistic democracy, that's part of freedom of speech. And we all need to do our best to lead by example, to keep the debate within the boundaries. But some of these matters just can't be solved by law. And if you try to, it has unintended consequences, a chilling effect on the debates that we should be able to have in a civil society. And I have your view with respect to that.
Well, I would still hope that debates can be carried out in a way that is not insulting or offensive or ridiculing anyone on the grounds of who they are. And that's a matter of, and they should, the other, Section 12 goes the other way in terms of allowing people to make derogatory statements against people of who they are, just simply because there is a religious basis to it, in a way that it would be unlawful if there was a philosophical basis to it.
But aren't you, Dr. Ten, aren't you looking at it in a negative way, in the sense that you're almost looking at this clause as if it says you can go out and make derogatory, demeaning statements, etc., when in fact what it's saying is you can make a statement of belief, provided it's held in good faith, and provided that it doesn't go too far in terms of all the checks and balances around vilification, etc. There's almost a presumption that there's people out in this community who are just itching for this clause to be passed so that they can go out and make these derogatory and demeaning statements, that waiters can say to customers that, oh, you're Jewish, you killed Jesus, etc. When that is not the context of the debate that we're hearing from some of these religious groups. They're profoundly concerned that they can't state their religious belief in a moderate fashion, and that's the note in the bill, a moderate fashion, in good faith, in a way which doesn't seek to maliciously insult other people. And it just seems to me you're looking at this clause in a very negative way, as opposed to seeing it as a means to actually recognise the fact that religion is an important part of people's lives. Can you see that perspective?
Well, entirely. I accept that religion is important and people are entitled to make statements of belief as long as they do it in a way that isn't unlawful under other legislation, and people can learn to do things that way, because that's what care and compassion is all about. And some of those examples that you say are outrageous have been given to this in submissions and to this committee as actual examples of what people have to put up with. So they're not so outrageous.
But
Our last question, Senator Scarr, please.
The statement of belief doesn't necessarily say that someone's saying, I can't imagine, to be frank, a waiter saying to a customer in a cafe who's Jewish, you killed Jesus Christ, right? Or something totally beyond the pale. Examples have been given with respect to taxi drivers saying to a visibly impaired person that their guide dog is unclean, etc. Totally beyond the pale. Look, feeding into unacceptable stereotypes, in my view. Wouldn't you just, if I owned the cafe, I'd sack the waiter because he's employed to actually serve coffee and to build business.
Senator Scarr, do you have a final question? We do.
Isn't that a fair response?
We are running very short of time.
Well, my response is that those are actual statements that people have reported as being statements that have been made.
Okay.
And fortunately, the employee conduct rules provision have been taken out, because otherwise that would have inhibited the ability of the employer to sack the person.
Well, I don't
Senator
necessarily
Scarr,
agree.
I'm sorry, we are going to need to leave it there.
I don't necessarily agree with that analysis. It just really concerns me.
Thank you, Senator Scarr. I'm now going to move to Senator Pratt just for a 1 minute clarifying question. Senator Pratt.
Thank you. I wanted to clarify with both witnesses on the Tasmanian override because the Archbishop has said that they don't desire a right to discriminate on the basis of any attribute, only on religion. And in that context, it's my understanding that that is what the Tasmanian law does to some extent. And that some schools have, for example, sought to discriminate against staff for attribute rather than their religious belief. Equally in that context as the Tasmanian override goes, messing with marriage is messing with kids was one of the statements before the Tasmanian Anti-Discrimination Tribunal that had very negative connotations for the gay community, which is why it was put forward before the tribunal. Again, I'm confused as to the extent to which that is the kind of vilifying statement or religious statement that no one can give clarity, given the Catholic Church regrets making that statement, and yet it's used as an example as the need for the legislation. So I'd like, if you can, please, to address both of those issues. Thank you, Chair.
Bishop Stead first.
If I may, Senator Pratt. Section 17.1 is not strictly part of the discrimination provisions in the Tasmanian legislation, so it creates an offence rather than discrimination, and so that's why my earlier comment about we're not seeking a right to discriminate is really not relevant to the discussion of Section 17.1. Section 17.1 makes it an offence to intimidate, humiliate, insult, ridicule, and so on the basis of a protected attribute. In relation to the particular document, so I'm not here to defend the Catholic Church in Tasmania, although I think their evidence is that it could have been better expressed, is how they would have described their document.
Isn't that the purpose of the law, therefore? Isn't that why we have these tribunals? So that...
That's with the benefit of hindsight. When it's cost them tens of thousands of dollars to drag through a tribunal, they probably would have expressed it differently, as I understand it. It's unfair to characterise the whole debate as messing with marriage is messing with children, because that's not reading that sentence in its context. The whole paragraph actually begins, God created marriage as between a man and a woman. This is God's design for the proper organisation of human families, and ... when you mess with marriage, you mess with children. Anybody reading that could not reasonably, I think, take away the connotation that messing with children has sexual connotations, which was what was alleged. So I think it's unfair to characterise it in that way. However, I'm not the Catholic Church in Australia, so I'm not trying to defend their statement, but it is an example of what happened on the basis of a statement of Orthodox Catholic belief that a bishop of the church gets taken through a very expensive for them process, taking many, many months, and quite a distraction from the other business of the office. So that's why it's a good example of why we need to override 17.1.
Dr. Tan, do you have a response to Senator Pratt's question?
Yes, I mean, I don't want to make any particular comments on the particular facts of that case, but I mean, the part of, to me, the difficulty is the process and the expense. And yes. These are things, and that's not specific to religion. I mean, it happens in all sorts of litigation all the time, and people are put through a lot of expense to defend something which really had no basis in the end. So that's something that one needs to look at the process rather than try to deal with it by allowing statements of belief to override particular sections.
Yes, thank you. That's very, very helpful.
Thank you very much, Senator Pratt. I appreciate that. And I would like to acknowledge the witnesses' contribution. Thank you both so much for your time today and for your considerable support of this inquiry process.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you all.
I would now like to welcome representatives of the Presbyterian Church of Australia and the Presbyterian Church of Victoria. Thank you so much for making time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 105 and 140 respectively. Assuming that you don't want to make any correction to your submission, for the Hansard record, could you please state your full name and the capacity in which you appear today?
So, John McLean, I'm convener of the Church and Nation Committee of the Presbyterian Church of Australia.
Welcome, Dr McLean.
Christopher Duke, I'm the convener of the equivalent in the state of Victoria.
Thank you very much, Reverend.
Moira Deeming, I'm researcher for the Presbyterian Church and Nation Committee.
Thanks very much, Mrs Deeming. Could I invite you, on behalf of each of your organisations, to make a 1-minute opening statement before we go to questions?
Sure. Thank you. Well, thank you for the opportunity to present and for the work this committee is doing over this summer period. We believe that the Religious Discrimination Bill will be a timely addition to federal anti-discrimination legislation, adding protections that are already present in quite a few state jurisdictions to the federal legislation as well. Australian society has people who hold a wide range of religious views and many who hold no religious view and are critical of religion. And the bill has the potential to provide protections for all those people. It also recognises that religious bodies, including institutions which provide care and education, should be able to admit members and select staff on the basis of their religious commitments. And that capacity is essential for religious organisations to continue to pursue their mission. And then it provides appropriate protections of statements of religious belief and religious non-belief from complaints of discrimination.
Dr McLean, we will need to move to the next. I'm sorry
Fine.
to be
No,
so
that's fine.
truncated. Thank you
Great.
so much.
Just before I give it an opening statement, I did retable an amended submission.
Yes, that has been circulated.
Okay,
Thank you very
thank you.
much for that amended submission.
Well, the Presbyterian Church of Victoria welcomes the introduction of the federal religious discrimination bills. Thus far in our laws, there's only some elements of religious freedom through exceptions in other anti-discrimination laws. We think that it's important for religious institutions to be able to preference staffing, staff who not only agree with the tenets of the faith but also daily express their faith by the way they live out their lives, especially in schools. We know that there has been criticism from certain circles, especially from groups supportive of LGBTQI rights. The bill gives, in our opinion, minimum advantage, but at least is a step in the right direction in the area of religious freedom. So far in Australian federal law, there's nothing that spells out positively a position of religious freedom. This bill at least brings us closer for Australia to meet its responsibilities in ensuring freedom of religion that are clearly laid out in the Universal Declaration of Human Rights, Article 18 of the International Covenant on Civil and Political Rights, and the Declaration of Elimination of All Forms of Intolerance and of Discrimination based on religion or belief.
Thank you very much, Reverend. We'll now go to questions, and I start by giving the call to Senator Van.
Thank you very much, Chair. Thank you all very much for appearing today. Can you explain your position and why you believe the bill is compatible with Australia's international human rights obligations?
You just finished on that point, so you might as well keep going.
So I've been trying to be consistent across the day.
Well, at this stage in our law, we've had discrimination laws come in about most of the other attributes of the Universal Declaration of Universal Human Rights, but there's nothing that's really been spelled out positively in relation to religious freedom. Religious freedom is one of the attributes, and we know that all of these attributes are meant to be held equally, and and at this stage, there's not an equal position for religious freedom. We just have, at this point in time, as we know, we just have some exemptions in some of the anti-discrimination laws, and so at least this is a step forward. Now, we would argue that what's been proposed is not a great step forward, but it's better than nothing at this point in time.
Do you believe currently that Presbyterian schools and institutions have the freedom to make decisions in line with their ethos currently?
Well, depends which state you're in.
Well, someone speaking across the nation and someone from the great state of Victoria.
So I think generally, and certainly in New South Wales, where I'm from, our church schools find they can, especially in selection of staff, can pursue their mission and retain their ethos. But I think at least potentially there's a different situation in Victoria.
Well, as we know, in Victoria, we've just had a change to the Equal Opportunity Law, and which will make it more difficult for faith-based schools to actually employ staff based on their religious mission, and we're sorry that this is occurring, because whilst you have a differences of philosophy and opinion across all religious types of schools throughout the nation, those schools which come under the umbrella Christian schools have been especially targeted, and especially targeted in Victoria, that the idea that the only person that really matters is your principal and maybe your chaplain. Well, we don't believe that. We believe that presenting the Christian ethos, the Christian faith is something that occurs in the whole school, and it occurs all of the time when a student comes into it. And so it's very important for a school to have that freedom to do that. And therefore, when we talk about human rights, there's going to be clashes. When you're intersecting all the rights that we have at the moment, there's no law that's actually perfect at this point in time, and you're going to have clashes. Our preference is that we actually are able to still conduct our mission, and in some cases you've got to, we believe that we endeavour to treat people fairly, in love and compassion and all that sort of thing. And one of the other aspects of the reason why we want to have this freedom is because this is what the majority of our parents want. You know, we're supplying a resource for our parents who want to bring their children up in the admonition and nurture of the Lord. And, you know, this is not just a Christian ethos, it's also a Jewish ethos, as you understand the Shema, and it's vitally important that we train up our children in the way they should go.
Thank you. I've been told I've been wound up prematurely.
Apologies, we have such truncated time allocated to you this afternoon.
Sorry, I'm a preacher.
Praise the Lord.
Very briefly, we'll go to Senator Bragg.
Thanks very much. I just wanted to ask you about the status of same-sex attracted students and staff inside your schools.
So what's your question?
Well, what's the status? I mean, what happens? I mean, do you have gay teachers? Do you have gay students? What's the story? How does it work in your schools?
So I think our answer is going to be very similar to Bishop Stead's answer previously, that our schools would have a range of, first of all, would have a range of policies of to what extent they expected staff to affirm their faith position, that some would simply be seeking staff who will support the ethos.
Yeah.
Other schools would want teachers who are committed Christians and share the same faith views and the same moral views. So there'd be a range of policies of the schools. Within those schools then there certainly would be staff who are gay, but who are happy to support the ethos of the school. There'd be other schools which would expect staff to, in their own lifestyle, reflect the Christian sexual ethic. And so if gay means being in a homosexual relationship, that wouldn't be, they wouldn't be employed.
Would that be uniform in all schools?
No, I think there'd be variety across the schools in terms of staffing.
Within the denomination of Presbyterianism?
Yep.
Okay, thank you.
Okay. Can you? Okay. So your view is that you would want to have, some of your schools would want to be able to discriminate based on sexual preference or orientation.
To be precise, it's about sexual ethic. It's not about orientation. It's about what type of lifestyle you live, and so whether you're committed to heterosexual monogamous marriage as a sexual expression.
Okay. So just so I understand, just because it's an interesting statement you make. So, I mean, it's hard for an employer to understand whether or not a staff member is doing what you want them to do. I mean, people do a whole lot of things in their lives.
Right.
So that might be a hard thing to police.
Well, all sorts of things may or may not be difficult to police, but I think the capacity of a religious organisation to ask people as they're seeking employment to set out, here's our statement of belief. Do you subscribe to that? It includes ethical elements. Do you live according to those? And for the person to say yes and to take them at their word, you'd have references.
Okay, I think now I understand what you're saying, okay. Okay, so effectively what you're saying is a staff member could be gay. They would need to teach in accordance with the ethos of the school, of course, and they may need to sign a piece of paper.
And it wouldn't be a piece of paper that's particularly produced for that staff member. It would be a standard code of conduct. And again, I'm not saying that all schools will want to do that, but we want the capacity where schools judge that is the kind of employment practice they want to have.
But you're not seeking to discriminate on that basis?
They are.
Well, are you or not?
What we're seeking to discriminate upon is the basis of belief and practice. Now, if a school is wants to choose staff on a more liberal employment policy, then we would have some schools that would do that, but we have other schools that would want to be a bit tighter on its employment policy. We would want those schools would have people or policies that where the policy is that they want to see evidence that you live it as well as believe it.
Okay, I know that I'm out of time, so can I just ask on...
Sorry, Senator Pratt, if I can just ask you to hold for a moment. I know it's hard when you're attending remotely. Mrs Deeming just wants to make a comment as well.
Thank you. I just wanted to add some further clarity, if you don't mind. So I'm just going to quote the membership standards from the Australian Greens, which is that you've read the Charter of the Greens and agree to abide by the party's constitutional rules and values. Labor Party, membership of the Australian Labor Party is open to all residents of Australia who are prepared to accept its objectives and who have associations with no other political party. You know, political parties want the same rights that we want. We just want to form an association with people who are of like mind, based on religion. So there are gay Christians, and teachers, I am a teacher. There are gay Christians who are Christians first. And the way that they deal with whatever their sexuality feels like is expressed in a Christian manner. It's about religious freedom, it's about religious association. It's not about finding out if someone's gay and cutting them out. It's about working out whether do you belong to this, are you like-minded with us? If you are like-minded, joined with us, then there shouldn't be an issue.
Okay, that wasn't my question, but I know I'm out of time, so can I just ask on notice that you come back with exactly what your position is, because it's a bit murky,
Would you
frankly.
mind restating your question clearly, just one more time?
So the question is, Do you want to be able to discriminate based on sexual orientation or preference in the hiring of your staff?
That's a corollary to preferencing based on religious belief.
No, no.
We're not targeting anybody.
The question is, do you want to do that? So that maybe you can come back on notice having thought.
Well, unless we
thought through
understand the
exactly.
question, we can't come back
Well,
to you.
the question is, I can repeat the question if you like. It's a pretty simple question.
My clarifying question, Chair, might assist.
Yeah, no, I know you're very anxious, and I'm about to come to you, Senator Pratt.
So that's the question on notice. Is that something that you can do? Yep, thanks.
Before I go to Senator Pratt, just by way of clarification, really what's being discussed is not the question as to how difficult it is for religious schools to police the personal lives of their staff. Isn't the question as to whether the bill would give those schools the freedom to express a preference for staff who affirm and hopefully live out the ethos of those schools? Is that how you would distinguish it?
Positive discrimination, the same kind of positive discrimination that political parties and other kind of cultural groups employ.
All right, on that note, I will now give the call to Senator Pratt.
Thank you. By way of clarifying question to this discussion, you've acknowledged that some schools hire staff who are not of the religion of the school. Is that correct?
You have to say yes or no.
Yes.
Okay. Is it also correct that for those teachers that are not part of the specific faith, that some schools will discriminate on the basis of attributes such as marital status, use of reproductive technology, abortion, or sexuality or gender, and how that person, at an individual identity level, if not in terms of if not in terms of any expression within the school more directly.
I missed that. Did you?
Yes. So, as I understand it, Presbyterian schools would be consistent that if they're employing people from a range of religious views, then they're simply expecting the staff to support the ethos of the school. Where there are schools that have a more restrictive employment practice, that would be explicit in the hiring process, that there's a statement of faith that's required for the person to sign. They'll be asked some questions about it. They'll be asked whether they live consistently with the ethical principles that are in there.
Okay, so let's just unpack that. That's where the heart of it is. This is someone who is not of the faith, and do you live consistently with those ethical principles? Will that cut across things that are currently contained, for example, in the exemptions in the Sex Discrimination Act?
Yes.
Thank you. Thank you, Chair.
Thank you very much, Senator Pratt. Senator O'Neill.
Thank you very much. Thank you for being here today to give your evidence in person. It's such an important thing. I appreciate you making the effort to come, especially in these COVID times. And I'm very concerned at how truncated this set of hearings is, because I know there was a promise in 2018 and then 2019 and 2020 that this would be sorted, and it feels very inappropriate to be dealing with such complex matters in such a collapsed period of time, but that's where we are. So thank you for your submissions, which are careful. Can I go in particular to your submission with regard to pages 3 and 4, where you state the Presbyterian Church remains concerned that seeking to protect religious freedom by codification may prove to be counterproductive. We urge the government to allow maximum freedom with minimal regulation.
Senator O'Neill, you are reading from the amended submission, is that right?
No, she's reading from the
PCA.
From the
I'm sorry,
national.
apologise.
Yeah.
Apologise.
Do you still hold by that?
Look, that's a sort of in principle statement.
Okay.
The paragraph before that, I think, recognises that in fact the way in which Australian legislation generally has dealt with human rights is through anti-discrimination legislation, And so we've headed down that track.
So we've got a historical precedent, and here we are.
We're not really arguing that we can.
Yep. Go back and start again.
Exactly.
Right. So
Yep.
given the framework that exists, the natural next step, which has been a long time coming, is to create a piece of religious discrimination legislation, which seems to be generally agreed as a required component of Australian law to meet our international obligations.
That's right.
Can I take you now to the detail of... I want to mind the gap between what might be promised by the government and then what can actually be delivered, which has been somewhat contested in this space. A number of ideas about what Clause 11 and Clause 12 should look like, questions about the constitutionality under Section 109, particularly from Professor Toomey. And I just wonder if you have had the opportunity to look at the Appendix B from Professor Aroney, which most witnesses I've asked this question of indicate does respond to the concerns raised by Professor Toomey and still do, I think, what the government has attempted to do with Sections 11 and 12. Do you have a view about that particular part of the legislation?
Well, our view would be that we would support Professor Aroney. He's known to us, and he's actually a friend. But that's not the reason. He's a very astute constitutional lawyer.
He's just nice too.
And you know, look, what we want in the end is a bill that's actually supported by the whole of the Parliament, not just one party in the Parliament, and we want it to actually last, and then eventually amended as other improvements can be made.
Yeah.
And so, if Professor Aroney is suggesting a pathway through this muddied area, then we would support it, yes.
Thank you very much for that, and thank you for the opportunity, I think, in light of your comments there, to indicate that Mr Morrison did indeed make a promise to the Australian people that he will proceed with this bill on a bipartisan basis. I think we need to let the record show that this bill was not seen by Labor, neither were previous drafts in any of their iterations until it actually landed on the floor of the Parliament. So perhaps going forward, a bipartisan approach to deliver something more unified, a multi-partisan approach to deliver something more unifying might actually go some way to address the concerns that were raised in the Catholic Bishop's submission.
Senator O'Neill, do you have a final question?
I do. 1 in 20 Australian children experience discrimination on the basis of their religion, which was higher than the rates of discrimination based on disability, mental health or sexual identity. And the data about anti-Semitism with multiple attacks, and 72% of attacks on Islamic people going to Islamic women. I'm sure you're concerned about all communities of faith. So what is your hope in terms of this committee? Do you expect it to bring forward a unanimous report? If it fails to do that, what do you think the cost of that would be to people of faith that you're particularly here to represent, given that we already discussed the range of perspectives that exist within just one denomination of the Christian churches?
Well, we would hope that in Australian society, in a pluralistic society, that we can actually hold different beliefs, but we can get along. And that would be our view. I mean, yes, as a conservative evangelical church, we hold to conservative values, and we hold to orthodox biblical values concerning things that affect sexuality. But that's not the only thing that we hold to. We believe in stuff today that a lot of Australians would find strange. We believe that Jesus is God. We believe that he died on the cross, he rose again from the dead, and he's coming back again.
And the manifestation of that faith is perhaps best known to Australians through the service that's now called the Royal Flying Doctor Service, which was established by John Flynn.
The Presbyterian Church.
And the Presbyterian Church.
John Flynn, who was Presbyterian.
And that didn't happen just because he thought it was a good idea. That came as a manifestation of his faith that continues to this day. So that intersectionality of religion and good civic action has a long history in this country.
So I guess to answer the question about what are we hoping from the committee,
yep.
This will probably it's probably politically naive, but I would hope that the committee would, whatever the views of the members on the details and on how this will work in terms of the override of the states and what's the best formulation there, would support the general principle that there should be a religious discrimination bill, and would recognise the importance of religious organisations being able to continue to follow their mission and express their ethos consistently.
Yep.
All right, thank you. Thank you.
If you wanted to add to that, I'd be happy to take some more on notice. Thanks.
Thank you so much, Senator O'Neill. Did you want to add to that,
Just
Mrs.
a quick
Deming?
one. I think what we'll get out of this committee is we'll find out who is serious, which parties are serious about defending multiculturalism in Australia, which parties are serious about religious freedom. You all have it in your charters, I noticed today, that you care about it. And so that's what I think we'll find out, and whether, you know, parties here are going to lead our nation towards handling our deep philosophical differences well, or weaponising the taking of offence where none was intended. That's what I think we'll get out of it.
Where people of faith become a casualty.
Well, everyone will be a casualty if we're just fighting all the time and we can't agree to disagree.
Thank you very much.
Thank you. Thank you very much, Senator O'Neill. Senator Rice, who's very kindly promised to be a couple of minutes only.
Do you have schools in Tasmania?
No.
No.
Okay. I did my Google search and I thought there was one that was a Presbyterian school in Tasmania.
There may be a school which has the name, but I think it probably is. It's probably in the Uniting Church now. Anyway, no, as far as I'm aware, we don't have any schools in Tasmania.
Okay, so you don't have to deal with okay.
So,
I mean, if you had schools in Tasmania that had to, I mean, there are religious schools in Tasmania that all seem to operate quite well and maintain their ethos without being able to discriminate on the basis of gender and sexuality. But it's a moot point in terms of the Presbyterians.
Yep.
On the issue of a bill that could have multi-partisan support, we're all on the record of saying we know that this is a gap in our federal legislation. Would you support a more limited bill that protected, you know, religion as a protected attribute so that people of faith were not able to be discriminated against? A bill that genuinely is a shield, not a sword, if that had, you know, chances of getting through with multi-partisan support, rather than a bill like this one, which has got the Law Council, the Australian Human Rights Commission, the ACTU, the Australian Industry Group, multiple minority faiths, multiple denominations of Christianity, who all are pointing out the huge problems with this bill.
So I think if the bill doesn't give some protection to expression, both spoken and acted expression of religion, then it's not really protecting religious freedom.
But if it protected it on equal footing with other protected attributes, because that's the issue that people have with this bill, is that it privileges religion over other protected attributes, such as the statements of belief that allow discrimination against people of minority faiths.
Could you give us an example of such a statement?
Well, the Hindus and the Buddhists, I encourage you to listen to their submission.
Is that about the hospitals or the...
There was discrimination in employment, but there was also
I meant
being discriminated against by having people coming up to them in the street regularly to tell them that they are sinful, that they're going to go to hell, and basically that the people of religion who are making those statements are essentially saying that their religion trumps the other one.
Every religion says that their religion trumps the other one.
Well, but they don't have to express
atheists
it.
say that they're...
No.
So you want them to be silent.
Senator
The point
Senator
that Dr.
Rice,
Tan from the Anglican
Senator
Church
Rice,
said...
can I just ask you to pause? I would like, Mrs. Deeming, to have the opportunity to finish your answer.
What I was going to say is that every religion thinks that their religion trumps the other religion. Atheists think that their atheism trumps religious views. That's fine.
And could I ask you then, so you support the ability of religions to actually actively then discriminate against and belittle, offend
No.
people of other faiths?
No, of course not.
So,
I mean,
you may believe that, but it's
Sorry,
the discrimination
Senator
is
Rice,
actually stating
I am going to have to ask you to give
depends
the
what you
witnesses
class
the
as
opportunity to
discrimination.
answer the question.
Well, the Australian Human Rights Commission have multiple examples in their evidence of statements of belief that amount to discrimination.
So if you think people trying to form an association with other like-minded people, and therefore, you know, the result of that being that some people are excluded, and you would say that's discrimination. If you think that's not acceptable, then I don't see how you have any respect for religious freedom at all.
That's not what we're talking about. We're talking about particularly clauses 11 and 12 of this bill, and
Senator
particularly
Rice.
the statements of belief that the Australian Human Rights Commission say that statements of belief that will be legal under this legislation, that will override state and territory legislation, are currently considered discrimination, and they will no longer be considered
So
discrimination.
multi-partisan support. Let's get a controversial statement. Trans women are men. Would you consider that in and of itself a discriminatory statement that should never be uttered?
If that is being stated in a workplace to a trans woman, absolutely.
Sorry, I'm just going to remind everyone that the Senator's role here is to ask questions and the witnesses
Do you believe that's not
to answer.
I just think it's a statement of belief, and I don't think it's necessarily a religious
And if it's offensive
belief.
to that trans woman,
I
you think
think
that's
it's-
acceptable?
and it's offensive-
Deeply offensive and potentially
Senator
causing
Rice,
that trans
Senator
woman
Rice,
to have severe mental
Senator
illness
Rice,
to be not being accepted in their
Senator
gender
Rice,
identity.
Senator Rice, excuse me. I'm just going to ask you to pause
Well, in
here.
the same workplace, someone might have
Senator
the right
Pratt,
to call the person
Senator
that
Pratt,
said that a bigot.
I'm just
So
going to
this
ask you to
is
pause as well. Senator Rice has put a question to Mrs. Deeming. Mrs. Deeming, if you could please answer the question. I don't want any witness being interrupted, please.
I pose that question because it's obviously the most controversial one at the moment. It's not specifically a religious view that biological sex cannot be altered. It's not. There are many, many people, lesbians in fact, and homosexual men, and people from across the political spectrum, people in every single party here, that would agree with the statement that trans women are by definition male. They wouldn't be making it on the basis of hate. So what I'm interested in finding out is whether you're going to try and make statements like that, you class them as inherently harmful, whereas no offence was intended. It's just a difference of belief. It's a belief that we don't subscribe to.
A difference of belief
Yes.
that in that sort of
Last
instance,
question,
if
Senator
that
Rice.
is in a workplace or if it is a statement that's been given to a young person who is attempting to affirm their gender, leads to severe mental unwellness, the impact on them
Senator
of
Rice,
not being able to affirm their gender leads to suicide ideation, leads to potential suicide. That is the reality for trans and gender diverse people. So I put it to you that is in and of itself a discriminatory and a hateful statement if it is being made to those people.
And I put it to you that it is psychologically abusive to coerce students and other people to say things that they do not believe, especially about the nature of biology.
All right, we're going to. Thank you, Senator Rice. I'm now going to share the call. I know Senator Van has already indicated he's got one clarifying question. Then I'll come to you. And then I'll come to you, Senator O'Neill. And I think Senator Pratt has got a very quick follow-up. Senator Van.
Yeah, just to Reverend Duke. Are statements such as Buddhists are going to go to hell or Jews killed Jesus, are they tenets of the Presbyterian Church?
Look, as a minister, I don't know anybody that's making those statements, and I'd be sorry to hear if anybody was. But I would make this statement before this group, and I make this with a bit of fear and trepidation, that unless you have faith in Christ, you're going to hell. That is the gospel, and that is the traditional Christian view. This is what we preach in our pulpits on Sundays. Now, am I out there on the street saying that in a vile way? No. But if somebody comes and asks me about what the Christian faith is about, well, we get to all these sorts of issues. We're not out there making these open-ended, malicious statements.
All right, thank you very much, Senator Van. Just one quick clarifying question from Senator Pratt. No, you've got no more questions, thank you. Senator O'Neill, you've got a question you want to put on notice?
Thank you. I think it's very important to get on the record. Mrs. Deeming, you indicated awareness of pledges, statements of agreement with principles, values, etc. of, I think, the Greens Party and the Labor Party.
And the Liberal Party.
You didn't state the Liberal Party one. Do you have that at hand?
No, theirs was a bit more vague.
Okay. But as a member of the Liberal Party, can you research that and put it on the record for us?
Yeah.
Thank you. Thank you.
Thank you very much, Senator O'Neill, and thank you to all witnesses for appearing today. We really appreciate your time and your commitment to our inquiry.
Thank you for hearing us.
Thank you so much. I would now like to welcome representatives of the Uniting Church in Australia Assembly. Thank you very much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 44. Please let me know if you wish to make any corrections to your submission. But for the Hansard record, would you please each state your full name and the capacity in which you appear today?
Sharon Hollis, President of the Uniting Church in Australia Assembly. Claire Wynne Little, National Director, Uniting Care Australia.
Welcome to you both. Now, would you like to make a brief opening statement of no longer than 1 minute, please?
Thank you, Senator, and thank you to the committee for having us today. The Uniting Church in Australia Assembly does not support the Religious Discrimination Bill 2021 in its current form. The Uniting Church in Australia commends efforts to strengthen legislative protections to prevent discrimination against people on the basis of their religious belief at federal level. We have long believed that this is best done through the development of a comprehensive Human Rights Act. We believe that there are certain provisions in this bill that actually increase the likelihood of discrimination against people of minority faiths and also more vulnerable people within society, such as the LGBTIQ community, people living with disabilities and women. We believe it does this by privileging powerful religious voices at the expense of minority and vulnerable voices in society, which seems to be the exact opposite of its purpose, and providing what we see as extraordinary and excessive religious exemptions.
Thank you very much, Ms Hollis. Right on 1 minute, you did very well. I'm going to start by giving the call to Senator Rice, if you're ready, or we could come back to you.
Come back to me.
All right. Senator Ciccone.
I'm also happy to take the call, should you wish.
Senator Pratt, would you like to?
If Lou wants
All right,
to.
Senator Pratt, we'll go to you first.
Thank you very much. In the context of this legislation, what's most concerning and do you think should be amended, and why, particularly in the context of changing church doctrine and its adaptation, and how that may or may not cause harm to women, people of other faiths or minority groups?
Thank you, Senator Pratt. I think, first of all, as I said, we personally don't believe this is correct, the best way to pursue that claim. And so everything we say is prefaced, first of all, on rejecting the legislation. There are a couple of things. We believe that Section 12, the Statement of Belief, is too broad and that it has too narrow a bar. And so even though it does, at one level, rule out the highest level of offending people, there's a lower level of offence or hurt that could be given to people if you claim you're making a statement of belief. We further think that there's a dilemma in a person simply holding that to be their own held position of religious faith, that there's no way to test whether that statement of belief is in fact held by the wider religious community to which they belong. That makes it dangerous and therefore hard to tell whether what they're making is a statement of belief or simply a statement of dislike of people that is harmful. We also believe that the range of organisation covered by the religious exemptions under the bill, as included in the definition of a religious body, Section 5, and then subsequently in Sections 7, 8 and 9, should be narrowed and replaced with the phrase "a body established for a religious purpose." So we think the provision to include a range of things as being having religious exemptions too broad.
Okay, so in that context, if you were to take, for example, something like the Convention on the Elimination of Discrimination Against Women in terms of violence, etc., that convention has existed at times in terms of a need to mitigate against pervasive religious views that condoned such violence, or how do you see that playing out in the context of a right to make such statements when a statement that's backed by religious belief is privileged above other statements in these laws?
It's our view that that religious freedom has to be put alongside all other rights, so it should be of equal status, and it needs to be in the space where there's in a sense, the contestation of rights, so the rights of women, and over and against the rights of people of religion. And obviously, given that we're represented here today by two women, I holding one of the key senior leadership positions in our Assembly, and Ms Little holding a key leadership position in our service delivery arm, would not find that contestation of ideas difficult in the current moment. But I think we do have to accept that it is possible that someone could claim the position you're claiming and say that's a statement of belief, and we think that that's dangerous. And that's why we think that that statement of belief clause is too broad and too undefined in terms of what's allowed and how it relates to other rights in the legislation.
Can you give some insight into how the Uniting Church has evolved its own beliefs in these contested ideas? In effect, where because in this case, someone's individual right within a religion to express their version of that religious belief is not consistent with the overall doctrine, which gives the overall institution an opportunity to negate someone's individual religious belief and their right. What's the Uniting Church's take on that in the context of religious freedom?
So I think we function almost at two levels in this. So I'd invite Ms Little to say a little about this in terms of employment in a moment. So within the Uniting Church itself, we have vigorous debate about a range of these issues and how that should play out within the practices of the Uniting Church. So back to the 1930s, we've had debate about, for example, should women be ordained or not? And that's a kind of internal to the religious organisation debate. Should women be ordained, for example? Should they be allowed to be elders? Should they be allowed to be the treasurer or be on church council or exercise governance within a local congregation? And people have been able to be members of the Uniting Church and not necessarily fully adhere to the breadth of the stated doctrinal position, but they cannot interfere with people within the Uniting Church living out that stated doctrinal position. So you cannot in the Uniting Church, for example, say, I don't want that woman to be my minister because they're a woman. That's just not an accepted position. In terms of the rights of, for example, LGBTIQ people, that's a much newer journey for us. We accept LGBTIQ people fully as members and able to fully participate in the life of the Uniting Church, including being ordained and exercising leadership in the church, although individual congregations have the right to say they wouldn't have an LGBTI person as a member. However, we don't seek those exemptions in employment, and it might be helpful if Ms Little says a little about how that works, particularly in our community service organisations.
So, Senator Pratt, we are going to need to wrap up, so could you ask just a final
Fine,
question?
Thank you, Chair. Once the witnesses have answered this question, I'm fine. Thank you, Chair.
Thank you.
Thank you, Chair. Yes, in our community service activities, Uniting Church has a very large footprint of community services across the nation. We're one of the largest networks. We employ 50,000 staff and 30,000 volunteers across our network. So that's an awful lot of people. But in our community service activities, we have a really strong belief in the inherent dignity and worth of every individual that comes to us for a service. and that they deserve the best possible quality service that we can provide. And so therefore in our employment practices, we don't discriminate around people who are of a Christian faith or are a member of the Uniting Church, or in fact we have an extremely diverse workforce, and we are really inclusive in the way that we do that, because we have this belief that we need to provide the best quality service. It's not about what you believe as a worker, it's about how you can do your job the best possible way. So our employment practice.
Do you think that if governments were to say to you, we're going to, what role does government have in setting that standard, as opposed to you as a church setting that standard for yourself as an organisation?
We've set those standards for ourselves. Certainly we are contracted by government to provide a lot of funded programs and services across the country, but many of those services are not funded by government, but they are still absolutely part of the ethos and beliefs of the Uniting Church in our community service activities. So we say that people in employment should adhere to the ethos of the Uniting Church, and certainly the values of our church, which is about the respect and dignity of every human person and the importance of social justice.
Have you seen examples of harm when a particularly doctrinal view comes across in the delivery of services in other organisations?
Absolutely. I think one of the really concerning things for us in this legislation is that people who are highly vulnerable in their lives, who come to us for help, will find it difficult to knock on the door because we are a faith-based organisation. I think this bill, if it was passed, means that people will find it difficult to come to a church, even though we don't hold those views, that because we are a church, that they will feel reticent to come because they may be discriminated against. So, I mean, I think that is a real worry for us. That's a big risk for this, is that it will be something that people find as a barrier to get.
Right, Senator Pratt, I'm sorry, I am very conscious of time. So,
kind of discrimination happening.
Senator Pratt,
Thank you.
I'm just saying I'm very conscious of time. So could I ask you to put any other questions you have on notice? We've still got a number of other witnesses waiting and we are running over time. Look, I've just got one very brief question that I'll hand over to Senator Rice. In your submission, you claim the bill is an improvement on previous versions in some areas. In other areas, the bill has become worse. A number of significant amendments have been made, including a sincerity test and removing the conscientious objection clause for health practitioners. Can you just elaborate on your position and why you believe the bill has become worse?
Thank you. Our main concern, it goes to section 12, the statement of belief. We believe that's overreach, and I think we've already explained why we think that's overreach.
So you don't see those changes as being improvements to the bill that I've just nominated?
Oh, those things we do, but you asked us what we thought was worse, and I've just told you what we think is worse.
And you do recognise section 12, subsection 2, that a statement of belief does not apply to a statement which is malicious or which would have the effect of threatening, intimidating, harassing or vilifying a person or group?
We do recognise that. However, it could still leave people without protection in terms of it being hurtful and so on.
So you want a religious freedom bill which stops people being hurt? So just to clarify, are you seeking a religious freedom bill which prevents people from being hurt? And can I put to you, if that's your position, that's a very, very high bar, isn't it?
No, I'm saying that we think, although section 12 says you can't threaten, intimidate, harass or vilify a person, it leaves people without protection from a significant range of conduct that can be demeaning, humiliating, insulting or ridiculing. And we don't believe a religious discrimination bill should make it possible for speech or practice about religion to do those things to another group.
Ms Little, do you have anything to add to that answer?
No, I think Sharon's made it quite clear.
Thank you. I'll now go to Senator Rice. Thank you.
Thanks, Chair. Just to recap, so you're one of Australia's largest churches and you don't support the bill. That's correct, isn't it?
Yes, yes.
Yeah. I want to go to your concerns about Section 12 and the override of state legislation, the ability, as you just said, to allow statements that are offensive, insulting. We just heard some, what I felt to be pretty disturbing evidence from the Presbyterian, from one member of the Presbyterian Church who felt that on the basis of religious belief that it should be quite acceptable to say to a trans woman that she was a man. Would you see that as being a discriminatory statement that was, you know, in the realms of something that Section 12 would allow that you think it shouldn't allow?
Yes. Yes.
So doesn't it depend on the doctrines of the particular religious organisation, though?
Well, I guess this is the issue here that we have, because this is not framed within a bigger piece that's around recognising the range of protections people have. It's privileging, in a sense, a particular expression of doctrine, and saying that to express the view that Senator Rice just said was expressed, which I personally found hurtful and offensive. I mean, why should that be privileged over the right of a trans woman to have their pronouns honoured, to feel like they are a whole human being, and to be accepted, for example, in a workplace?
What's the ramifications of a statement like that if it was done in one of your services by one of your staff to a vulnerable client?
In one of our services to a vulnerable client, it would be disciplinary action.
Thank you.
Because it is highly offensive, and we provide many services to people who express their sexuality in all sorts of ways, and we would not find that acceptable at all.
I'm glad it's the Uniting Church that are running those services and not the Presbyterians. The Uniting Church, of course, runs a lot of schools.
Yes.
And so it's very possible to run Christian schools without needing to discriminate against LGBTIQA plus teachers and students.
Yes.
Thank you. I'll just leave it at that. Thank you.
So just to clarify in relation to the last statement that you made, so it is appropriate for a religious organisation such as yourself to discipline staff who don't act in accordance with your beliefs?
It is absolutely appropriate for staff to be disciplined if they are expressing disrespect and not behaving in a way that's professional in the way that they deliver that service. So we would see that if you were to express a personal belief about someone's sexuality in the course of doing your work, that is unprofessional, and that would be subject to discipline.
So do you respect the right of other religious organisations who may have a different set of beliefs to discipline their staff or to act in accordance with their beliefs in the same way that you wish to as well?
Well, this is, for us in our community service activities, it is about professional conduct. And, you know, if a person is providing, say, they're running a youth program for gay and lesbian young people, and a member of staff did their interview, said they would keep in with the ethos of the service, which is about respect and professionalism and non-judgmental ways in which they do their work. If they went then about doing their work in that way, any organisation would find that offensive.
So I understand, that wasn't quite my question. My question was, do you respect the fact that other religious organisations who may have different beliefs have the same right to discipline their staff or to enforce their beliefs and doctrine consistent with their beliefs and doctrine?
I think that any religious organisation or faith-based organisation that provides services to the community and does that in a way that then is harmful to that individual they're providing that service to is not okay. So I would not condone or expect a religious organisation that says that it believes in the Christian gospel to be harmful in the way that they are treating or speaking to people in their service delivery. No.
Thank you so much. That concludes our questions, and I would like to thank you very much for your attendance today and for your evidence and for your, very substantial work in supporting the work of this committee. Thank you so much.
Thank you.
Acknowledging that we are running around about half an hour behind time, and our apologies for that, I now would like to welcome representatives of the Seventh-day Adventist Church. Thank you for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 123. Unless you wish to make any corrections to your submission, for the Hansard record, could you please state your full name and the capacity in which you appear today?
Good afternoon. My name is Michael Worker and I represent the National Office of the Seventh-day Adventist Church, where I'm the General Secretary and Director for Public Affairs and Religious Liberty.
Pastor Worker, thank you so much for your attendance today. Would you like to make a brief 1-minute opening statement?
Sure, thank you. The Seventh-day Adventist Church desires to see that Australia continues to be a diverse and tolerant pluralistic society where fundamental human rights are appropriately balanced. We support the recommendations of the Religious Freedom Review expert panel to enact the Religious Discrimination Act and support the government's commitment to incorporate ICCPR Article 18 into the Australian legal framework. It is noted that the UN Human Rights Committee has observed that not every differentiation of treatment will constitute discrimination if the criteria for such differentiation are reasonable and objective, if the aim is to achieve a purpose which is legitimate under the Covenant. The various ministries of the Seventh-day Adventist Church operate in such a way where it is reasonable for them to expect that the staff will uphold the belief, values and ethos of the Seventh-day Adventist Church in the delivery of that service. And as a result, we desire to have the ability to prefer the employment of members of our faith community who believe and practice the teachings of the Church.
Pastor,
the same
thank
right
you.
is afforded to many organisations. Sure.
Apologies.
Therefore, we support the passage of the bill.
Thank you, Pastor. I'm sorry, we are trying to run a tight ship today.
Understood.
I know it's very challenging to get everything out in 1 minute, but you are able to obviously continue in the form of questions from senators. And on that note, I give the call to Senator Ciccone.
Thanks, Chair, and I'll also be quick and mindful of time. Look, I know the Seventh-day Adventist Church operates schools in Australia, and you expressed some support, as you just did before, about section, I think, 11 of the bill. Are there better ways for the federal parliament to ensure that religious schools can continue to preference in employment in good faith on the basis of religious belief or activity? So Christian schools being able to preference people who share those values, for example. Be just interested to see whether you could elaborate a bit further from your opening statement and also the submission that you've provided to this committee on that point.
Yeah, I think the key points that we wish to share are covered in the submission. In Australia we do have appropriate anti-discrimination legislation in place to cover against age, race, sex, disability, and it's an appropriate thing to have a framework in place to protect on the basis of religion and allow those preferences to take place, so that we see education as holistic. It's the delivery of curriculum, but it's also about providing a values-based framework for children to be raised in that helps them to be positive and well-contributing citizens of our society.
I think on page 2 of your submission, you state we don't have or wish to have the right to force values on other people. Choice and conscience are part of our values. However, we do expect the right to model and advocate these values in all aspects of our organisation as we work together for a harmonious, tolerant and peace-loving multicultural society in Australia. How are you currently prevented from modelling and advocating your values?
I think generally speaking, we have a reasonable amount of freedom to do to undertake our activities within our belief framework. However, we are seeing legislation that introduced that does seek to limit that and impact our ability to recruit and to retain in employment. For example, the recent changes to the Victorian Equal Opportunity Act does seek to limit our ability to preference staff who do uphold our beliefs and lifestyle practices.
And I take it then you'd obviously support the bill in the hope that it sort of overrides some of those aspects of the Victorian legislation?
And the documentation around the bill, I think, does do that appropriately, yes.
Yeah, all right. Thank you, Chair. That's all I've got for unless my other colleagues.
You have a couple of questions, Senator O'Neill?
Yes,
over to you.
So, Pastor Worker, can I just first confirm, thank you for appearing again. Double trouble with the two inquiries running. Could I just clarify that based on what happened last week and any further views, have you changed your view on any of the detail of the bill since you submitted or since last week?
We support the principles of the bill that have been submitted and happy to have any discussions about clarification that you want on
great.
aspects of it.
Because I think there's been general agreement across all submitters and witnesses that to fulfil Australia's obligations under the international human rights obligations to which we're signatory, that it is past time, way past time, to bring in a religious discrimination bill to fit into that suite of historical anti-discrimination bills that we currently have. So that's agreed. As a person of faith myself, and having grown up in the context of, a Catholic family and the Irish tradition, and then, mercy nuns and then Good Samaritan sisters, there are flavours to the way in which that ethos and the belief structures of those and variations are embedded in the schools. My concern now is into that reality that we have a piece of legislation that's basic in some ways, that meets our international obligations, but there are other parts of it that are quite complex. And we've had a lot of discussion about Clause 11 and Clause 12. Today we had evidence from Professor Aroney, and it's been supported by quite a number of the Christian school and non-Christian school representatives. And Professor Aroney has offered drafting of clauses 11 and 12 that's a little different from what is on offer from the government at this point of time. Most of the witnesses, I hope I'm not verbally anybody, indicate that they believe that addresses concerns about constitutionality that were raised in the Toomey submission to the PJCHR. So do you have a view about the constitutionality? And do you have a view about Professor Aroney's particular amendments in Amendment B of his submission, Appendix B of his submission?
Yeah, thank you, Senator. Good question. And I've had a chance to have a look at what has been brought to our attention by Professor Aroney, and I would see no reason not to support those amendments. They seem to be sensible and reasonable in helping to come up with a bill that can work for the majority of people.
Okay. So given that, is it fair for me to assume then that while you support the bill in principle, you do believe that there would be improvement if it was subject to amendment?
And I guess that would depend where the amendments were and what the recommendations were. Certainly the limited opportunity I've had to look at Professor Aroney's drafting today, on the face of it, it seems as though something we'd be happy to support as an enhancement and a refinement of the bill that's been put forward.
Okay. So can I give you the opportunity on notice to add any further comments that you might wish to do so with regard to that?
Sure.
I noted with the previous witnesses, I think most recently the Anglican Church, that the Presbyterian Church, that there was a commitment by the Prime Minister to bipartisanship in the development of this legislation. Well, that certainly didn't happen the first time that this legislation was seen was when it landed on the floor of the Parliament, this particular iteration of it. What is your hope for the work of this committee and the report of this committee in terms of next steps as we come to, back to Parliament in a couple of weeks? Given that there's a very short reporting line here for this committee, what are your hopes for the work of this committee, Pastor Worker, and do you see any problems if there is dissent in this committee?
I think every committee is going to have a range of views. But as we have mentioned in our submission, we would like to see bipartisan support for the bill. I think it's a fair bill, a reasonable bill, and we would like to see a recommendation for it to go forward essentially as is. Some drafting refinements such as put forward by Professor Aroney will, I think, only strengthen what has already been published.
Thank you. There have been some assertions, a considerable number of assertions, that the bill as it's proposed, even with the amendments by Professor Aroney, would lead to a diminution of other rights that are protected attributes. That is a contested position. What's your view? Is this bill setting up religious discrimination through the Religious Discrimination Bill an ascendancy of the right to hold a religious view over other views, or is it simply claiming a place amongst others to which, the general contest must apply?
I would take the latter view. I think it's an appropriate balancing of the various competing human rights, and legislation and addressing matters through the courts, I guess, is a remedy of last resort. We really want to have a tolerant and plural society where we can all get along together, where we can respect that people have different views, different values, but we can all work side by side and allow everyone to coexist together. And I think, generally speaking, we all aspire to that as Australians.
Thank you.
Have you just got a final question,
I
Senator
have,
O'Neill?
thank you. This morning I commenced my questions by referring to a statement of St Thomas Aquinas. Some people wouldn't call him a saint, I suppose, they'd just call him a scholar, but in the Catholic tradition I'll put the saint in front of it today. He writes that to one who has faith, no explanation is necessary. To one without faith, no explanation is possible. Given that assertion by St Thomas Aquinas, do you think this legislation will provide the necessary change in Australian law to sort of help bridge that space between people of faith and people of no faith by giving protections under this bill to both of those perspectives?
Certainly that would be my hope that occurs. As we operate schools and various other ministries, community service and all the rest of that, we don't discriminate in the delivery of the service, but how we go about delivering that service, we want those who are involved in that service delivery to align with our teachings. And I guess people who choose to enrol their students in our schools, those who have opportunity to engage in our other community service ministries, would expect that we would be genuine in the delivery of our faith, that we would deliver those services and provide that community benefit within the context of our worldview, of our values, where we seek to bring good to society.
And do you make that explicit in employment and also at enrolment?
Yes. We certainly do talk about the principles and the values and the teachings of the Seventh-day Adventist Church as we go through that process.
So outlining the religious body's position in relation to particular religious beliefs and how that would be enforced would not be a particular burden on your organisation because you already operate with that degree of transparency. Is that correct?
All of our schools are starting up for the year, and we hope we can have students back in class in a very short period of time. But I know all of our education leaders at the moment are going around from school to school and providing induction processes for all the new teachers and support staff that are coming on. And part of that process is, you know, an orientation and an understanding of what a Seventh-day Adventist worldview, how we live out our biblical values, and we do endeavour to make that very clear to everyone that we engage.
Thank you. Thank you, Chair.
Thank you very much, Senator O'Neill. Just a couple of quick ones from me, Pastor. Can you provide some examples of where members of your community have been discriminated against and hence the need for this legislation?
Yeah, thank you. Probably one of the most pressing concerns for us is around the observance of the Sabbath. We observe the sacred time from sunset Friday to sunset Saturday in a similar way to the Jewish faith. And there have been a number of times where we have had to engage with educational providers, employers and the like to advocate on behalf of our members who are feeling under duress to attend classes, to attend examinations, to work during the Sabbath hours where we don't undertake secular activity. And I know there was a case a couple of years ago where we had some students at a university who went through a 9-month appeal process to endeavour to articulate to their educational provider their convictions around observing the Sabbath and their inability to reasonably undertake an examination during the Sabbath hours. And that was very draining for these students. Ultimately, they were successful in their appeals through their sincerity, through their doggedness in that process. But we have a number of settings where that continues to bubble up as a pressure point for our members.
And does the bill resolve that particular challenge that you face and your community faces?
I think, you know, in responding to these matters, we often will refer to international law and ICCPR and other international instruments to raise our defence. To have something contained in Australian federal law will certainly make it easier to have more localised conversations and to point out the protection that is afforded for people of faith. So we think it will be a great advantage to our members.
All right, well, I will leave my questions there, and I want to thank you very much for your time today, for your evidence and for your participation in this inquiry.
Thank you.
Thank you so much. Our last witness today is the Australian Christian Churches. I would like to welcome representatives from Australian Christian Churches. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 5. Do you wish to make any corrections to your submission? And in your answer, could you also please, for the Hansard record, state your full name and the capacity in which you appear today?
My full name is Mark Llewellyn Edwards. I'm the senior pastor of City Hope Church in Australian Christian Churches.
I'm sorry, Pastor, could you just repeat that? We just got a bit of interference in the audio.
My full name is Mark Llewellyn Edwards. I'm the senior...
Pastor, what I might ask you to do, we're losing you, the frame is freezing. Could I ask you to turn off your video? We might just hear from you by way of audio only, and that might improve the connection. Now, we can see you, but we can't hear you. So if I could ask you to turn your video off and just leave your audio on, if that's possible. All right. I'll just ask you again, Pastor, can you hear us loud and clear?
Yes, I can.
Oh, that's much better.
Is that okay?
Yes, indeed. So just if you could describe your position, if you could just describe your position, please.
My name is Mark Llewellyn Edwards. I'm the senior pastor of City Hope Church in Ipswich, and I represent Australian Christian Churches.
Thank you so much. Look, I'm going to just kick off with a couple of questions.
Could I make
I apologize.
1 minute statement?
Yes, I apologise. I overlooked that. It's getting a bit late in the day. Please, please make your 1 minute opening statement.
Yeah, last cab off the rank, I understand.
Yes, sorry.
Chair and other members of the committee, I thank you for the opportunity to appear before you and answer questions. I've been the senior pastor of the same local church in Ipswich for over 30 years, and having given my life to this vocation, you would expect me to support religious freedom in this nation. Everyone has the right to freedom of thought, conscience and religion, and so I do support the bill. Australia has a progressive federal anti-discrimination framework to ensure that individuals are not discriminated against because of age, disability, race, sex, gender identity, sex characteristics and sexual orientation. So I would ask you as a committee to recommend the extension of this framework to religious beliefs or activities as outlined in this bill. I've outlined my reasons for this support of the bill in my submission to you. Thank you.
Pastor Edwards, thank you very much. As I mentioned, I kick off with a couple of questions and then I'll hand over to Senator Scarr. Why is this bill so important to your organisation, to Christian churches that you represent throughout the country?
Senator, it's really important for not only the Australian Christian churches, but me personally as a pastor of a local church, that I have the right to express my religious belief, which I can't separate from. I can't turn my religious belief off. I can't turn my faith off. I can't turn off those values that I live my life for and have given my life to. So for me, to have that expression in some form of legislation is really not just important, but absolutely vital to who I am as a person.
Thank you so much, Pastor Edwards. I'll now give the call to Senator Scarr.
Thank you, Chair. And Pastor Edwards, can I just thank you for joining us today and just thank you for all the great community work you've done in the greater Ipswich region during this time of the COVID pandemic and all the wonderful work you do, especially through your congregation in terms of supporting victims of domestic violence. It's quite inspirational.
Thank you.
Can I take you to your submission, this issue with respect to statement of belief that has taken a lot of time during our deliberations today? And I quote from your submission, "The bill will reduce the harassment and intimidation of people of religious faith who express in a moderate and reasonable way statements of belief long held by all the world's great religions." The obvious example of this is the well-known Tasmanian case of Bishop Porteous and the case brought against him in relation to the publication of a document which outlined the Catholic Church's traditional position on marriage, parenting, end quote. A concern's been raised by a number of stakeholders, a number of colleagues, that the statement of belief clause may provide additional avenues for people to make harmful comment in relation to others in the community. And this is certainly causing some concern amongst stakeholders and colleagues. I'm just interested in your view with respect to that concern and from your perspective, how do we achieve the right balance in this regard between making sure that someone such as yourself who's committed your life to the church has the ability to sincerely and faithfully and moderately express your statement of belief, whilst also making sure that those who don't have your personal attributes and your personal characteristics aren't in a position to cause harm to more vulnerable people in our community. How do we achieve that balance in your view?
Well, I was privy to the comments made by our Buddhist brothers probably about an hour and a half ago, where the comments that have been made to them are absolutely abhorrent, and particularly when they referred to the aspect, the Jewish for example, the Jewish example of someone saying at a cafe, you killed Jesus. I, for example, Senator Scarr, cannot understand anyone saying that.
Pastor Edwards, neither can I. I found it quite unbelievable, to be frank.
Unbelievable. And it goes against the very tenet of Christianity that says that we should love our neighbour as ourselves. So it just floors me. So I can't say to you that this legislation is going to stop those comments. We just can't do that. No legislation is going to stop someone making, and I don't know whether I can say it as bluntly as this, but such a stupid statement. But what this legislation does do, particularly in the area of statements of belief, I think it puts enough safeguards in there to ensure that reasonable statements of belief are protected under the Act. For example, it's got to be, it's conduct that is not discrimination. Statements of belief must not be harassing, threatening, intimidating, vilifying, determined by a reasonable person, must be in good faith and not be malicious, in accordance with the documents, tenets and beliefs and teachings. That's a high bar, Senator Scarr. And so what I'm saying is that as far as I'm concerned, that gives me the comfort to know that statements that I'm going to make, reasonably made, very reasonably made, are going to be held to account by that particular criteria. But I can't stop someone making a statement that is just totally disgraceful.
Yeah. And by the same token, from your perspective, it's important that you have the right to express your beliefs,
yes,
sincerely held, in a way that is moderate and reflects your long-standing and deeply felt religious faith. That's important to the expression of your identity as the person you are and the faith you hold. Isn't that correct?
Yes, Senator, because I can't separate my faith from anything I do. It's not just my words, but it's my actions as well. It's expressed through our church, as you well know, in the huge care program that we operate every day of the year. We don't ask people when they come to the church for help whether they are, what race they're from, what sexual orientation, whether they're. We don't ask any of those questions. We don't even ask whether they're in need. We simply say, look, you're welcome to help. But I want to be able to express my Christian views, not only in the sense of the role I play as a pastor, but as an individual as well.
Mm. And to some extent, as you were giving that answer, Pastor Edwards, and I was reflecting, and my colleague Senator O'Neill has referred to this repeatedly, a quote from Thomas Aquinas, and I don't know if you've heard that during the course of, I should say St Thomas Aquinas, if you've heard it during the course of this hearing, about the difficulty perhaps in terms of people who don't have faith appreciating what it means to people of faith and how important it is.
But can I say also, Senator, that remember that this particular bill it's not just a bill to protect the rights of people of faith exclusively. It's also someone who's an atheist or agnostic. They can make a claim if they've been discriminated against because, for example, they're not a Christian or they're not a Christian. So I think we need to just put on the record that the Religious Discrimination Bill in its current form is not just exclusively for people of faith. It does protect people who don't have faith.
And it also protects people who change their faith.
Change their faith, absolutely. Absolutely.
Yeah. Okay. All right. Well, thank you. Thank you very much, Pastor Edwards.
My pleasure.
And, thank you for everything you do. Thank you, Chair.
Thank you.
Thank you very much, Senator Scarr. Just on a clarifying question, Pastor, so you made a very good point that the bill allows statements which in fact might ridicule religion from someone, who is an atheist. And that view is also respected in the bill, isn't it?
That's right, absolutely. And I think that's worth making that comment on, is that it's not, even though it's the Religious Discrimination Bill, it does protect people who do not have any faith.
Mm. So you would support the bill even obviously where it gives rights to an atheist to say, well, Christianity is a load of rubbish, for instance.
Absolutely.
May I ask a clarifying question, Chair?
Yeah, sure. Yes, and then I'll hand
Thank
over
you.
to Senator O'Neill. Senator Pratt, just briefly, yes.
So I understand that the bill on the basis of being protecting atheists means, yes, an atheist can say that. But if a gay person ridicules a person of religion, not because they're an atheist, but because they are offended by that religious view, that gay person, if they did that in employment, could, and rightfully so, it's not a protected attribute. It's not protected in the same way a religious statement is. It's
That's
only
right.
protected in the purpose of it being an attribute. So religion is protected as an attribute, but a negative statement about religion that's not on the basis of atheism can be seen as discrimination under this bill. Why should not everyone be on an equal footing when it comes to issues of discrimination?
Because this is a religious discrimination bill. And remember, there are other discrimination legislation throughout Australia that
Oh,
may
no,
or may
I
not-
understand that.
Yeah.
I
Sorry,
understand that.
Senator Pratt, if I could just ask the pastor to be given the opportunity to complete his answer. Pastor,
Yes,
please.
thank you.
I'm sorry. No, I'm sorry. I was just going to say that some statements that are made, Senator Pratt, that are made, according to your example, by a gay person towards a Christian, some of those statements, if they were said to me, I'm not going to run off to make a discrimination complaint. I'm going to just wear them. I really am, because, I know that sounds so trite, but I've been around for a long period of time, and I've had my fair share of statements
I'm not
made
asking
against
about you.
me.
I'm
I know what
asking
you mean.
about that as a matter of
but
law.
I agree with the great basic premise that you're putting up. Yeah.
Yeah. So as a basis of law, does the bill treat all beliefs equally? It clearly doesn't, only if that belief is a religious belief.
I think I've answered your question to the best of my ability.
Thanks,
I
Senator
believe
Pratt.
you'll go to hell because you're gay. I believe you're a bigot because you believe gays will go to hell.
I'm sorry, I didn't catch that.
No, that's just as an example of the kinds of statements that
I just didn't catch the
Se-
question. you
Senator
asked,
Pratt,
sorry.
just to be very clear, do you have one final follow-up question, just to make your question clear?
Thank you. If you've got two staff in a workplace that say you've got one person that says, I believe only heterosexual people have a place in heaven, that people that are gay will go to hell. And you say, I believe you are a bigot because you say that I will go to hell. One is protected from discrimination on the basis of their religious belief statement, whereas the other statement is not.
And Senator Pratt, can I just say that I don't know if I'm answering your question, but I would never say that.
No. I'm asking it as a point of law for all people. I'm not asking you.
No, I know what you mean. And as a point of law, I agree with what you're getting at.
I'm not accusing you of ever saying that. I'm just trying to search for the point of law.
All right,
I do
thank you.
understand.
Thanks, Senator Pratt.
And I
I
certainly
appreciate
agree
that.
with where you're going with it.
All right, I'm now going to, very cognizant of time, we need to wrap up in a couple of minutes, so I'll give the final call to Senator O'Neill.
Thank you very much. And Pastor Edwards, I know that you've put on the record previously the extraordinary call on resources of your particular church in the Ipswich area with regard to great need during the COVID crisis. And this is perhaps one of the most important things that churches do during in their service of the community and democracy at large, is to provide services right across the entire community, regardless of faith or any other attribute. I note in your opening part of your submission that you represent more than 1,000 churches in the Pentecostal movement and 3,300 credential pastors and 400,000 constituents. Given your long experience as a pastor, and given the range of religious views and debate about religious tenets and beliefs across that Pentecostal movement, how can a religious discrimination bill sufficiently cover off the breadth of that range of views? Because you intimately know how different it is from one denomination to another and from one church to another that might, all profess to be followers of the Christian tradition.
Senator, the only way I can answer that is by saying this. I agree entirely with your proposition that, you think about over 1,000 churches, and I'm probably exaggerating slightly, but you would have so many viewpoints within those 1,000 churches. Then you've got 3,300 credential pastors. You're going to have so many different views just there. But what I want to say to you is this, is that we have waited for so long for some type of bill that gives some protection to statements of belief that I want to see this particular bill go through, because if this one is delayed or substantially amended or doesn't go through both houses of parliament, I don't know when it's going to go through. And I just simply can't solve the problem that you address, because there are going to be so many viewpoints right across. However, I can say that if you look at the definitions of statements of belief, I think you can work them out by saying that any of these statements by anyone within Australian Christian churches has to still be within the doctrines, tenets, beliefs or teachings of our faith. It's the only way I can answer it.
So I'm just thinking about the challenge of trying to have each of the faiths come to an expression of what they believe doctrinally. I mean, when Catholics go to Mass, we say things in the Nicene Creed. We believe in the Holy Spirit, the Lord, the giver of life, who proceeds from the Father and Son. This is something that many people would not accede to at all, yet we unify around these particular doctrinal truths for each of the traditions. Given the complexity of religious belief, that's just in the Christian tradition with Catholic statements of belief, which would be quite different from the way Pentecostal expressions of belief would exist. We've got a piece of legislation generally agreed in terms of, at principle level, as an appropriate vehicle to provide the high-level protection against discrimination that is required of us as signatories to international conventions. But we have one particular part of the bill, well, there's a few parts that there have been a number of suggestions about, but particularly exercising my mind is the parts that have given many people of faith considerable comfort, which is Clause 11 and Clause 12, but have been critiqued as not actually doing what they purport to be able to do. Certainly by Professor Toomey, who argues that they are unconstitutional, largely because of the way they've been drafted, given that state law is only rendered inoperative to the extent that it's inconsistent with the Commonwealth's law, and that the problem with this particular drafting of the bill as it stands is that the bill doesn't actually follow that path of creating inconsistency. To that end, we've had the offer of an amendment by Professor Aroney, who's provided drafting of clauses 11 and 12. Have you had a chance to look at either the submission of Professor Toomey or Professor Aroney?
When I heard the debate, some of the questions that were asked throughout the day, referring to Professor Nicholas Aroney's submission, I did have a quick look, and I haven't read the other submission that you refer to, but Australian Christian churches would, on the face of it, support that submission by Professor Aroney.
Okay. So while you, in your opening statement, indicated support for the bill, that support is for the overarching bill. You do not have any objection to amendments of the bill, of the kind that Professor Aroney has advanced, if it resolves questions about the constitutionality and gives more likelihood to be practicable. Is that correct?
That's true. Yeah, and that's right, Senator, because when I prepared my opening statement and was asked to send it, that was yesterday afternoon, prior to having any idea that Professor Nicholas Aroney had put up an amendment, which I read today, and I think it's appropriate.
Could I ask you to take on notice any further response to questions, the sort of questions you can imagine that I would like you to answer with regard to that. So if you want to have a look at both of those submissions and give us your formal view, perhaps you might call on the Brains Trust that's part of the Australian Christian Churches movement, and there are many people there with incredible skill, I'm sure, who would assist in advancing some drafting. Could I just go to the question finally, Chair, of bipartisanship? Mr Morrison indicated in 2018 and then again in 2019 and 2020 and 21 that this bill would advance, and he commenced his promise to the Australian people on this by saying he would advance in a bipartisan way. Clearly that has not been the case, with the first and second drafts landing without consultation with the Labor Party, the alternative party of government, and the third draft, which we are giving close consideration in this hearing, was not seen by Labor until it was in the Parliament. Is it too late for a bit of bipartisanship now, Mr Edwards? Or better question might be, how important is bipartisanship in the next stages of delivering this long-promised bill of discrimination protection for people of faith?
Last question, Dick.
Well, Senator, as you're aware, myself on behalf of Australian Christian Churches and many other faith groups, not just Christian groups, but faith groups, wrote to the Attorney-General on at least, I think, 2 occasions, I could be wrong, but at least one occasion, asking that there be multi-party support. And I still would hope that could exist as it goes through the Parliament. And very briefly, here's my reason why, because I think it sends a message to the Australian people that both houses of Parliament and all parties agree that this legislation is necessary.
Thank you, Pastor Edwards.
Thank you very much, Senator O'Neill. And Pastor Edwards, thank you so much for your time and for your evidence today and for your very valuable participation in this inquiry.
Thank you.
That now concludes today's proceedings. The committee has agreed that answers to questions taken on notice at today's hearing must be returned by close of business Thursday, the 27th of January 2022. I thank all witnesses again for their evidence today. I also thank Hansard Broadcasting and our very hard-working Secretariat. I declare the hearing adjourned, and we will of course be back tomorrow for a second day of hearings.